PUC adopted the reliability plan conceptually, determining that major transmission expansion was needed, but deferred decisions on voltage until a later date. In October of 2024, the PUC formally approved the Permian Basin Reliability Plan and directed further evaluation of the import paths and what voltage they should be. In January of 2025, ERCOT submitted a comparison of its 2024 RTP, which was at 345 kV, and the Texas 765 kV Strategic Transmission Expansion Plan, known as STEP. Then in January of through April of 2025, the PUC staff and ERCOT, manufacturers, landowners had a number of public workshops to get comments and rounds of evaluation around costs and other details. Ultimately, then in April of 2025, the PUC unanimously approved the 765 kV option for the Permian Reliability Plan. And where we sit right now is those CCNs have been filed. There are 3 import paths, and those are broken up into 5 distinct projects. There are also other underbuilds associated with this at 345 and lower voltages that go along with this. But obviously, the 765 lines are the ones getting the most attention. So as we spoke last time, what I committed to was when we get asked to do oral argument in these cases, I was going to grant it. We've had our first case before us and heard oral argument a few weeks ago. We have our second oral argument this Friday. We are holding those as separate open meetings where we take nothing else up, just so we can hear from folks who are willing to travel from wherever in Texas they are that this is affecting them, so that they can come to Austin, tell us their story, and we will sit and listen to them. That's where we are right now. A lot of this, when we talk about 5066 and what it did, the one thing I always want to make completely clear in that is it did shorten the timeline for CCNs from a year to 180 days. It did not require this build out to be at 765 kV. That was determined by the commission after a lot of analysis by ERCOT and others about what the most efficient and effective way to build out this transmission plan is going to be. So I just want to always make sure I get that out there on the record. And Vice Chair Hernandez, with that, I'm happy to answer any questions that I can.
Any questions?
No, go ahead. Well, thank you, Mr. Gleason. Is this the 2024 plan? It's a
yes.
workshop, June 28, 2024 was adopted in July.
I believe that's right.
And then it just kind of went on the shelf and we started again? Is that kind of
That's
what happened?
correct. So, Chairman Guerin.
So this is the plan that 5066 authorized.
So the RTP is the Regional Transmission Plan, something ERCOT does every year. And yes, after 5066, when we directed ERCOT to go look at a Permian plan specifically, as well as the bill requires a look at transmission planning around the state, what they came back with were options for us to consider at different voltage levels.
Because in looking at this, there wasn't much talk on 765s. It was mostly the lower voltage. But then all of a sudden, the 765s came around and were talked about, and that's what happened to it.
Correct. 765 was born out of the Permian Reliability Plan analysis. That's correct.
Thank you.
Mr. Raymond.
Thank you, Chairman. I just wanted to ask you while you're here, before you leave, because we're going to talk so much about 765 lines, and I think part of the concerns, people that are, either not for them or have concerns about them, are that they'll require, is it another 50 feet of right-of-way? Is that right? 200?
So, Representative Raymond, so yeah, if you look at a single 345, typically around 150 feet of right-of-way, 765 typically around 200. But what I will say is, and if you've seen the map of the Permian Reliability Plan build out at 765, when you see that same layout at 345, it requires 2 or 3 times as many lines.
That was going to be my question.
Yes, sir.
So that's first one. I started thinking about that when I saw the 345s, and because I think it's important for us to think about, all right, if you don't build a 765, but you're going to have to build more transmission in the state of Texas because we're going to grow. But let me ask you this. Do you believe that if we didn't build one more data center in the state, we would still need more transmission lines.
Yes, sir,
Yeah,
particularly in the
okay,
Permian.
yes, right? All over the state.
Yes, sir.
Okay. I think it's important for us to sort of think about that. So it takes 2 to 3 345s to get to what a 765 would get to, right?
Yes, sir.
So the amount of right-of-way that would mean is that, I assume in the end, a lot more right-of-way?
Yes, sir.
I think, members, I don't know if you read that or saw that, but it jumped out at me, and I'm like, you know, it's kind of one of the things we should think about, just in terms of the common sense part of it. I think some people who will testify will probably be concerned with the process of being notified and having a say in how these lines go, where they go, all that. I get that. But in terms of the value of a 765 overall, what that means in terms of 2 or 3 345s.
Yes, sir. I mean, you know, one of the things I've talked about a lot through this is, again, that map at 345, and it almost looks like a spider web of 345 going around the state. And these lines would be sited, these routes would be in the same place at 345 kV, except there would be a lot more of them.
Let me ask you this: Are you familiar or aware with how often or how many folks have been complaining or upset about the process as we've built the 345s? Have you had a whole bunch of opposition there and so forth?
No, I would say we don't hear that. You know, at our open meeting coming up tomorrow, we actually have 2 345 kV Permian Reliability Plan projects that we will make decisions on tomorrow potentially. And really, all of the, everything we've heard, all of the discontent has been around the 765 plan.
Well, so the reason I ask that is because if up to now, you've had a lot of 345s built, right, and you haven't had a whole lot of opposition, then maybe whatever the process was for the 345s, if we're not doing that on the 765, I guess, because if they weren't complaining about those, then maybe you were doing that right. And I don't know what the difference is between that process and the 765, but don't reinvent the wheel, right?
Yes, sir. So the process is set forth in statute and rule, and it's actually the same process. And I think that is actually what you hear the complaints about, that these lines are so much longer, have so many more interveners. So we have one case that has over 800 parties in it. And what we've heard, again, we've taken, you know, public comment on this in our open meetings. We've also heard oral argument in one case. Most of the complaints, yes, people do not want these facilities on their property, but a lot of the complaints about this have been around the process, that for construction of this size with this many parties, that the shortened timeline from a year down to 180 days is just insufficient.
Thank you.
Ms. T.
I'd like to ask you something about the Comanche Nation. They have a concern about how does the CCN permit application process identify tribal nations whose cultural resources, including burials, will be impacted by a project?
Yes, ma'am. So we make all of our decisions on routing based on evidence in the record. So any party can put evidence in the record. So if that is there, we would avoid, in our routing decisions, look to avoid those types of impacts, of course.
Thank you very much.
Yes, ma'am.
Members, Mr. Darby.
Thank you. Chairman Gleason, prior to House Bill 5066, was there anything in statute preventing a transmission provider from filing a CCN application for a 765 kV line?
No, sir.
Or is it accurate to say simply never was one proposed? We've never had one proposed here in this state. Is that correct?
That's correct. In ERCOT, 345 kV has been the highest voltage.
Senator Schwartner filed SB 1665 last session, which would have required PUC feasibility study on extra high voltage transmission lines. That bill never received a hearing.
I believe that's correct, sir.
Chairman Gleason, I want to ask about the market design signals for thermal generation. Mr. Bennett with TPPF, who testified earlier, has argued that we need to fix market design before we act on transmission. You said we need to send market signals for new dispatchable generation, a carrot, not a stick. Last session, House Bill 3970, which I authored, passed the House unanimously, 142 to nothing, and would have expedited the interconnection process for large loads to bring their own generation. It died in the Senate. Do you think that that was the right approach? And specifically, can we tailor or could we tailor a version of that concept so that large loads bring their own dispatchable generation, like natural gas, jump the interconnection queue?
Yes, sir. So, as we talk about affordability and the need for additional thermal dispatchable resources in this state, I've spoken a lot about this. I know you and I have talked about this as well privately, that the companies, these data centers, when I've talked to them, they are more than willing to bring their capital to bear, not just to benefit their own private interest, but also the public interest. So I think discussions heading into next session around the types of incentives we want to incent those companies to bring that capital here. And if, as they tell us often, that speed to power is the most important thing to them, provide those incentives that if you are going to bring your own generation, come up with some percentage of that, 51%, 75, 100%, we can debate what that needs to be, but bring that amount of thermal dispatchable generation with you, and you would move to the front of the line on the interconnection queue. Yes, sir.
Thank you, Mr.
Mr. Guerin.
Mr. Gleason, and we've heard testimony from several of the data centers, that if they bring their own power and they have no intention of hooking up to the grid, and we put it in legislation that they cannot hook up to the grid, would that, and therefore they wouldn't be selling electricity onto the grid and making money off of it, would that be a solution that the PUC could live with?
I guess I would ask what problem we're trying to solve with that. So, as I've talked to the data centers, they all need 5 nines of reliability, and they've expressed to me that, bringing their own generation behind the meter is really a bridge solution, but they need to be ultimately interconnected to the grid. I think if they do have a way that they believe they can get consistent, reliable electricity as a full island, I'd like to hear the details around that. Obviously, if they're not grid interconnected, it doesn't affect the reliability on the grid. But I think, again, that if we can partner with these companies to, again, not just benefit their own private interest, but bring that capital to also benefit the grid. And what we've been working on since Winter Storm Uri, since 2020, late 21, when Chairman Peter Lake came to the commission through 2023, as was mentioned, we spoke almost exclusively in this committee and everywhere else about market design, about the PCM that has now pivoted to the DRRS Plus that ERCOT has proposed, ways to try to find incentives to bring generation that we want here. I think it makes a lot of sense to start talking to these companies that have a lot of cash on hand about bringing that to benefit the grid as well.
Well, where I'm going with this is when batch 0 finally ever comes out, and you don't get an interconnect, bring your own power behind the meter, and agree to never be on the grid, then PUC shouldn't even have anything to do with them. Would that be correct?
I think that is correct.
And just TCEQ on their air permits and stuff.
Correct, and if they ever made the decision that they did want to interconnect, then they would go through our process.
And then, or if ERCOT came to them and said, we've got to have you, will you hook up?
Yes, we could have those discussions as well if we need that generation.
All right,
Yes,
thank
sir.
you very much.
Yes, sir.
Appreciate you being here.
Members, other questions? Chairman Gleason? Oh, Mr. Turner.
Thank you, Mr. Chairman. Chairman Gleason, thank you for your testimony. You alluded to the complexities of this process with the timeframe stipulated in House Bill 5066 of the 180-day turnaround time on the CCN. If the commission did not make a decision at the end of 180 days, what happens in that circumstance?
So the law provides that the parties can seek mandamus and get a court to order us to act. Nothing goes into effect by operation of law. And so what we've committed to, again, because we're going to hear oral argument, there may be some of these that do slip somewhat beyond 180 days. So you may see a decision come out on day 190, for instance. but nowhere near the previous 365 days that we had prior to House Bill 5066.
Okay. And the parties in that example, would that be?
I would,
Maybe who?
I would imagine, in my time at the commission, which is going on 20 years, this has never actually happened. But I would imagine that you would see the utilities want to get an answer to the question about, needing to build, because they have an obligation to serve their customers, and they believe that these projects are necessary. So I'd imagine that is the party that would ultimately seek to have a court mandamus this and to make a decision.
Okay, thank you.
Yes, sir.
Other questions, Chairman Gleason? I've got one before you leave. We're going to talk a lot about the Permian Basin, particularly in being underpowered. And would you say that it's true that without further transmission and more power generation, that part of Texas could certainly be facing rolling blackouts? Are we running that close to the?
Yes, sir, and I know Mr. Rickerson is here for ERCOT, who can probably better testify to it, but yes, ERCOT is projecting that as early as next summer, far west Texas could see rotating outages. So every day that we don't make a decision on building transmission just exacerbates that issue. So,
but beyond that, there are other parts of the state that are kind of facing that same dilemma, right? Particularly Houston. There's been a lot of testimony about how close how much available power is out there for Houston without more transmission.
Yes, how much capacity is out there? Yes, and as we see, Texas is blessed to have all of this economic development and have people from all over the country and all over the world wanting to move here. We have to build the infrastructure to support that. We're working at the commission to make sure that the costs and the process around that are done fairly and equitably. But I think we have to find a way to accommodate all of the development that's coming here, and transmission, just like generation, is a part of that solution.
So the 345 lines, to build the 345 lines that would do what a 765 would more than double the footprint of the lines, correct?
Potentially, yes.
Okay. So it's one 765 or 3 to 4 345s is what I've been told, to get the same amount of transmission.
I think that's right. What I typically hear is 2 to 3. Yes,
So
sir.
now we're talking about really a routing issue, and I think everybody in this room is upset about the routes, right? So we have to, when we're figuring out if we're not going to do 345s again, and we're not going to do 765s, what's the alternative for transmission outside of Elon beaming it down?
Yeah, I don't know if the space energy is going to be here while I'm the chairman. So, and that's a good point of clarification, Chairman. Actually, thank you for bringing that to the front of my mind. A lot of what we've heard has been around the routes, because these are as proposed straight lines, because the transmission companies don't actually know where point A and point B, where it's actually going to be sited. And so ultimately in all transmission CCNs, we select a route, but the next phase of that is siting. And so in the siting phase, where the TDUs will work with the affected landowner to figure out exactly where these lines need to go, and we can order in our final order in any CCN that TDUs do everything that they can to mitigate impacts to landowners. And that is something that I have committed to doing in these final orders for any project that has this type of, input from affected landowners and so much concern about what is going on. But I think a lot of that too is around education, that we could have all done a better job of letting the landowners know that if you have a ranch right now that's been in your family for generations and a line is currently routed to go to bisect your property, that we will order the TDUs to avoid and mitigate that impact to your land.
So do you think it's fair to say, if you have generation, you have to have transmission. So to get to the parts of the state that are growing, particularly without data centers, just population growth, those areas are either going to have a power plant or transmission lines, right? Because you can't. If we're going to build the power plants in West Texas, you're not going to get power to the I-35 corridor without transmission, or you're going to build power plants where the population is.
I think you're going to do both. I think it's all part of one ecosystem. The load begets the generation requires transmission, and it's one big circle that has to be closed, and transmission has to be a part of that.
So on the routing question and the cost overruns that we heard quite a bit about the cost overruns over the last few months, but particularly, you know, the Senate brought it up that, you know, how bad in 345s, how bad the cost overruns were, and it took longer and cost more money, just the whole thing. How much of that cost overrun was due to turnbacks, rerouting? I mean, I guess my point is, I'm not saying I'm for the straight line approach. I just think it's important to get it out there that the reason you start with a straight line is that's the cheapest. Is that right?
It's the cheapest, and again, I think, you know, and the TDUs can probably better answer this, but because they don't know what the actual route's going to be, it makes sense when you're planning to just draw a straight line and ultimately figure out the details. But yes, you know, if you look at something like the CREZ project, you know, from 15 years ago, that project initially through planning was estimated to be $4.9 billion. It ended up $7.9 billion. It's not one for one, but there's a pretty high correlation between the number of line miles added and the increase in cost. And so again, yes, there is a trade-off as we, you know, instead of going straight, in order to mitigate some, you know, line of sight impact or some other impact to a landowner, if we end up making 4 right turns to go straight, adding turning structures and line miles, that is going to increase cost. We did order in this project for all of this to be a Permian Reliability Plan, a monitor similar to what we did in CREZ, so we can monitor the construction progress and the costs and report back on that. And where there are cost overruns or delays, we can get an understanding as to why, and that will help inform decisions as we go forward. Because again, all of this ultimately, whether or not these companies can recover and earn a return on any of this investment will ultimately come to the commission in the form of a rate case.
Okay. Members, another question for Chairman Gleason before we let him get out of here. Thank you.
Thank you, Mr.
Thanks
Chairman.
for being here.
Thank you, members.
And I know you weren't the right guy to answer all of that, but since you're leaving, had to get you while you were here.
And do my best. Thank you, sir.
Okay. Woody, do you want him to clear the room before you start? So, we'll go with you, Woody. We have, just state your name and who you represent and give us your opening comments.
Woody Rickerson, Chief Operating Officer at ERCOT, registered professional engineer in the state of Texas. I've been with ERCOT for 26 years now in different roles, including transmission planning. Transmission planning is one of the core ERCOT responsibilities. We're the sole planning coordinator registered with NERC for the Texas interconnection. And in that work, we coordinate with more than 25 different transmission service providers and over 200 generation and resource operators and developers in planning a system. In regards to 765, we've conducted 3 relevant studies to date that considered the 765 transmission, the Permian Basin study, which was published in July 2024. And then each year in 2024 and 2025, we do what we call a regional transmission plan, which is a 5-year plan that looks ahead. So those were 2 other plans. I guess in summary, ERCOT's recommendation of 765 transmission facilities reflects a lot of engineering analysis on multiple load scenarios. And in each of those scenarios, that 765 was recommended.
Okay. So, Ben?
Excuse me. Ben Barkley, Chief Executive and Public Counsel for the Office of Public Utility Counsel. I'm going to limit my testimony to the CCN process and how that affected some landowners there. To start out with, typically we don't get involved in CCN processes as OPUC because it would force us to essentially pick one landowner over another, both of whom we're technically supposed to be representing. So we typically don't do that. However, given the magnitude of these particular cases, we decided to intervene with the objective of trying to maximize the rights of the landowners as participants. What we found in this process is a few issues that cause problems for landowners. I think the one that you've already heard the most about is going to be the 180-day timeline. Out of those 180 days, 60 days are typically reserved for the ALJs, and another 30 to 35 are going to be reserved for the Public Utility Commission to make their decision. Now, we're not begrudging either one of those entities for that time. They need that time to make that decision. I think that's perfectly reasonable. However, that still leaves residential consumers and everyone else, all these landowners, 90 days to litigate this case. And in some instances, that results in a 4-day hearing where there were 230 parties who had, in some instances, roughly 5 minutes to conduct cross-examination in a case. And when your land is at stake, that's not an ideal situation for you to be able to fully litigate your case. That was one of the potential problems. There was another instance where there were 70 briefs filed with a 4-day turnaround deadline for submitting responses. And an attorney would be hard-pressed to be able to do that efficiently. I think a layperson involved in this case would have an even harder time. In addition to the compressed timeline, we've also seen some instances, which were also supported by NALJ's findings, that there were a considerable number of landowners who were not actually informed of an open hearing, so they were not given that chance to be able to get a jump start in finding their attorney, formulating their case, or even informing the utility of potential obstacles on their property, like a homestead or a cemetery or anything else. And then in some other instances, and this unfortunately comes up in all kinds of utility cases, for various procedural reasons, people end up getting excluded from the case. And most of the time, that happens to lay people who don't understand the process. In one instance, there's roughly 600 people who ended up getting excluded from a case on procedural grounds. This obviously creates a lot of confusion for landowners. It creates a lot of frustration. I think returning to a 365-day schedule is not going to address some of those procedural problems, but at a minimum, it's going to give people more time to formulate their case, become more familiar with the law, or find an attorney. So that would be one of the helpful changes for the system. In the absence of that, maybe something that protects pro se litigants and enabling them to continue to participate in a case, even if they fail to meet certain procedural hurdles that an attorney would be able to overcome that they might not be familiar with, would be helpful. I'm happy to answer any questions.
Thank you very much. All right. Christopher, please
Yes.
just tell us who you are and who you're with and
Okay,
proceed.
my name is Christopher Monson, and I am the Chief ALJ. I want to start by pointing out that I'm ethically barred from discussing the substance of the programs in question. I'm here to just answer your questions about the procedural and logistical impact of the 180-day deadline on these cases, and that's what I can speak to. It is a significant, for those of you who don't remember, quick refresher on who SOAH is. We're about 60 judges and an independent agency in the executive department, and we perform an independent hearing process where we do have all kinds of procedural requirements, as you would have in a court of law, to bring your information to become part of the record, to be part of an administrative finding. In these larger cases, we also serve an information gathering and refining process. Often the parties will negotiate once you have the pre-hearing lineup, because when we have one of these big cases in front of the TCEQ or one of these CCN cases, when it's referred, we don't actually know how many people are going to be there or what issues are going to be involved, and we don't find that out until the pre-hearing conference. At that time, traditionally, folks have been able to see what everybody's arguing and align themselves, and often we'll see 500 competing routes down to 6. So we only have to make a decision between 6 potential route decisions and not 500. That's an efficiency, for example, that we were not able to realize in this case. And so just things like that, I'm here to answer any questions you might have about the process and the pressure it put on us to provide due process.
Understood. All right. Ms. T. Okay. You ask me whatever you want.
I'd like to ask you something about the Comanche Nation. They have some concerns, and they are concerned about whether or not that the certificates of convenience and necessity permit application process identify tribal nations whose natural resources, including burials, will be impacted by the process. And I have 2 other questions after that.
Okay, I can't speak directly to that. Under this process, those filings are made at the PUC, and we proceed under the Commission's rules. We don't proceed under our regular SOAH rules. So I can't actually speak to that with specificity, although I think, as was mentioned before, the rules governing evidence and admission of parties do govern these proceedings. So I would expect them to have a chance to present that information in a hearing.
Anybody on the panel?
The only thing I would add is that it's going to depend on their ability to participate in these cases. So if they have participated in these cases and submitted that evidence, then it certainly will be considered. If they have not had the opportunity to participate in this case and submit the evidence, then it won't be.
Okay, so they would have already had to been added to the participation list? Or can they now become a part of the participation list?
After the pre-hearing conference, there's a process to figure out who's an appropriate party and who isn't. And under this compressed proceeding, we're already done with 2 out of 5, and we expect the rest to be out before the end of the month. The process is over, and it's too late to participate in the procedural process.
So they would be too late to be concerned about their tribal nation burial sites and then their protection that could afford that particular nation, particularly about their spiritual aspects and other concerns that they may have relative to those burial sites and their cultural resources relative to their nation and their tribes across Texas, where you all are going, where these projects are going to be taking place.
The statute provides the amount of notice and participation in these processes, and so I think that's a question of applying the statute. We apply the statute right down the middle, and that's all we can do in this case.
Let me ask you one final question.
Of
And
course.
I understood what you just told me. I just want to be absolutely clear on the record. You have a process that you notify the public at large of those persons who may have an interest or concern about what you're doing in those hearings, and particularly on this certificate of convenience and necessity. And the public, if they have a concern, have an opportunity to contact you and make whatever legal arrangements that they may have to participate in that process and bring to your attention their concerns concerning some of the things that the Comanche Nation are concerned about. They said about their burial sites and other tribal cultural resources that may be impacted by this process.
So those notice requirements and requirements to participate are fleshed out in statute and further fleshed out in PUC rule. I just want to point out that because the PUC's rules govern, it's not SOAH's procedural rules that govern this part. All of those applications are originally filed with the PUC and then transferred over when the hearing is transferred over to us, and they send us a number of questions, and then we hold the hearing and hear the evidence from the participants.
Okay, Mr. Chairman, I have a statement from the Comanche tribe to present as a part of the record of our committee hearing. Would the chair will accept this?
If they will submit it through the public comment portal, it'll be part of the record, but they need to submit it through the public comment portal.
And what is the length of time, the deadline, the cutoff
It's the
period
same.
for that?
Friday at 5.
This Friday
This
at
Friday
5.
at 5.
Thank you very much.
Mr.
Thank you.
Chairman,
Mr. Smithy?
Yes, so in following up to Ms. Thompson's question, I've gotten a lot of complaints from individuals who are complaining about the process. They said, it occurred too quickly and all that. What I'm wondering is whether SOAH has any authority by rule or statute where a SOAH judge could look at this case and say, hold on just a minute. There are a lot of reasons in this particular case that we need more time, and send it back to PUC. Is there any authority to do something like that in extraordinary circumstances?
No. By contrast, though, in some other statutes, we do have that power, actually, to amplify the amount of time. So the TCEQ has a similar 180-day deadline that starts at a different point. At TCEQ, it starts from the date of the pre-hearing conference. At PUC for the CCNs under the current statute, it starts when the utility files the application.
Yep.
And as Commissioner Gleason pointed out, in this case, there's only a mandamus to require prompt issuance of the decision. Under the TCEQ statute, there is a ground for expanding the deadline based on a showing that there will be a deprivation of due process.
Okay. Well, it's concerning, I think, to members of the legislature when our constituents say we didn't get a fair shake. That's concerning. But the other thing that I think is concerning is when they have specific complaints about the process and that they didn't get a fair hearing or were not heard on on what their position on the issue. And so I understand you're limited by your rules and your statutes that apply to you, but that may be a topic the legislature needs to look at in connection with these types of cases, whether there may be extraordinary circumstances where we just have to say, let's reset the clock and look at this again. I don't know. This is the first time it's come up.
We'd be glad to share our expertise, because every statute's a little bit different. We'd be glad to share our expertise and what's worked in other circumstances.
Okay.
Okay. Members, are there further questions of this panel? Mr. McQueenie.
Thank you, Mr. Chair. What's the impact of this 765 project on batch zero? I think that's an ERCOT question. Everybody, both of them slid the mic to you quickly.
So the batch zero process is like Pablo described earlier, is a way of taking all these individual studies that were done for all these individual data centers and putting them in one
Large load
one
users.
large load batch and doing that study together. Every one of those large loads had multiple studies associated with it. All of those studies included 765 in their base assumptions. So there's 600 plus individual TSP studies that would not be valid, would
If
have
we
to be
went a
reworked.
different route. Okay, thank you.
Mr. Darby.
Thank you. Woody, you and I have talked many times over the years regarding economic modeling, and 8 years ago plus, if we had switched to an economic modeling to determine the necessity for these lines, would we be sitting here today, in your opinion, talking about 765s, or would we have built in the interim 345 lines that were capable of servicing the economic development that that region has demonstrated to the state? I know it calls for speculation, but
I think it's the what's driving the 765 at this point is reliability. Two ways you build transmission lines or justify the build of transmission lines. One is an economic criteria, which says that the economic benefit to consumers is more than the cost of the line. That's one way. The other way is if you don't build it, you can't serve them. It's a reliability. The 765 is being driven by the reliability need, not by the economic need. However, there is a tremendous economic impact by building these 765 lines. So they're saving $230 million a year in consumer energy cost savings. So there is an economic
you're
impact.
talking about transmission constraints.
By reducing transmission constraints, by
GTCs,
having the
are there-
765, congestion goes down.
Are there still approximately 17 GTC constraint areas
No, we're
in the
above
state,
that
or have you
now,
reduced
yeah.
those?
Even more now, yeah.
Even more
Right.
now? And for those in the audience who don't know what a GTC is, it's basically, ERCOT acts as a highway monitor with electrons flowing, and they say, at this point in time, we're going to restrict the number of electrons that are able to access that bridge, if you will. And so what it does, before the meter, before that constraint, the energy generation is less efficient. So if you tell them reduce their capacity by 15%, that makes their project 15% less efficient. But what happens on the other side of the constraint is customers pay more, 15% more for their electricity than they would have had that constraint not existed. So you're saying, now I always thought, at least a couple of years ago, that congestion cost was about $2 billion a year. You're telling me, are you saying now it's been reduced to 200-something million?
No, what I'm saying is that these lines will provide, 765 alternative provides over $200 million more in congestion cost savings than if you built an equivalent 345 kV
Oh,
system.
okay, I get that.
Yeah.
Okay, Benjamin, you got a lot of people sitting behind you. They're mad. They're frustrated, as we are. I'm the only one on this panel that has 2 lines going through my district. And part of this is complicated because we do have a growing state. We have growing needs for reliability. But it has to, we have to go across people's land, so the process has to be fair. And I look out, and according to the plans that the utility companies have submitted, there are 3 nodes, and the PUC has approved this. But at each node, there are multiple route locations within that node. So we've involved a multiple of people that have spent money and time to protect their interests, but yet those lines won't be on their property. They've spent legal fees and time and effort to try to prevent those lines from going onto their property, but yet they're having to pay out of pocket those costs, but they're not able to recover those costs. So we've involved, I don't know, roughly 66%, 2/3 of the people involved in this process will never have a line on their property, right?
Yes,
And
sir.
they spent the money to defend their property, but they're not gonna have a line on their property, but they're out that money. So they kind of feel good about that perhaps. But then you have the people that spent a lot of money, tried their very best, and they're gonna have a line crossing their property. Now, they're out that money. Now, the frustrating part is that when the rates start being calculated, and you need to confirm this, that the utilities get to recover their attorney fee costs in this process, but landowners are not. So the landowners have to pay double.
Yes, sir. That's,
That is unacceptable. Now, I've tried in the past, I think Senator Colcourse and I tried to cap utility legal expense. These are more on the rate side. It didn't pass, as you might suspect. But it's frustrating to me that we don't have some sort of cap that does not penalize, that we don't penalize folks who are trying to protect their property rights by making them pay double for it. And that's what's frustrating. Can you elaborate on that a little bit?
oh, I couldn't agree more. Right now, the system is designed in such a way that in utility proceedings and in rate cases, you have one party who has all of their rates, that's the utility, who has all of their rate case expenses, that's their experts and that's attorney fees, that are getting paid for by the opposing party. So in a lot of cases, even if you potentially lose, although what losing means in a rate case is a little complicated, you still have to, those residential consumers still have to pay for the attorney's fees of the utility. And it creates an incentive to perhaps litigate more than you otherwise would if you had some of those expenses, if you were on the hook for some of those expenses.
Well, I would look forward to your support in the next legislative session when we look at legislation that tries to cap some of these legal fees on the utility side.
I'm happy to testify.
To right the ship a little bit, so. Thank you, Mr. Chairman.
Members, there are other questions of this panel. I see none, but you may have one in a minute, so please hang around if you can. All right, chair calls Ms. Tanya Tucker. And while our next panel will be, what is that, Emily Martin Howe, Bonnie Terrell, and Brandon Huckabee will be after Ms. Tucker. Yeah. I don't know where she's at. Where's the Jeopardy music? There she is. Come on down.
This good?
That is good.
How are y'all? Good to see you.
The record shows that you are Tanya Tucker, and you're testifying on behalf of yourself. Is that correct?
That's correct.
Please proceed.
Good afternoon, Chairman King, Vice Chair Hernandez, and the members of the committee. I'm Tanya Tucker, and I'm back. I'm not back because I don't have anything else to do. I'm back because, like so many others, I've had to stop what I do for a living to navigate my way through an obstacle course that is so daunting and complicated, to say the least. You might say, Tanya, you're out of your lane. But contrary to what you may think, these 765 kilovolt transmission lines are not only in my lane, but more importantly, I'm in their lane, in their direct path. They threaten the 140-year-old multi-generational ranch where I live. They threaten the lives and livelihoods of thousands of other Texans who cannot be here and cannot be heard. And again, some weren't even notified. So yes, here I am again back in Austin at our beautiful state capitol for the second time. Next time I'm gonna bring a sleeping bag. So I'm here, and I love the beautiful capitol. It's good to be here. I've been walking these corridors today looking for the words that will capture my feelings. On these walls, I have seen paintings of the people who shaped this great state. Davy Crockett, Sam Houston, Stephen F. Austin. It's humbling to think about the sacrifices they made for us. We all understand that a strong, reliable power grid is key to our future, not only as a state, but as a country. But we also need Texas to be Texas and look like Texas. In the last couple of weeks, I have been contacted by people from as far away as Minnesota asking me for help. I don't have the answers, and I'm not an expert. I'm not even sure the experts are experts. The answers seem to be so vague for such an important question. And I'm not asking our leaders to stop working towards a stronger power grid, but just to pause. Take a closer look at what this will do to our beautiful land and our lives. Our lives. There's a lot you can't see by looking at maps on a computer screen. We, the people, elected you to make these decisions on our behalf, and the landowners, well, we didn't even get a seat at the table. You just got to make the right choice for our children and our children's children.
Ms. Tucker,
Yes.
I'm going to stop you because you're out of time, but you're not done because I'm going to ask you a question.
Okay.
So, you said that you don't have the solution, and you know, there's no bill before us here today. I mean, the reason we're having this hearing is
Yes.
exactly what you said.
Yes.
We have way too many people that don't like the proposed routes.
Right.
I think everybody says that 345 is going to be a bigger footprint and not deliver as much as 765. But I really think, regardless of the size of the line, really the problem is the route.
Yes.
Is that correct?
Well, yes. And what was so wild is we don't really know a lot about it. It was kind of it's a surprise thing, and I didn't even think, I thought it was a joke. But yes, the thing is that I just think that it needs more time. We need more time to process all this that's happening to us. It's a harsh reality. And I just, I'm grateful. I want Texas to be a beautiful state and stay that way. I understand all that, but it seems to me like there needs to be taken some time to just think about the options. There may be some, we were just starting to drive not too many years ago, discovered the car. So we've got some smart, very intelligent people in this country, and I think that they'll be able to come up with something that will be good for everybody.
But I wonder if you have an opinion on, it seems like, and there's always another solution, right? We can keep digging until, but
Well,
we're not going to make everyone happy
No, we're not.
all the time.
No.
But one of the things I've heard a lot of pushback about is we don't want 765 lines. I understand that. But where the population centers are, they don't want the power plants. So, you're either going to build power where the people are.
Somebody's not gonna be happy.
Somebody's not going to be happy. And I guess it's what we're trying to do is make the least amount of people mad
Right.
is ultimately what we're doing. But I do think that we're growing so fast.
Yes.
You take data centers out of the whole equation. We've got parts of Texas that aren't just the oil field in West Texas.
Right.
There's huge population centers that are facing rolling blackouts. And so the transmission piece of this has to come from somewhere. But as far as I will make you a commitment from State Affairs Committee in the Texas House, there won't be anything next session that the landowners don't have a seat at the table.
Yeah.
We don't do things that way in this chamber.
Well, yeah, I know. I tell you what, if I thought there was one thing great about all this, I'd be out there, making lemonade for them and singing them a song, whoever was working on the dang thing. So I'm all for what's good for this state. And I just know that we're a leader. We lead the rest of the states. And what we do is going to kind of they're going to depend on what we do and look to us. So I have faith in our governor, and I also want to say I'm forever grateful to Brad Buckley, Representative Brad Buckley, for his knowledge, his guidance. There's no way I could have made it. It was over my head, way over my head. But I'm willing to, I'm all behind our leaders, and I just have faith that you're going to make the right decisions.
Well, we love Brad too, but it's over his head. So.
Well, I'll tell you what, it's a good thing he's a vet, too.
That's right.
I'm very grateful to all of you, too, for listening, and I certainly appreciate it, but just remember, it's not a little too late to do the right thing now. God bless you. God bless Texas. Thank you so much.
Thank you, Ms. Tucker. Appreciate your testimony.
All right.
Oh, wait a minute.
Something different to me.
I didn't ask anybody else they had a question.
Oh, y'all ask away.
They're leaving you alone.
Oh,
Thank you.
I can't believe that. That's not fun. Thank you
All
all
right.
very much.
See you later.
Thank y'all.
Thank you. All right. Chair calls Emily Martin Howe, Brandon Huckabee. Who's that? And Bonnie Terrell. Ms. Howe? Are you
Yes,
Emily
sir.
Howe? We're going to start with you. The record shows you're Emily Martin Howe. You're here testifying on behalf of yourself. Is that correct?
Yes, sir.
Please proceed.
Thank you. Thank you for the opportunity to be here today, for another opportunity to have our voices heard. You have seen many people here today who are concerned about these proposed projects, and I'm here today as one of them. I stand as a landowner directly affected by these routes, and I want to share with you my story and my concerns. I was legally notified by mail, postmark in February of this year, but not aware of the project except by a neighbor on March 9th, less than 30 days before the deadline to become an intervener. Like many landowners who do not do business directly with the Encore, I had previously disregarded the packet from the February as junk mail. Since March 10th of this year, I have been actively involved in advocating and helping others. I've had the honor to work with many volunteers to help our fellow neighbors to have their voices heard, to defend our homes, our businesses, our schools, and our family legacies. We have had to navigate a system that is not user-friendly to pro se. It's in a limited amount of time. One of my fellow volunteers has provided a timeline of this process, and I ask you to review that timeline as you look at these steps and the things that we had to go through. I plan to email my full testimony with attachments to you because there's a 300-character limit in your system, and I have more to say than that. This email will show you all the filings that were related to my name. Not only did I have to file mine, but our volunteer group filed on behalf of several hundred other people across our area. Before these filings, we had to educate people to advocate for themselves. We had over 1,300 interveners file. Unfortunately, over 700 of them were removed from the case with SOAH for one reason or the other. I hope this information and those numbers pique your interest to research this process and help make changes on behalf of the public who elected you.
Thank you for your testimony, Ms. Howe. Remember, there are questions for Ms. Howe. Seeing none, before we move on, the next panel is going to be Dave Clark, Charles Grandstaff, and Joanna Freibel? Okay. That would be the next panel. So right now, we're going to go to Brandon Huckabee. Mr. Huckabee, the record shows you're Brandon Huckabee. You're testifying on behalf of Erath County citizens, and you're the Erath County judge.
Yes, sir.
Is that correct?
Yes, sir.
Please proceed.
Absolutely. Chairman King and members, thank you for allowing me to speak on behalf of Erath County citizens. My name is Brandon Huckabee. I serve as the Erath County judge and chairman of the Erath-Somerville Subregional Planning Commission. When I testified before the Senate, I talked about the human cost of these 765 kV lines. Today, I want to talk about how we got here, because the record now confirms by SOAH what Erath County landowners have been saying for months. This process failed them. Take segment C8 in Erath County. The proposal for decision confirms that routes affecting those landowners were added after the public meetings had already occurred. After those routes were added, a public meeting and direct mail notice to all affected landowners was required. That did not happen, yet the PFD still recommends C8. Members, if a Texan can have a 765 kV transmission line placed across their property without ever having the opportunity to attend a public meeting where that route was presented, what exactly due process mean for that landowner? And the problem is much larger than C8. The record contains an admission from PUC staff that it's simply infeasible to read all the testimony, filings, and protests. I don't say that to criticize staff. I say that because it proves the project scaled, but the process didn't. We're using procedures designed for ordinary transmission projects to decide one of the largest infrastructure expansions in Texas history. So I ask a simple question. How can we admit the process is broken and still allow permanent decisions produced by that process to move forward? You cannot restore due process after the easement is condemned. You cannot hold the missed public meeting after the line is built, and you cannot meaningfully consider evidence after the record is closed. These applications should not advance until the legislature is done determining what a fair and adequate process looks like. Reform the process, give Texans meaningful notice and meaningful opportunity to be heard, then make decisions of this magnitude under a process worthy of their consequences.
Thank you,
We
Judge.
can-
Judge, I have a question so
Yes,
you
sir.
can finish. So you were very clear. I mean, I don't think I misheard anything, but just so we're going to repeat this. The route that was supposedly adopted wasn't even proposed in the public meeting? So what'd you meet about?
It came afterwards, after their due diligence from the public meeting. C8 was added after that. In the SOAH hearing that was filed on August 14th, you can see that record that those people never had a public hearing. So they got notice, but we talked about that condensed time frame. Their time frame was condensed even more.
So in the meeting where there was public comment before the C8 was added.
Correct.
What did you talk about?
Well, it was held in June in Erath County, and it was, I think, 3 to 4 counties. It was one in, one out, hundreds of people outside for 2 hours. with a map. So lots of people didn't get anything
But the
from it.
route that eventually came out of this
One of the
discussion
segments.
wasn't proposed in that meeting.
Correct. It was not on the map at that time.
Oh, all right.
And the SOAH record reflects that.
That is good intel.
Yes, sir.
Members, other questions for the judge? I don't see any. Thank you
Thank
for
you.
that. Bonnie Terrell. Record shows you're Bonnie Terrell. You're testifying on behalf of yourself. Is that correct?
Yes, it
Please
is.
proceed.
Chairman King and members of the committee, I appreciate the opportunity to speak with you today. My name is Bonnie Terrell, and I'm here on behalf of my family and the 83-year-old Great Southern Ranch. In this process, landowners are expected to understand complex administrative law and legal procedures and follow a grueling timeline. They have to become investigators and regulatory experts to protect property they've spent generations stewarding. A process that affects people's homes, livelihoods, family land, and financial legacy should be accessible, transparent, and fair. If the stakes are this high, the process must earn the public's trust, and this one doesn't. Most Texans assume that before the government authorizes the use of eminent domain, someone's already done the homework. In the case of Dinosaur Longshore, my docket, that simply wasn't true. The testimony in our docket points to many important constraints that Encore's analysis overlooked, including habitable structures. They didn't accurately reflect that the city limits of Stephenville or that the best meets route crosses through those city limits. Encore relied on maps that were as old as 2022 in some cases. Landowners did their due diligence for them, but then the environmental assessment was not updated with the key information for decision makers. The response to legitimate constraints pointed out by landowners time and time again was that once boots were on the ground, they would engineer around it. And that simply isn't good enough. A routing decision should be based on sound front-end planning and landowner input before routes are drawn, not solicit information after the fact when the decision is all but made. Growth and reliable electricity are important, but growth should never come at the expense of private property rights and fair process. All can coexist. Please look to local generation where generation is needed. Together, we can save the heritage of Texas. Thank you.
Thank you, Ms. Terrell. I have a question. No, you can't do that. I appreciated her testimony too, but no, it's against the rules, but I do have a question for you.
Mm-hmm.
Did you just say, and I'm paraphrasing you, did you just say that Encore threatened you with eminent domain without a proposed route?
Sorry. The use of eminent domain, I guess, for this project. I said the government authorizes the use of eminent domain.
If it meets, yeah,
Yes,
it's got to
yes.
meet the hurdle. But
Yes,
you're not
yes.
testifying that without a proposed route and just because we've already established, the route came in after the public comment hearing, but nobody came to you and said, we're going to file eminent domain on you
Yes,
yet, anyway.
Thank you for letting me set the record straight. Nobody said that. But the use of eminent domain
Well, eminent domain's always
for
a-
the 765
Yes.
KV program.
And we don't like eminent domain either, but I just wanted to make sure that somebody wasn't out there saying, we're going to eminent domain you.
Absolutely
And-
not, and I appreciate the clarity.
Okay. Thank you so much for your testimony. Members, are there other questions of this panel? I see none. Thank you all for being here. Dave Clark. Charles Grandstaff and Joanna, is it Freeble? Did I say that wrong? Freeble. Joanna Freeble, please come down. Mr. Clark, are you Mr. Clark?
Yes, I am.
We're going to start with you. We have you registered as Dave Clark. You're here representing Friends of the San Saba and yourself. Is that correct?
Yes, it is.
Please go ahead.
Thank you. My name is Dave Clark. I'm a director of Friends of the San Saba and a landowner on the San Saba River. I'm a retired CPA, and I want to start by providing you with some big numbers. The Permian Basin 765 transmission lines could be 1,300 miles, which is the same distance as Austin to Washington, D.C. The lines could consume 33,000 acres of landowners' property. Landowners agree with Lieutenant Governor Patrick, Chairman Swartner, and many other legislators that the PUC should delay any final decisions until the legislature can determine the proper regulatory processes for these massive transmission lines. In my written testimony, I explained 12 problems and provide solutions. 1, Encore's holistic routing analysis is subjective, not documented, and not verifiable. 2, landowners say the June 2025 public participation meetings were terrible. 3, proposed route links cross through the middle of many landowners' properties because Encore used parcel data and not owner data. 4, the applicants did not follow up with landowners or local officials about their concerns. 5, the notice sent to landowners was confusing and lacked important information. 6, many landowners learned for the first time they were impacted by new routes when they received their notice, when the applications were filed. 7, the CCN application is very confusing and difficult for landowners to understand. 8, no instructions were provided for self-represented interveners. 9, landowners are only allowed 90 days to make their case out of the 180. 10, interveners had to upload their testimony and exhibits to 3 different systems. 11, interveners were not allowed adequate time to complete their cross-examination. 12, many legislators question if the Permian Basin Reliability Plan is consistent with legislative direction. Please read my written testimony for more details about these problems and solutions.
Thank you. Thank you so much. That was very clear and concise and to the point. I appreciate that. Charles Grandstaff. The record shows you're Charles Grandstaff. You're also here on behalf of Friends of the San Saba and yourself. Is that correct?
Yes, sir.
Please proceed.
Chairman King, members of the committee, I'm Charlie Grandstaff, and I'm a director of the Friends of San Saba, a member of the Whitetail Advisory Committee to the Texas Parks and Wildlife, a board-certified estate planning lawyer and CPA of 40 years with a substantial number of large rural landowner clients watching this process. Carpe Diem Ranch, west of Mason on the San Saba River, has been in the family for 4 generations. Texas Parks and Wildlife has recognized it with the Lone Star Land Steward Award. Encore's link M33 would bisect our ranch, cross the San Saba, and then run parallel to the river, jeopardizing the river's ecosystem. Here's what troubles me the most. Encore's own engineers asked Parks and Wildlife for routing guidance. On March 25, 2025, Parks and Wildlife answered in writing to avoid crossing riparian areas and to not run lines parallel to streams. Encore asked, Parks and Wildlife answered, and Encore drew a line that violates these very recommendations. That's checking a box. That's not due diligence. The spring-fed hill country rivers are the crown jewel of Texas, in my opinion. They hold the highest concentration of wildlife in the region, and Texas A&M, Texas Parks and Wildlife researchers are starting a new project on our place now. We've had many projects through the years with numerous universities. Every carpenter in Texas knows the rule: measure twice, cut once. History's littered with rushed projects and disastrous results. Encore now concedes the process has problems, but its answer is to fix them on the fly, while saddling many generations of landowners with the largest transmission lines in Texas history. We deserve better. We're not against doing what is best for Texas. We're against getting it permanently wrong. Pause the applications, fix the process, then build if necessary.
Thank you, Mr. Grandstaff.
Thank you, Mr. Chairman.
Question, do the existing 345 lines come through your property or anywhere close?
No, sir.
Okay. Well, and the only reason I ask is there's a lot of discussion about why are we picking new routes? You know, we already have easements, there's 345s there. Why aren't we using the routes we've had in the past? I don't have the answer to that question, but that's why I asked you that.
Yes, sir. Yes, sir. Thank you.
Members, other questions of the witness? Seeing none. Joanna Friebel, you said I said that right. Okay.
Yes, Friebel.
Record shows you're Joanna Friebel. You're here testifying on behalf of yourself. Is that correct?
That's correct.
Please proceed.
Chairman King, representatives, I'm basically an energy nerd. All these other people speaking have really, really good testimony. So I'm here today to invite you to join the growing among people who are learning about energy and what that means to this great state. It means everything to this state. Many of you all probably already are familiar with the basics and even better, the intricacies of the energy resources. I'm here to advise you that this subject cannot be overlooked. Today, you might be caught between large corporations and the regular voter. And you, each one of you, needs to decide how this is going to move forward. For the transmission, consider electric bills and land rights. Ask for a pause and reconsider, or think about denying this whole project. You have choices. But you need to understand the CCN process intimately. You need to know how that works. That is something that's really important to us all. The senators and the PUC both agreed on that. At this time, the end results are already baked into the CCN processes. The lines will get built, good, bad, or indifferent. No questioning once approved by the PUC. The TSPs of the PUC have no risk, only the ratepayers and the landowners. Attorneys' only obligation is to move these lines off their client's land. The need is never addressed, and this is flawed. The transmission project is different from anything we've encountered before, as you've already heard, leading to why we are here today. These projects are designed to divide rural communities, but it only brought all of us together, and that has been something that's really special. The magnitude and number of people affected on the import path 1, which is where I am, is close to 5,000 landowners notified. The failure of the TSP notification process, they hoped, would eliminate people, worked against them. Late notification on import path 1 was about 1,700 landowners, and this is in the record.
Ms. Freeble, thank you for your testimony. Question for you. So you said 1,700 got notices?
Late notification.
Late notification.
Yes.
So does that mean they did not get to participate in the public, I think we've already established that
They
the route came out after public comment?
Yes, the meeting was held, I think 2,400 people, somewhere in that range, were notified. And then whenever the applications went out, it was close to 5,000 people. Okay. And so 1,700 people were late notified, and I think the judge earlier addressed that.
Exactly, okay. Members, are questions of this panel? Mr. Raymond.
Thank you, Chairman. Is this your handout? Yes? So I wanted to ask you, because it says on here, and I know you're quoting Encore, but, so I guess maybe there's a 33 billion and that's X'd out. So is that Encore's number, you think? The
33 billion is the amount that ERCOT.
So ERCOT, it's at
cost.
33, and so you're Xing that out, or
So,
actually, it's the Public Policy Foundation, I think is what it says here.
yes.
And then, but then you wrote 80-100, so between 80 and $100 billion plan for the state, who pays? So we're,
That's lifetime cost.
whose lifetime?
The lifetime, that's the money they borrowed, the interest that's paid over 30 to 33 years, depending on how long they finance it. So that would be the cost over that period of time.
Okay, so
And that
Chairman,
can-
I don't know, we'll have somebody else that, I'm looking at here at the witnesses, but if we have, put the witnesses on notice, if somebody else can address that, I'm going to give you a chance to tell us, I don't know, if Public Policy Foundation is going to be back or somebody else, but I'm going to ask about that. That's a pretty big number, and how people got to that number.
That's from the Public Policy
I
Foundation.
think I want to ask him how he got to the number.
So, no, not
You
me,
have to say your
but
name.
Mr. Bennett, who was on one of your earlier panels.
Yes.
That's his number.
That's his
Yeah,
number.
but he's not here.
TPPF.
Well, at least I don't see him.
Okay. Well, we can do that. You can talk to him, and we'll get an answer. Thank you so much for being here.
Thank you.
Chair, who am I calling now? Chair calls Emily Jolly, Adrian Rodriguez, Jaron Taylor, and Jonathan Tijerina. Did I say that anywhere close?
It's close enough.
All right.
Thank you.
Good. All right. Adrian, looks like we're starting with you. We show you're Adrian Rodriguez, you're President and COO of AEP Texas. Is that correct?
Yes, sir.
Please give us your opening statement, and
Yes.
we're going to do the same thing. You guys will all go through your opening statement, and we'll come back to questions.
That sounds great. Good afternoon, Chairman King, Vice Chair Hernandez, and members of the committee. My name is Adrian Rodriguez, for the record, and I am the President and Chief Operating Officer of AEP Texas. I'm relatively new to AEP Texas, having joined the company approximately 4.5 months ago. However, I do have engaged with this committee in the past from my prior roles in non-ERCOT utilities in other portions of the state, specifically the Panhandle and Far West Texas. As I mentioned in the Senate committee hearing, we don't take this conversation lightly. AEP Texas has the Howard to Solstice transmission line project from south of San Antonio to Fort Stockton with our partner in the project, CPS Energy. We recognize the challenge that customers feel when there is an electric utility project in their yard or on their ranch, and we recognize that transmission projects especially raise these questions. They're large, visible, and long-term, and we need to make sure that they are technically sound, grounded in meaningful engagement, especially with our affected property owners. I want to make sure that the committee understands the history of 765 kV transmission lines, which you can see with the history of American Electric Power, as well as our sister utilities in other parts of the country who have operated 765 kV transmission lines since 1969, as well as 2,200 miles that are currently in the Midwest, as well as other grids that are looking to embark on more 765 kV transmission lines because of their efficiency. Texas continues to grow. We have 6.5 million more Texans today since 2010. And as as Texas continues this rapid growth, we need to make sure that we have adequate and sufficient transmission to enable to support that growth. We're also experiencing business growth throughout the communities where our fellow Texans live at AEP Texas. In the Rio Grande Valley, the construction of new liquefied natural gas terminals and the continuing expansion of SpaceX's Starbase require more energy. There's also development around Laredo, which is scheduled to become one of the world's largest ports. There's, of course, in Abilene, the Stargate project continues to expand its footprint, which you heard earlier today. Altogether, what we might call traditional Texas business, oil and gas and manufacturing, businesses and communities are growing fast across Texas, and we have an obligation to serve them. The community and economic development placing its new demands on our electric grid, as discussed earlier today by Mr. Vegas and Mr. Rickerson. The electric grid needs to be able to move power efficiently from areas of supply and demand where it is needed, when it is needed. And transmission is also not built for its own sake. We can't have generation without transmission. Likewise, we can't have transmission without generation. There are currently major transmission projects that are being constructed, as I mentioned, in other parts of the country. Significant delays in this process can impact our ability to procure the supplies necessary in order to construct these projects. Our goal at AEP Texas, members of the committee, is to ensure that Texas has the infrastructure necessary to support the growth and reliability while also respecting the private property rights and giving landowners clear information, proper notice, and real opportunities to participate in open houses and regulatory processes. We have and will continue to hold meetings that give landowners the ability to engage and, of course, look forward to engaging forward. We're committed to working with this commission, the Public Utility Commission, ERCOT, landowners, local officials, and all stakeholders to make sure that Texas can meet its growing energy needs responsibly and continue to be the economic engine that brings businesses and talent to our state. I look forward to answering your questions at the appropriate time, and thank you for the invitation to address this committee.
Thank you, Adrian. Jaron Taylor. We show you Jaron Taylor representing Encore, is that correct?
Correct.
Please proceed.
Good morning, my name is Jaron Taylor. I'm here on behalf of Encore Electric Delivery. Encore rebuilds or builds hundreds of miles of transmission line every year in the state of Texas. These lines are built for primarily one purpose. That purpose is reliability. They are built to keep the lights on to the residences and businesses of the state of Texas. That is our job, all of us sitting up here on the table in front of you. It is to provide a reliable service to those who need it. I intended to go into a lot of detail on the 765 kV lines and the Permian Basin Plan and why it is critical and needed. Given that a lot of that's been covered, I will simply refer you to this letter that was sent from ERCOT to Representative Guerin last week. It was dated August 12th. This goes into a substantial amount of detail and is probably the most recent and most detailed description of why the 765 kV lines are needed and why the Permian Basin Plan needs to go forward. In particular, I'll just point you to 3 points made in that letter. One, today there is a very real risk of load shed in far west Texas. That means the light's going out. Winter Storm Uri style, where we would have rotating outages based on thermal limitations that we have on our transmission grid today. The 765 kV projects are the solution to that problem. Number two, ERCOT is very clear that generation alone will not solve that problem. I am sure throughout the course of today, you will hear many folks tell you that West Texas is flush in natural gas and we just need to burn it and have power generation, obviate the need for transmission lines. ERCOT is telling you very directly that won't solve the problem. 3, transmission planning is not a game of Jenga. You cannot reach to the bottom of the layers of blocks and pull one out and have the tower remain up. That is fundamentally not how our transmission planning works. These transmission lines become base assumptions and then we build on them, one after another. That is how we study our transmission grid. ERCOT addresses that on the last page of their analysis, clearly pointing out that there are 58 projects, reliability-based projects, all across the state they have approved since the Permian and the STEP plan that are all invalidated if we do not move forward with these plans. Second, there are over 600 different load studies that they have approved and validated that are all invalidated if we do not move forward with these plans. A lot of those are data centers. A lot of those aren't. They're things like Samsung. They're things like Chevron. They're things like TI up in North Dallas. Those are the type of load studies that are the basis of it that need these transmission lines to go forward. Chairman King, I'm happy to delve into the individual projects and some of the complaints and concerns that have been raised, but I'll just look for your guidance as to whether or not you would like me to go into those details, but happy to if you would like to.
We're going to finish introducing the panel, and I bet you get an opportunity. All right, who do we have? Jonathan? I hate to address you that way, but I'm not going to try to butcher your name again, so please say your name for the record and who you represent.
That's quite all right. Thank you. Good afternoon, Chairman King and Vice Chair headed on this, and members of the committee. My name is Jonathan Tijerina. I'm the interim senior vice president for energy delivery services at CPS Energy. We're the nation's largest community-owned provider of electric and natural gas service, serving more than 1.3 million customers in the San Antonio area and portions of the adjoining counties. Similar to, as was mentioned by my colleague here at AEP Texas, my conversation today will be focused on the Howard to Solstice project, as that is the project that was jointly assigned to both AEP Texas and CPS Energy. While similar to our comments during the Senate and B&C committee, we fully acknowledge and are willing to work with the committee and the legislator to figure out what improvements can be made to the process that currently is stated. However, we will want to highlight that in addition to the current process, we are doing our best to go above and beyond to make sure that we are bringing as much awareness as possible around any project that CPS Energy is connected to. And that includes a couple of things such as, currently the process requires at least one open house. We actually had 4 open houses during our process. We had open houses in Atascosa, Uvalde, Del Rio, and Fort Stockton. We pushed out notices 17 times to 10 different newspapers inviting folks to these open houses and reached out to approximately 4,412 landowners. Those 4 meetings drew roughly 470 different attendees at various times of each of the meetings. And in addition to that, we offered as many engagements with the county commissioner courts in those 14 impacted counties that the current lines will be proposed to run through. Both CPS Energy and AEP Texas maintain the project website and maps and fact sheets on both of our sites. They're very detailed into the project and ways to participate. And we have received over 1,600 feedback forms, which led to several preliminary alternative links being added and removed or modified throughout the process. I'll also just want to highlight that through our efforts, we have received over 5,000 pages of testimony, with pretty much none of that testimony being countered or rejected on behalf of CPS Energy or AEP Texas, with the exception of a couple of hearsay documents that just weren't directly connected to the project. Again, for us, our obligation is to serve as a TDSP here in the state of Texas. We take that obligation very seriously to ensure that we provide the reliability that's needed for our customers and for the broader state of Texas. But we also, again, do recognize that a process can always be improved upon, and we look forward to hearing and working with you all through the process to enhance it. We do believe we have complied with the current statutory framework, and again, welcome the opportunity to discuss potential improvements. CPS Energy recognizes the importance of these projects to the Permian Basin reliability and to Texas as a whole for its economic prosperity, and we remain committed to working with you throughout the process to hear how we can make improvements. I welcome the opportunity to answer any questions at the appropriate time. Thank you.
Hey, Ms. Jolly, we show
Thank
you as
you.
Emily Jolly with LCRA, is that correct?
Yes, sir.
Please proceed.
Thank you, Chairman King and committee members. Good afternoon. For the record, my name is Emily Jolly. I'm the Senior Vice President of External Affairs for the Lower Colorado River Authority. I also serve as LCRA's Chief Regulatory and Compliance Officer. Unlike the other utilities that are here today, LCRA is a little bit different. We're a political subdivision of the state. Our utility is a nonprofit corporation. We don't receive legislative appropriations. We don't have taxing authority. And so we fund our system through the revenues that we earn from wholesale transmission, wholesale power sales. Those revenues go back into our system. I think that's important as we think through kind of the next steps in our role and our opportunity, I think, to find solutions that work for the Texans that we all serve. We take that obligation at LCRA very seriously. Our role in these projects came when LCRA TSC was identified by ERCOT and assigned joint responsibility by the PUC for the projects that are known collectively as Import Path 2. That's because we own and operate the Big Hill substation. So that's at the center of the center line that the folks are talking about in the Permian Plan. So we'll own and operate the 765 facilities that go in either direction in and out of Big Hill. My role in these projects was to oversee LCRA's regulatory affairs team. That's the team that engaged directly with the public, and we've had a lot of touch points and heard a lot of their feedback. More than 2,000 emails and phone calls that my team has answered. And so we have a good sense of where we can all improve. Representative Raymond, earlier you asked about the process and whether it's the same for these cases that we've used for all the other CCNs that we've done in the past. And at a high level, yes. It's generally the same process. And we've had experiences with prior cases where we had just as many landowners. The difference in those cases, and some of them, I can think to one about 10 years ago in Williamson County, it was about a 20-mile line, 138 kV, but it affected a lot of landowners. We had over 800 interveners. The difference, as y'all are aware, is that is a one-year processing case. And we understand the significant impact that compressing these procedural cases into 180 days can have. So we're committed to working with the PUC staff and you throughout the legislative session to identify other opportunities to improve that process for landowners. Happy to talk more about our role in these projects and the overall need for them, but ultimately, I'm here to answer questions that you might have, and I appreciate the opportunity to be here.
Okay, before we get to questions, I just want to make an announcement. The next panel will consist of Vanessa Halford, Eric Allman, Sidra Hansen. Following that, we'll have Myra Alanis, Manny Lucio, and Mark Friesenhan. Yeah, I remember you. Okay. All right. Just so everybody's in the room, and if they need to come over when this panel's done, that's the order we'll be going in. Do you have a question? Mr. Chairman Guillen.
Thank you, Mr. Chairman. So this line that's going from San Antonio to Corpus, our folks got letters in the mail over the last couple of weeks from CPS and from AEP about the open houses, I think in Floresville and Alice and somewhere else there. Are those still going to happen?
Mr. Guillen, those open houses have been postponed at this point. We seek to reschedule those. We sought some guidance from the legislature and policymakers. That transmission line is not one that is currently pending with the Public Utility Commission of Texas. It has not been filed. We wanted to wait to get some guidance on those prospective additional lines. The line that we do have pending with CPS Energy right now for which we did have transmission, open houses and is pending with the commission at this point in time, is the Howard to Solstice transmission line project. That one goes from San Antonio out toward Fort Stockton in West Texas.
In previous projects, because I know AP has done one recently, as recent as, you know, it's still going on, I think, but I think it's a 345 line that runs through South Texas, goes down to the valley. What percentage of properties did y'all negotiate something on versus what percentage of properties did y'all condemn?
Thank you, Mr. Gann. Related to this is a lower Rio Grande Valley 345 kV transmission project that, of course, goes through South Texas. We have evaluated every property owner, and 95% of the properties in which we engaged, we were able to reach an agreement with the property owner. Only approximately 5% of all the landowners that we engaged with did we have to go into a process of condemnation, remnant domain. But I think this is a testament to the fact that we seek to work with landowners once a route is selected and once we get to siting where we actually do see the details of the project. But that is an example of a 345 kV project with landowner engagement, negotiation, and as we always seek settlement. I do also want to highlight that 345 kV transmission line will be at its capacity once it is energized.
And so that 95% ratio, is that pretty indicative of other projects you've had in the past, or is every project very different? Do they vary significantly, or?
They can vary, of course, depending on what area of the state we are engaged with. We wanted to make sure that we were able to look at the most recent engagement that we've had, and there are a series of lines that we do have and property owners that we engaged with related to the project that you are discussing.
Thank you.
Thank you, sir.
Mr. Raymond.
Thank you, Chairman. Let me, well, actually, let me start real quick with Ms. Jolly. What I was asking a while ago was whether there had been a lot of complaints, you know, or objections, or what, I guess complaints would be the right term, on when the 345s were being built. And I think what Chairman Gleason testified is that not a lot compared to what you have right now. And I think he also said that maybe part of it may have been that we've given them such a short timeline, which I think maybe Chairman Guillen's kind of referencing as well. So is that your experience too, that there weren't a whole lot of complaints in comparison to what's going on now, or were there a lot and he didn't know about it?
Historically, with
Say
the
your name.
CCNs.
Say your name.
Apologies. Emily Jolly with LCRA. Thank you. Representative Raymond, the experience I've had working with LCRA, which I've been doing CCNs with that utility for about 15 years, every single one of those has been a contested proceeding. And so we've had interveners, we've had objections, we've had people contest the application, put in their own evidence and testimony, and object to the routing, you know, proposals that we brought forward. That's the process in every case.
I understand that the process, but are you familiar with the volume of complaints and objections and so forth that are going on now? I was just asking for the comparison.
It's not unique to the 765 dockets in my experience.
So you've had a lot of, you've seen where a lot of people objected?
We operate in Central Texas, in areas that are fairly heavily populated, and in areas of the state with a tremendous number of natural resources. So we have experience seeing these kinds of objections, seeing these kinds of procedural complaints, and work through them with landowners successfully.
Thank you. Mr. Taylor, you're Encore, right?
Yes, sir.
Say your name.
Jaron Taylor for Encore.
So did you hear me ask this other lady that was here a while ago, a witness, about this handout she gave us?
I did. I haven't seen the handout, but I heard the question.
Well, yeah, so it says on here, and she said it was well, it says here, according to the Public Policy Foundation. So they're saying that the cost would be $80 to $100 billion, and then she said lifetime, and I said who's lifetime? So what do you know about those numbers?
So that $100 billion number was put out by TPPF, and as with many of the reporting items they've done on this topic, I think there was far more interest in having a catchy headline than there was in accuracy of their math. That number is grossly exaggerated, and bluntly kind of misleading, as it only looks at the cost and ignores all of the benefits that come from these projects. What they've done to arrive at that number is they've taken the $13 billion for the Permian project. They've then added on all the 2024 RTP projects, which include the STEP plan and a bunch of 345 kV build. They've then taken ROEs that are higher than any utility in the state of Texas has, and they've assumed extreme O&M costs that are much larger than any state in the utility any utility in the state of Texas has, and they've compounded those over decades and decades. And even more important, I think, than the inaccuracy of that math to arrive at that number is the fact that they haven't talked about any of the benefits that come from those transmission line projects. As you heard Mr. Rickerson sit up here a little while ago and say, there's $300 million in annual congestion costs alone that come from just the Permian Basin projects. That's not including all of those other projects. You also have the simple benefit of reliability. What is the economic impact of not being able to reliably serve the Permian Basin and the oil and gas industry? I don't know that number. The panel that's going to come up after us has Texoga and several Permian producers on it. I would recommend you ask them that question of that impact. And then most importantly, I think today in ERCOT, we serve 90 gigs of load. The plan and the infrastructure that goes into that TPPF number, that's about $30 billion in actual costs, allows us to serve up near 150 gigs of load. In the state of Texas, load pays for transmission. So as we bring on 60 gigs of additional load, we have that many more payors into the system. Right now, based on the guidance from the legislature last session in SB 6, the PUC is completely reworking the way cost allocation works in this state. Data centers, pursuant to Governor Abbott's letter, as well as the direction that they received from you all through SB 6, are substantially going to pay a larger portion of the wires charges. When you take that reallocation of those costs together with 60 gigs of actual load, that's where you get the benefit. We have far more payors into the system that brings down the individual responsibility that all of us pay at our houses on wires charges.
So let me ask you a couple more things. From your vantage point, what are the complaints? What drives the complaints? Is it the voltage of the line or the location, the geography? What is it split or what? How would you say?
It's a good question. We've been involved in a lot of these cases over the years. In my personal opinion, I think this is where Ms. Jolly was going with this question is, I think the geography has far more to do with the complaints than the voltage of the line. If we were to have, if the PUC 2 years ago had approved 345 and not 765, we would be building transmission lines through the exact same geography. And I think we would hear many of the exact same complaints about the 345 kV routing, as the actual difference in the footprint is minuscule. It's not nothing. It's 50 feet in total between a 160-foot right-of-way and a 200-foot right-of-way, but we would be routing 3 times the number of lines.
Right. So let me ask you, did you listen, I'm sure you did listen to Chairman Gleason a little earlier. You know, one of the things that he talked about, I think, was having the TDUs work with landowners in the siting process. Actually, I think he was pretty, definitive about it. He said we won't. Didn't he say we won't split them up? If there's a, I'm looking at my notes here, bisecting a landowner's property. Do you hear him say that?
I did.
So is that a new requirement, or is that something said on the fly here? Or I should have asked him.
That's authority that he can grant us through his final order. He has the authority to grant what are called minor route modifications, is how I would refer to those. That's how they're referred to commonly in a PUC final order. And he lays out that authority that we will have as utilities to work with landowners once a route is approved to make those type of modifications. For example, from moving from the middle of a property to the external boundary of a property, things like that.
Let me ask you one more this one is one of my constituents that's watching online. Hello. Sent me, I hope you don't mind, but they ask, how does batch zero objective criteria account for a project's ability to utilize existing transmission infrastructure and rights of way?
So we haven't seen the transmission plan yet for batch 0, so that's step 1. But what we have seen is in both the Permian and the step plan, a large desire to utilize and rebuild existing infrastructure. The problem we have with that today is those existing 345 kV lines that are the backbone of our ability to transfer are so constrained we can no longer take them out of service. That takes the rebuilding of those lines and makes them substantially more expensive than it would be if we were able to take them out of service. And that just has to do with the fact that customers and residences are relying on those lines to receive their power. And so ERCOT can't grant us what's called a clearance to allow us to remove those lines so we can rebuild them. But it is absolutely a factor. And in fact, if you look at the Permian Basin Reliability Plan, they itemize each line that they looked at to be rebuilt as opposed to putting new transmission in.
Thank you. And Chairman, I was going to ask Mr. Rodriguez, AP, a question about, I think you said that Texas has grown by 6.5 million in what period of time, did you say?
It's used it from 2010, the 2010 census.
Okay, from then to now? I thought it was more. But this is about 765, but I'm going to throw it and hope he doesn't get mad at me. It's a very quick question. Do you know the 6.5 million additional people have meant a whole lot more power need, right? Generation.
Yes.
Right? Do you know how much of that has been driven by data centers that were built in that time from then to now?
Not specifically for that period of time. I would note, however, Representative, that what we are building, the 765 kV transmission lines, especially those that are pending to the Permian right now, were preceding much of the data center conversation that we are having today. So the tradition, that's when I mentioned that what we have considered traditional Texas business, oil and gas, that has been the basis of what is driving much of our need for transmission and the ability to be able to interconnect not just the load that we have there, but obviously as the market signal is sent, the generation that will be built across the state and in order to bring it to where
Yeah, so
it's
actually
needed.
the last charge I asked that question, which is I said, if we don't build one more data center from today forward, your opinion is we still need this power. We need these new lines, transmission.
Yes, sir.
Yeah, thank you.
Mr. Darby.
Thank you, Mr. Chairman. I think it's Encore. The Erath County judge has given us information regarding segment 8 in Erath County. Is that yours, Jerry?
Yes, sir.
Okay. Can you add to the narrative? He's saying that this was added after the public hearing and that there was no public meeting on this route and the affected landowners were not engaged in the discussion. Can you give this committee any background information on that?
Sure. Jaron Taylor for Encore. We need to distinguish between two things to have this conversation. There are public meetings that are required by rule to be held before an application can be filed. That is Rule 2252 of the PUC's procedural rules. That requires that one public meeting be held before a CCN application can be filed. That's a public meeting. The separate and apart from that is a public hearing. That is the actual hearing that would happen. The gentleman who was sitting right here was the chief judge of SOAH. That is the hearing that would happen at the State Office of Administrative Hearing. These are two different things, and they happen at a different point in time. Link C8 that Judge Huckabee mentioned was not present at the time that case went to public meetings. As I think actually I sat down in your office looking at these maps at one time. These maps are preliminary in nature. They are our first draft of routes. And after we put these out and we hold these public meetings, we go back to work and we add links, we modify links to try and bring forward an application that can be filed. That link that he was referring to, I think it was C8, was one that was added after the public meeting, but before the formal application was filed and before the public hearing was held.
Was there opportunity for the landowner, enough notice for the landowner to have due process and the ability to participate in that particular segment in his response to the PUC?
So they are provided the same notice at the filing of the application as every other landowner who is, under the PUC's rules, quote, directly affected. And that is, they are noticed at the time the application is filed. I am fully aware that many folks will feel that that was an insufficient amount of time, but that is the time provided under the rules from that notice and for the deadline that the legislature has established for these projects.
If you recall, we've also talked many times about routing.
Yes, sir.
We're hearing a lot of information provided by the Friends of the San Saba and others. This committee, this bill author, this chairman, and this whole committee spent a lot of time trying to keep infrastructure out of flooding river valleys. And so tell me how, and this letter was delivered to you nearly a year ago. So tell me how you have approached the idea of adding additional infrastructure into river valleys that are subject to flooding.
So the project you're referring to is a joint project we have with LCRA that is coming through that San Saba area. We've addressed it a couple of different ways over the year. Number one, we have tried to locate links that, first of all, we have to cross that valley. It is between the two endpoints for the project and that river in particular.
Start over again. You have to cross that river, you're saying, because of the starting point?
Yes, sir.
I mean, why is the starting point the starting point?
Because of the electrical connections, if you look at where these routes, where these projects start and end from, they start and end at large nodes on the transmission system, where there is a lot of
existing nodes?
Yes, sir, existing infrastructure. So those are our starting and our ending points. Between those 2 points, in your example, is the San Saba River, which is kind of coming south and west through our study area and is directly between the 2 points. So we have to cross it at some point. How have we attempted to minimize the impacts of that crossing? We have done that, one, by providing many options. I forget the exact number, but I want to say there's 4, do you remember off the top of your head? 4 to 5 separate crossings that we have provided as options for the Public Utility Commission of Texas. And I probably should have mentioned that earlier. Our job as utilities is to provide the PUC with options, not to pick the route. We provide them options. So we've provided 4 or 5 different ways to cross it. 2, we've tried to locate those in areas where we can have the actual transmission line structure set significantly back from the river. So if we have to cross over the river, the only thing that has to be in proximity to the river is the actual conductor that will go over the top. The 765 kV tower that we've designed together with LCRA has a 1,400 to 1,500 foot span, meaning we can be essentially 700 feet back from the river on both sides, depending on the width of the river, obviously, to avoid being in that floodplain. And third, to try and route in areas where there is already some crossing or disturbance of the river. So those 3 primarily.
Okay, and I pulled back your letter recently of August the 12th, and your final point, and there's been a lot of discussion about delay, postponement. Tell us, committee, again, go over if these 765 kV transmission applications are either postponed or delayed, what effect would that have on ERCOT's long-term planning, transmission, and ability to forecast load growth and other aspects? Tell us about the impact of that, because that's what a lot of people are asking.
That's right. And happy to, just to be clear, your letter you're referring to, this is the ERCOT letter to Representative Guerin from the August 12th.
That's correct.
Okay, just making sure. So if you look at the last page of this letter in ERCOT's response, they talk about, and this is where I use the analogy of a Jenga game. We've all played it. You can pull out a block and hopefully keep your tower standing. When ERCOT does transmission planning, they are building in layers like this. They have fundamental topology assumptions that are the basis of every study that happens thereafter. These cases, the 765 kV Permian plan, as well as the 345 kV, the 765 kV that is part of the STEP plan, as well as the 345 kV. These are base assumptions that have been integrated into every study that has been done since that time. And so the ramification that Woody goes into, Mr. Rickerson, in his letter, talks about the fact that all of those studies become invalidated if those base assumptions change.
you talked about 58 regional planning group transmission projects that incorporated the underlying base assumptions. So when we're talking about delay, we're not just talking about till the legislature meets next in January of this next year. We're talking about a process that, talk us through the practical effects of that and what it would cost and what it would delay.
So there are several loads that are looking to interconnect to the system who would functionally not be able to do so. That is step one. Two, our ability as TSPs, and I'll speak for Oncor directly, we have construction schedules set up with contractors to get these things built by the in-service deadlines that ERCOT has requested and modeled as necessary. We lose that ability if there are months and months and months of delay. That's just a practical reality of the construction segmenting. And then the third, and frankly, I'd refer you again to the panel after us on the delay if the Permian Basin is unable to have its load met. They're the best folks to answer that ramification.
I intend to ask those questions.
I imagine you do.
But just from your standpoint, with your companies that have, talk about your forward purchasing of equipment in relation to that, you're a regulated industry and your costs are going to be recovered plus a rate of return. And so I presume there are embedded costs of pre-ordering a lot of this equipment based upon the assumption that these CCNs are going to proceed according to the timeline that you're currently operating under. Talk about the costs that ratepayers, your company's going to be expending and ratepayers are going to have to ultimately pay. Talk about that from each of your company's standpoint.
So, do you want to go first? I'll go first. From an Oncor electric standpoint, I can tell you that yes, your assumption is absolutely correct. Just for example, in the stations, if we talk auto transformers and we talk breakers, these are extremely long lead time material. We had to order those 3 to 4 years ago to get bays and slots secured to be able to receive that equipment. In fact, the PUC required, as part of their decision to go and approve 765, they required us to have letters from the actual vendors that we would be procuring this material from, both for compliance with Lone Star Infrastructure Protection Act, but more importantly, to be sure we could get the equipment we said we could get in the timeline necessary to get it energized. So yes, we absolutely are on the hook for those facilities. They have been ordered and those deliveries are scheduled at this point.
Mr. Darby, specific to AEP Texas, one thing that we do is sometimes purchase slots, meaning that we're not necessarily taking ownership of the specific item, but we have purchased at least a place in line. If we lose our place in those lines, given the 765 kV transmission line build that is occurring in other grids in this country, there is a high demand for these slots. We have the potential to lose those slots, or that equipment could then be utilized for another part of the country. When Texas then, if Texas were then to decide to move forward, we would then have to repurchase some of those slots or that equipment. Of course, with the current demand that the country is facing for transmission build, those would likely be at a higher cost than we were able to originally procure those.
Thank you. Emily Jolly for LCRA. We'll do everything we can to minimize the costs that won't be recoverable in the event that the PUC does not move forward with these cases. But as we sit here today, we're in at about $92 million for equipment.
Jonathan Tigrina with CPS Energy. I think I share the similar sentiment, right? The ability to lock in the long lead procurement items is a real risk. And so every month that you are delayed, you run the risk of not being a recipient of that particular slot of the piece of equipment. But similar, we will do everything in our power to mitigate our costs and not expose customers from those costs. But those are the risks that are real if delays continue for evergreen.
Thank you, Mr. Chairman.
Ms. T, did you have a question? You're next on my list.
Most of my questions have been answered, but let me, Mr. Taylor, how far behind are we?
On the construction schedule?
Yes.
The first two Encore cases that were filed. I think one is about 45 days behind, and ma'am, off the top of my head, so please forgive me if I'm off by a couple. And the last, if we were on schedule, the last of the 765 kV cases would be approved in kind of right at the end of September, I believe, is its timeline. And that last case is waiting on a PFD from SOAH right now, so we don't know exactly how far behind it is.
Thank you. Thank you.
Mr. McQueenie.
Thank you, Mr. Chairman. I just want to make a statement, and I'll let you guys address it, but the biggest complaint that I get from my constituents is a function of y'all's land departments doing a poor job. And in particular, there's more complaints about one of the companies represented than the others, but the complaints we hear are about land departments not treating people with respect, and with land departments conflicting out appropriate representation by putting attorneys on retainers, so that there's not somebody that eminent domain-wise can go represent somebody to have a good, constructive conversation with you. So I just want to put that on record so that you guys are aware of what I'm hearing from my constituents, and that we need to, if founded, we're going to have some problems, okay? We just need to make sure that you guys address that, okay? I think that's all I've got.
Mr. Turner.
Thank you, Mr. Chairman. I have a few questions. One, just to follow up briefly on Representative Raymond was asking about, in light of Commissioner Gleason's earlier testimony that during the PUC's review of these routes, that he and his staff are going to endeavor to avoid routes that bisect a landowner's property and that type of thing. And since this could apply to all of you, but I'll ask Mr. Taylor, because most of the public testimony we've heard today involves Encore proposed routes. Based on what Mr. Gleason said, is that possible? I mean, can Encore, any of you, go back and move those routes to where the lines would ultimately run along a property boundary as opposed to cutting through the middle of a property? Is that something feasible for y'all to be able to actually do?
At times, yes, at times, no. And if you'll permit me to explain a little bit.
Please.
On larger properties, that is an easier thing to accomplish. I will tell you that as we move, the routing requirements at the Public Utility Commission of Texas ask us to do many things which are commonly inconsistent. For example, we are asked to parallel roadways. As we parallel roadways, we come in to closer proximity to homes commonly, especially in rural areas where homes are built off of county roads. As we parallel existing pipelines, as we parallel existing infrastructure, as we parallel existing transmission lines, we're commonly not following proper lines, we're paralleling something. And really, if you zoom out and look at our routing overall, what you will see is we are paralleling something, and then we are getting from one opportunity to parallel to a separate opportunity to parallel. And it is in that spot where we are transitioning from paralleling this to trying to get to that where we are bisecting properties. And so, yes, at times, the answer to your question will be we will be able to accomplish that, but I would be disingenuous if I told you we would be able to do it in all situations.
Okay, I appreciate that candor. Shifting gears a little bit, I think we've heard from a lot of stakeholders, but I don't want to presume that this is y'all's position, but I think we've heard from a lot of people that the 180-day period has not been sufficient for a process of this complexity. And I voted for the bill. I'll vote for most of Mr. Guerin's bills. And, but I think in hindsight, as we look at this, like maybe this needs more time. Do y'all share that viewpoint that this should, for these types of cases, this should go back to a 1-year time frame?
I'll speak for Encore. I assume each of the utilities will have an opinion on this. We've processed a lot of cases in the state of Texas on a 180-day time frame. The entirety of the CREZ cases, which were 30-plus cases, were processed on a 180-day time frame. Critical reliability projects for the last 2 decades have been done on a 180-day time frame. It absolutely can be done. Does additional time allow more process? It absolutely does. Do I think that can be of benefit if the legislature views that time as well spent on that process? Then absolutely we do. And Representative Darby and I have spoke about this a couple of times over the years, but there are a large number of cases that can be processed on 180 days without issue. We have several of those that are happening right now. On some of these larger cases, it may be perfectly appropriate and we would have no opposition to additional time being provided. Is it a year? Is it 9 months? I think that's really up to you and your colleagues.
Okay.
Mr. Turner, yes, we were willing to work with the legislature for a time frame that the state views and that we can view for very large, significant, lengthy projects that impact a substantial number of landowners in a longer time frame. As Mr. Taylor notes, there are some that we can do in a shorter period of time, and if the state gives us guidance on those, we will follow those. But as it pertains to even to our current cases that are pending, if the legislature or the PUC deems that some more public comment is necessary, we understand that that may be the opportunity for additional landowners to be heard, recognizing that once a route is chosen, we can then really get down to the details of the specific route at issue.
Great.
Thank you. Emily Jolly for LCRA. As I mentioned earlier, every case is different. Every case presents its own challenges. I think one of the proposals that we've talked with the commission staff about in terms of making recommendations to improve this process is really looking not just at the voltage or the geography, but the number of noticed landowners. Because when you're in more suburban areas, more densely populated areas, you're going to have a lot of interveners, even if it's not a long line or a line that crosses 10 or 15 or 20 counties. And so we think that's a good metric to help guide that conversation and result in some recommendations for this body.
Jonathan Tejerina with CPS Energy. I think I share a lot of the same comments here. At the end of the day, we want to be good actors, right? These are our neighbors, these are our communities, these are our customers. And so whatever the future recommendations end up looking like, we will work to fulfill them. And I do think we will be responsive to whatever the legislator ultimately decides from an appropriate time period, because we do also agree that the process has worked in certain situations for the ability to build transmission in Texas. And so at the end of the day, we want to ensure that we are just working as swiftly as we can to ensure reliability. I think it's worth noting, at least from a CPS Energy standpoint, we are a vertically integrated utility. So for us, we are a generator, we are a TDSP, and we are the retailer. And so for us, all of these tools are needed, right, to ensure the broader reliability and affordability for power delivery here in Texas. And so we want to do what our part will be as well.
Okay. So I think the common theme, what I'm hearing from all of you, is maybe consider a threshold for projects, whether that's the length of the project in miles, or the number of property owners affected, or the dollar value of the project, but some sort of threshold that maybe has a longer time period for vetting.
Yes.
Is that a fair summation? Okay.
All right.
Then a couple more real quickly.
You hadn't done anything quickly all day.
It's
We've
gonna be quick,
got 5
Mr.
more questions, and I'm about to move to public testimony. I'm serious. We've got to move on, so please.
Okay. Yes, Mr. Chairman. With respect to Chairman Gleason's comment earlier, when I asked him about what happens if the PUC does not act on the CCN at the conclusion of 180 days, he said the statute allows for parties to seek relief in court, basically. But that they're going to try to do the best, but it may go beyond 180 days. For all those of you who that could impact, is your position to give the commission some grace on that so they have the time to do what they need to do?
Yes.
Yes.
Okay. Everyone was a yes? Okay. Yeah. Very, very good. Okay. And then, promise, last question, Mr. Chairman. Mr. Darby asked you about the forward costs you've already incurred. I think, Ms. Jolly, you said $92 million for LCRA. When will y'all file with the commission to be able to begin recovering those costs?
Emily Jolly, LCRA, not until the projects are in service and used and useful. So we're looking at probably 2031, given the expected in-service date on the current schedule of end of 2030.
Thank you.
Adrian Rodriguez, AEP Texas. That also applies to us. Projects will need to be used and useful before, and that's consistent with the language of the statute and the rules of the commission in order for us to seek recovery of the costs.
Okay. Same. Okay, great. Thank you, Mr. Chairman.
Mr. Garrett.
Thank you, Mr. Chairman. Since it's my bill that's getting talked about quite a bit, when this was brought to me, the 180 days was suggested, and it was suggested based on the Permian Basin Plan, not y'all deciding that we've got to run lines all the way across the state. So that's where the 180 days came from. And I agree, I think we need to relook at that. Jared, when you said that y'all took back to the PUC different places to cross the river,
Yes.
Is that public? Has the public been able to see that? Because that's a whole lot of the people that are sitting back here is how it's going to affect that river and the land around it. But is that information, after you gave it to the PUC, is that available where these different crossings may be as opposed to where the first straight line came across?
Yes, sir. They're in our maps that are part of the record in these cases. And they were the main issues at the public utility, at the hearing that happened in SOAH here in Austin 2 months ago, I want to say.
Okay,
maybe
but
3.
it is available to anybody that wants to pull it up on y'all's website, is that right?
Yes, sir.
Okay, thank you for the clarification. Thank you, Mr. Chairman.
Mr. Guillen.
Thank you, Mr. Chairman. I want to go back to what we talked about you having settled 95% of the previous project and 5% being condemned. I want to explore a little bit more with this 95% part. Is there, because I'm not familiar with this process, I haven't gone through it myself, but for folks who go through this process, is there a portion of this 95% that ended up settling that, may have felt like they were in a position where they had to settle and they were cornered and they didn't have a choice?
Mr. Guillen, I don't know the specifics of every one of those. I can tell you that there were some people, and by the way, I do have the specific numbers here. Out of 338 properties, 315 reached resolution. So I'm sorry if I didn't do the division correctly on that. So out of 338, 315 were settled. I certainly hope, and it is my expectation, that people do not feel that way. But I completely understand and recognize that knowing, and as was mentioned in public comment earlier, that is an avenue that is available in this state, that some people may place that into their calculus and decisions as to whether or not they settle or not. So while I certainly wish and hope and would like to expect that every one of the people that we come to an agreement with feels that way, and while we do, we have some people that do want it on their property because their property is not income producing, and so they actually seek to have the line on their property. As a realistic perspective is that maybe some people put that into their calculus.
So when you settle these cases and/or you're compensating these landowners, are you giving them fair market value for the property that was taken or for the property that's being used, or are you also giving them or compensating them for damages that they may incur because you now have a big, power line running nearby the property that they're going to continue to have, and the decline in value that they might experience? Can you explore that with me?
Absolutely. It's a case-by-case basis. And the reason I say that is that there are some property owners who seek just an appraised value for that use of the property. So it's essentially, they still get to utilize, let's say, the grazing in some areas, or their land, they still have access to the property underneath. So it is a minimal amount of impact to their property, and they are fine taking what that appraised impact is. Other parties either seek to wait until their other neighbors come to an agreement and then calculate an estimate based on their neighbors. So in each of these circumstances, and in some cases, we do have counsel who defends individuals. They get an attorney very early on who's versed in eminent domain law, and that counsel advises them throughout the process, in which case it then becomes the utility lawyer or outside counsel with their counsel to negotiate an amount.
So let's talk about the ones that you had to condemn. and then you're going to compensate them for having condemned the property. Are you then, at that point, giving them fair market value only for what was taken, or does it also contain a portion for damages that it might have brought to property that you're not taking but is adjoining the property?
The result of that is from the condemnation commission, and in some cases, if that commission order is then appealed from the court that oversees it. In some cases, they will, the condemnation commissioners have given an award that is consistent with the appraised value. In other cases, they have given an award that is higher than the appraised value, calculating in a number of other factors that are presented to that commission. And in order to go through that process, we pay what the commission or the court, if it is appealed, finally order.
Thank you.
Okay. Okay. Jeremy, one final question. You said in testimony that you only give recommendations to PUC. Representative Kerwin would really like to know, do you only give recommendation, or do you only give options, or do you actually recommend one option over another?
Our job is to provide options. Their rules require us to define what is a best meets route, the route that best meets the criteria from the Public Utility Commission of Texas. So we are required, sorry.
I guess, just make it quick. So when PC asks you, which one do you like better? You say, I don't like any of them better.
If you were to read our testimony, you would say, Route 559, for example, is the utility's best meets route, and we are happy to build any route the commission approves.
Okay. All right. Anybody else got a question? Nope. See y'all later. All right. Chair calls Vanessa Halford, Eric Allman. Is it Sidra Hansen? Vanessa? Vanessa? Record shows you're Vanessa Halford. You are here representing yourself.
Mm-hmm.
You have 2 minutes. Go
All
ahead.
right, thank you. My name is Vanessa Halford, and I am the founder and executive director of White Horse Christian Academy in Stephenville, Texas, which is built on my family land right there, right next to my house. The C3 line runs right directly through in between my house and the school. After months of completing mounds of paperwork and trying to navigate this process, I'm here to ask you to stop the construction of the proposed 765 power lines until the process can be properly reviewed. Let me be clear. Texas needs a reliable and sustainable power grid, but transporting electricity from one part of the state to another does not by itself solve our underlying problem. We need to take care and develop a comprehensive plan for how we're going to create a more reliable energy program for our Texas's growing needs. Instead, we look like we're moving forward to a massive transmission plan that could ultimately cost Texans nearly $100 billion over its lifetime. But who pays that price? Texas families will pay, landowners will pay, ranchers will pay, businesses will pay, and schools like White Horse Christian Academy may pay with property, opportunity, and potentially our ability to remain where we have invested so much. White Horse Christian Academy is one of the entities that could suffer from what I believe are flawed and unjust routing decisions made by Oncor. Oncor relied on maps and imagery dating back to 2022 when proposing routes through property belonging to schools, families, and businesses. Our new 4.7 million, 19,000 square foot school building wasn't on the map. How can you accurately determine the impact of a proposed power line when the maps being used don't accurately represent what is actually on the ground? I'm asking you not to simply put a Band-Aid on Texas energy problems. I'm asking you to slow down, look at the entire picture, and develop a plan that creates more energy while protecting the Texans who are being asked to sacrifice their property to support it.
Thank you. Thank you for your
Thank
testimony.
you.
You bet. Next, I've got Eric Allman.
Yes, good afternoon, Chairman King and committee. Thank you for having me here to speak. My name is Eric Allman. I'm here on behalf of the Hill Country Preservation Coalition, and the Devils River Conservancy. Hill Country Preservation Coalition seeks to protect the Edwards Aquifer, the Medina, Sabinal, Frio, Devils, and Pecos River watersheds, all of which are crossed by the Howard Solstice line. And I will note, includes within its membership 50,000 Texas landowners, many of which have their property crossed by that proposed line. Devils River Conservancy seeks to conserve the Devils River. There are two different lines that would cross that watershed. I'll note our law firm has practiced representing landowners in contested case hearings on environmental matters for 45 years in the state of Texas. And this is the most burdensome, difficult hearing process that we have experienced in that more than 4 decades of experience. I don't want this to come across as merely a matter where you have citizens who are sucked into a process and it's difficult for lack of familiarity. There were two particular problems here, one of them somewhat substantive and the other more procedural. Substantively, the question of need was really not addressed in terms of the need for these particular lines at this point in time, as would be appropriate. It was rather assumed based on the Permian Basin Reliability Plan, which was completed 2 years ago. In addition, the procedures did not treat private property with respect. And I know we've heard a lot about expediency and how the urgency and the need to do these. This is the state of Texas. We treat private property rights with respect. This was not a process that was respectful of private property rights. 2 weeks after the deadline to intervene, there was a deadline to file a statement of position or pre-file testimony. In our case, there were more than 200 interveners pro se who did not file a statement of position. They had filed to intervene. They'd expressed their position once, but for that paperwork mistake, they suffered the death penalty. They were thrown out of the case. That is not respectful treatment of those private property owners. Those who stayed in the case had 1 week after then to file pre-file testimony in response to the others, who many of which may have said, well, the line should go across that property. Then we had a 4-day hearing on the merits. We did in 4 days what the judges said a federal court would do in 4 months. Thank you for your time.
Thank you. Thank you for your testimony. Next, I've got Sidra Hansen. I'm sorry I didn't do this with you, Eric, but you did a good job identifying yourself. I've got you shown representing Hill Country Preservation Coalition and Devils River Conservatory. Sidra will go with you. Is that accurate? Thanks.
It is. Thank you. Good afternoon. My name is Sidra Hansen, and my firm represents the Hill Country Preservation Coalition, or HCPC, in the proceedings for the Howard to Solstice transmission line. HCPC is a grassroots coalition of private landowners and conservation groups dedicated to preserving the Hill Country, including the Edwards Aquifer, as well as regions such as the Medina, Sabinal, Frio, Nueces, Devils, and Pecos River watersheds. The Hill Country's springs, aquifers, wildlife habitat, and other natural resources are ecologically sensitive and biologically diverse, and its karst water systems are particularly vulnerable to groundwater contamination. The Devils River is widely recognized as one of the most ecologically intact rivers in Texas and one of the most pristine spring-fed river systems in the southwestern United States. This proceeding has drawn extraordinary public interest. There were more than 700 protests filed in the docket. By the time of the hearing, there were approximately 230 interveners. The record includes approximately 400 admitted exhibits from 80 parties, along with testimony from 147 witnesses. However, many affected landowners reported receiving notice only shortly before the deadline to intervene. Interveners then had approximately 2 weeks to prepare and file their direct cases. Before the hearing began, 280 interveners, approximately 55% of those who initially successfully intervened, were dismissed for not filing their testimony or position statements in time. The Commission's certification process not only provides for, but relies on, meaningful public participation. These numbers tell an important story. The statutory 180-day timeline did not give the public enough time to understand the process, evaluate the proposed routes, and participate fully and effectively. Thank you.
Thank you for testimony. Members, do we have any questions for this panel? Chairman Darby.
Was that question for me? Yes, my role at the legislature is usually to take care of the kids while she's up here working the legislature. Today, I'm the one up here. Thank you, sir. Thank you.
Thank you. Thank you all very much. Next, Chair calls Myra Alvarez. Marie Lucio and Mark Freischahan. Mr. Mark, I assume I messed that up, and I apologize.
You know, my mother put me in a dark room in the first grade with long-term measles, and she made me learn to spell my name. I just say, call me Smith, and I'll answer.
I'm going to call you Mr. Mark and let you pronounce it for us in a second. All right, we will start with Myra. Myra, record shows Myra Alvarez representing yourself. If that's accurate, please identify yourself and go ahead.
Yes, thank you. Again, Myra Alanis. I live in Nueces County, Texas. In listening to today's testimony, it is undisputed that the 765 is primarily needed for the data centers and large industries that need large connections. These industries are coming to Texas because of tax incentives that are available, but these incentives come at a cost. They're paid by the Texas families through higher utility, higher water bills, higher property taxes, and now a loss of our land. As a resident of Nueces County, we pay higher property taxes to cover revenue lost when industry freezes their valuations. One industry facility in my community has the same assessed value today as it had in 2019. Mine has gone up 250%. We pay billions to fund alternative water infrastructure built primarily, again, for industry. And now we're being asked to fund billions of dollars for new transmission lines. The burden doesn't stop there. When landowners receive notice of a proposed transmission route, they have fewer than 30 days to understand the complex process, evaluate their impact on their properties, and submit comments. And landowners who live just beyond the 500-foot notice radius may receive no notice at all, even though these lines will permanently alter their landscape and the future of their community. Large load customers should pay 100% of the infrastructure costs their demand creates, not pass that burden to Texas families. Texas families already subsidize private industrial growth with their tax dollars, their water bills, and their electric bills. Now they want our land too.
Thank you for your testimony. Next, we've got Marie Lucio. Marie, I've got you on the record showing that you are a concerned citizen of Robstown and Cal Allen.
Yes, sir.
Please proceed with your testimony.
Marie Lucio, please excuse me if I stumble a little because there was some questions that were brought up earlier that I thought should be addressed in my comment. I'm a part of a grassroots volunteer group fighting an ammonia plant, Nueces Green Ammonia, who sits between two communities, Robstown and Cal Allen. It recently got an endorsement from ERCOT for the 1,150 megawatts they need for power. This is one of 6 projects that's slated for our area. These 765s, right now, AEP has 2 proposed lines going down and ending in Driscoll, Texas, both of them. One is called the Howard Blue Lacy that goes from San Antonio down to Driscoll. The other one is the Hilgi Blue Lacy that goes from the Hilgi, Victoria area to Driscoll also. So along those lines, we can only guess that we will be getting more projects of this nature. So at whose expense? Water infrastructure paid by citizens, alternate water sources. As you know, we had a dire water issue in our area also. That's going to be paid by citizens. Drainage improvements paid by citizens. One thing that was asked earlier from TCEQ is if they actually enforce when wastewater discharge is discharged into the ditches. I could tell you that we had a report of a lithium battery plant that was recently built in our area, draining black or dark water into a ditch. TCEQ came, said that it was clear, there was, flowers and everything, and minnows or grass, I'm sorry, not flowers, grass and minnows. There was nothing wrong with it, case closed. The Drainage District took it upon themselves to do an independent water study, which found hexavalent chromium and lithium and bromium, among other things, in that drainage test.
Thank you for your testimony, ma'am.
Thank you.
Next, we've got Mark
Friesenhahn, sir.
Friesenhahn, thank you very much, representing yourself. Is that accurate?
That is correct.
Please proceed with your testimony.
Chairman King, committee members, Mark Friesenhahn, ditto on pecan farmer, landowner in Schleicher County and current PE license. Because of my landowner in Schleicher and Menard counties, I became an intervener in the power line process. In a nutshell, the PUC plan is illogical in our opinion, and we disagree pretty significantly with Encore and the other TSPs. The plan is to move natural gas to the east from Permian Basin, generate power, put $33 billion worth of power lines in place to move the power back to the Permian Basin. All the while, the Golden Triangle runs short or close to short on a routine basis. In summary, the needs determination for the project has not been conclusively determined as per statute. Landowners have been unfairly treated and left out in many cases with the accelerated 6-month review process. And finally, the Permian Basin demand balance doesn't add up. Where's the generation coming from to fill these lines, and how are those lines going to meet the demand? Even worse, we believe the power grid has boxed itself into a corner. Solar and wind appear to be about adequate to power the Permian Basin, but they only run 60% of the time. The dispatchable power needed is on the open market, and they can't afford power plants in the West with 40% runtime. And finally, power lines, on the other hand, are guaranteed 9 to 10% rate of return. I respectfully request, kind of a bottom line here, 5 things. Pause the PUC plans, address landowner concerns with the abbreviated timeline during the next session, reevaluate the need for the proposed 760 kV power lines, include power generation that's needed. We have an incomplete story here. We've talked only power lines. Encore has admitted that they do power lines, not power generation. Take legislative action to support dispatchable power in the Permian Basin and address immediately the apparent bottlenecks in the Permian Basin distribution system. That's a small project that can be done quickly.
Thank you very much.
Thank you very much.
Thank you for your testimony. Members, any questions for this panel? Thank you all very much. We're going to do one more public testimony panel. Let me call, Chair calls Ashley Goldbranson, Charlie Horner, or Hormer, I can't quite tell, and Kevin Kennedy. It looks like Charlie Horner. And then our next panel is the third invited panel, just so you guys can prepare yourself. How are you today?
Good. How are you?
Good. I'm going to assume you're Ashley,
Yes,
representing yourself.
Yes, sir.
Okay. Record shows Ashley Goldbranson representing yourself. You may proceed with your testimony.
Thank you. Thank you, Chairman and Committee, for the opportunity to speak today. My name is Ashley Goldbranson. I'm here today not to share about our lack of notice, how close these massive lines will be to our home, our business, our family, or how daunting this process has been as a pro se intervener. I could share about our story all day, but instead I'm here for others. In April, when we found out about this project, myself, my husband, and our closest neighbors decided to host a local meeting. My husband and these 2 neighbors went door to door, inviting people and informing them of what was coming. Most, if not all, had no idea. With a week of planning, we had over 150 people there. So today I decided to share a little bit for them. The widow, who I had not met before that day, that cried on my shoulder because her 5 acres was all she has left in the world, and a tower was planned to go right in the middle of it. For the family who sold everything to buy land and live out their dream. For the pastor who lost his church in a tornado and recently got it rebuilt. There are thousands of stories just like these. Each one of us in this room speaking today represents 100 more Texans. And I'm here today to ask you 2 things on behalf of myself and these people affected by these lines. First, I'm asking you to request the governor and PUC to pause this project and push it back to the legislature. And secondly, I'm asking you to call for reform on this entire process, not for the next project and the next group affected, but this one right now. While I can be a voice for many landowners, each of you have been elected by your fellow Texans and neighbors to amplify our voices. Texas history has a long list of brave men and women who did not back down or cower. those who stood up for Texas and what was right. Today, you are being given the chance to add your name to that very same list. May God bless your efforts, and may God bless Texas.
Thank you for your testimony. Chair calls Charlie Horner. I can read. It wasn't Horner, I'm sorry. It's Horner. Clearly
Yes, sir.
typed in here, but I was having a hard time reading my own
Yes, sir.
handwriting, so I apologize for that.
No, you're good.
Representing yourself, is that accurate?
Yes, sir.
Okay.
In my school, White Horse Christian Academy.
You give us the authority to update the record for that real quick.
Yes, sir.
Or, okay, we're going to just put you down as yourself.
That's
and
fine.
you can represent and tell us all about it.
Yes, sir.
Please proceed with your testimony.
Well, first, I'd like to thank the members of the House for allowing us to bring our concerns forward today. Thank you for your time. My name is Charlie Horner. I attend White Horse Christian Academy in Stephenville, Texas, the same school which Miss Vanessa Halford just is able to lead and was able to testify a little bit earlier. The proposed dinosaur longshore transmission line would cross directly over our campus. For years, our school has been raising funds to build a gym, multi-purpose building, and outdoor recreational fields on this part of our property. The route could significantly affect those plans. And it's not just our school. Within approximately a mile, major recent developments, including a steel mill, an industrial park, Atwoods, Amazon, Tractor Supply, Valero, and the Texas A&M AgriLife Research and Extension Center, all of which would be affected. All of which, except for the A&M Research Center, have been built within the past 3 years. An additional significant development is actively being constructed as we speak. I want to be clear, I'm not asking Texas to stop building transmission infrastructure. I believe our state needs reliable power. My concern is that the information being used to evaluate this route does not appear to fully reflect the development that exists on the ground today. That matters because the PUCT's routing process considers schools, commercial and industrial structures, existing development, and community impacts. So our request is simple. Update the mapping, field verify the current development around our school, and reevaluate the alternate routes using that information. We're not asking Texas to choose between reliable electricity in our communities. We're asking Texas to make sure a decision this important is based on accurate and current information. Thank you.
Thank you for your testimony. Chair calls Kevin Kennedy, representing yourself. Sir, is that accurate?
Yes, that's accurate.
Please begin your testimony. Thank you.
Okay, my name is Kevin Kennedy. I'm an affected property owner, and I'm going to tell you a few things about these Permian 765s that you may not know. Did you know that the TSPs failed to provide notification and opportunity for public meetings to owners of 3,500 properties in violation of PUC Rule 2252? Did you know that the 59315 ALJs stated that the PUC commissioners must either deny or delay 59315 in compliance with that same rule? Did you know that 1 week after the PUC approved the Permian 765 import paths, ERCOT submitted a good cause exemption to drastically reduce the TSP load forecast, stating the load would not materialize on the projected timeline? Did you know that import paths 2 and 3 do not have a reliable source of power on the eastern ends? Did you know that ERCOT determined that import path 2 is not needed until 2038? Did you know that ERCOT is now claiming that they changed their mind overnight, literally overnight, regarding the 2038 need issue? Did you know that the PUC rules require transmission companies to comply with the PUC Commission policy on prudent avoidance, but the Commission has no such policy? Did you know the transmission companies consider a deer camp travel trailer exactly equivalent to an elementary school with 500 little kids regarding exposure to electromagnetic fields? Did you know that DC transmission lines do not pose the same electromagnetic health risk that AC lines propose, which are in the Permian Basin Plan? Did you know that DC transmission lines can be placed underground and bored or tunneled under sensitive areas, but AC lines must be placed overhead? Did you know that every route through Burnett County bisects at least one family ranch dated into the 1800s? Did you know that the state of Texas relies on a clodhopper like me, and only me, to root out any and all issues with the CCN application? Did you know that my family came to Texas in the 1860s? I'm a recently retired professional engineer, and I'm really not a clodhopper. This is right up my alley.
Thank you. Thank you for your testimony. Members, any questions for this panel? Seeing none, thank you all very much. All right, the chair is going to call Walt Baum, CEO of Powering Texans, Katie Coleman from the Energy Council, Texas Association of Manufacturers, and the Texas Chemistry Council, Will McAdams, President and founder of McAdams Energy Group, Todd Staples, President of Texas Oil and Gas Association. As a reminder, before you begin, state your name and who you represent for the record. We are going to start with you, Mr. Baum.
Thank you. Thank you, Mr. Chairman, members. My name is Walt Baum, and I'm here today representing Powering Texans and Texans Competitive Power Advocates. We represent Texans' leading dispatchable power generators. There is a lot of new thermal generation being built. There's over 1,500 megawatts of gas generation that has come online since last summer. There's 4,000 megawatts of new gas generation that's currently being built through the TEF program that'll come online by 2029. But as you've heard today, we need more. But transmission and generation work together. It's not one or the other. Businesses and everyday Texans alike deserve certainty, affordability, and a market structure to facilitate that power. And we're confident that the current transmission build-out plans accomplish that. The need for the Permian project is well established. It was approved in April of 25, underwent 2 years of analysis and substantial public input. We are concerned that putting a halt to these projects will not only affect oil and gas operations, but it's going to affect new generation currently being built and threaten many planned projects. We do support future changes to transmission planning to improve transparency and address specific siting and landowner concerns that y'all have heard about today. You've earlier heard, and there's been a lot of talk about a TPPF study that threw out both that number, but also talks about prioritizing building localized generation in the Permian Basin. A reliable grid requires both adequate generation and an ability to transport that power where it's needed most. Localized generation being built without transmission can result in stranded assets, leaving the generators unable to make the money necessary to support, paying for those facilities. And if you force new generation into a market that's already saturated with existing plants, you can drive those existing gas plants out of the market at a time where we need even more generation. The current existing gas fleet in Texas is underutilized. We're currently operating at about 40 to 60% of our gas fleet's capacity on average, meaning we've got lots of existing steel in the ground to serve this new load. We just can't move the power around. And a lot of this will be, we can deliver, underutilized plants that are in East Texas into West Texas to help serve when there's not enough wind and solar. We do think building these new lines will help facilitate the full use of our dispatchable plants that are already connected to the grid. Without these, ERCOT's not going to be able to fully utilize the existing resources or effectively integrate new generation to meet the growing demand. New gas plants are being built in the Permian. We believe that these lines, when these lines are approved, we're going to see even more new gas plants built in the Permian, both expansion of existing plants and additional thermal. As investors know that those plants can be used to serve that area when the renewables can't produce the power, or can't, and then export that power during times when gas plants can't economically compete with renewables. Senate Bill 6 that y'all passed did give the tools to manage the few hours where the grid is tight while allowing the market to drive investment. The new loads coming online can absorb the renewable oversupply that we've had in the market due to the federal tax credits. and utilize the existing thermal. We need to allow the load growth to materialize so that the market can determine how much of that load can be used by the existing plants and where new plants are needed. And investors, not customers, should bear the risk of building the incremental generation in response to clear market signals that this new load will bring. We need certainty. We believe that these new lines will attract new thermal generation. You've seen and heard earlier, the gas queue in ERCOT is currently larger than it's been in years, as investors, rather than ratepayers, look to put their capital at risk. But we need certainty to be able to do that. So, thank you.
All right. Mr. Staples.
Thank you, Mr. Chairman, members of the committee. My name is Todd Staples. I'm president of the Texas Oil and Gas Association. Appreciate the chance to be with you today. Our members are closely aligned with your constituents and your consumers because we are consumers in this situation. West Texas is the epicenter of American energy security. Production has increased 430% in just a 10-year period from 2015 to 2025. These unmet needs have been well documented for a dozen years. And dating back to 2019, we have documents where ERCOT has done assessments specifically identifying the deficiencies of the need for transmission in West Texas and started contemplating solutions. And I think a lot of what we're experiencing today is because it hasn't been built out as it's been needed to. If you look at the roughly $14 billion price tag of the Permian Basin Reliability Plan, $4 to $5 billion is for just regional efforts, and the remaining part is for transmission lines. And if those had been built out over a 12-year period, it would just be under the radar screen, but we're seeing it all at once. And the reality is a pause on the clock only stops the solution. It doesn't stop the clock on the problem. And we all know that when you pause these solutions, it increases the cost when you ultimately get to it. Now, on the 765s, I want to tell you that my members did not choose those lines. In fact, when they were proposed, I sent that to my members and I said, look at this, because we're paying customers. We're ready to sign up and pay for this. We're going to pay for this load that we're signing up for. And we wanted the most effective, most efficient system that Texas could build. And our experts couldn't find a reason to oppose these because of the tremendous amount of demand that exists for the energy center of America. And we want to deliver on that. And reliability and affordability is the key that we measure all these decisions under, and we think that's what you look at as well. That's what customers expect, and we want to make certain that we're doing that. Now, our members want to be connected to the grid for the same reason that you want to be connected to the grid at your home. You want reliability, you want cost effectiveness, you want it to work when you need it, and that's what our members are asking for. We strongly believe the rights of private property owners should be protected. All the comments that are being heard today, we want regulators to take a look and a listen at and find ways to accommodate them. But I can tell you this, that I-35 was built, the Houston Ship Channel was built, DFW Airport was built, inconveniencing landowners, but because of the need for those projects that we all benefit from today, and we are going to benefit significantly from this project that is going to move all Texans forward and is going to meet the needs that we all experience. The reliability plan for this region was contemplated and passed long before data centers became a topic in this state. And it is needed separate and apart from the data center issue, and it is very important. And as Walt said, I just have to reiterate because it's so important, we need generation and transmission. If natural gas generation was a solution to this problem, I'd be leading the parade for that because my members produce 90% of the natural gas that's produced in the state. But it's simply an engineering and physical aspect that you have to move those electrons where they're needed, and this system will work.
We have never supported transmission unless there were customers to pay for it. We don't support transmission build-out just for the sake of building it out because of a generation type. We want to make certain that there's customers to pay for it. We're paying for what we're signed up for today. We're going to pay for our share of what we're using now, which there's 6 gigawatts of unmet demand that's ready to be signed up for, ready to be paid for, and we're ready to go and ready to do that. The Permian Basin Reliability Plan is not speculative. It is real demand with paying customers, and I appreciate your chance to visit today. Thank you.
Thank you, Mr. Staples. Katie Coleman.
Thank you, Chairman King and members. Katie Coleman. I'm here today for the Texas Association of Manufacturers and the Texas Chemistry Council. There's been clearly a lot of attention about how the 765 kV lines will benefit the oil and gas industry. I'm here primarily today for the rest of the state, customers who have large manufacturing facilities across ERCOT who will be paying for these costs, and to explain the impacts of backtracking on approved transmission projects for those companies. TAM represents more than 500 small and large manufacturers across the state in a wide range of industries from LNG to semiconductor fabrication, petrochemicals, aerospace, industrial gases, and pharmaceuticals, just to name a few. The Chemistry Council represents more than 65 companies who operate over 200 manufacturing and research facilities across the state. And of course, we have a big, heavy presence along the Gulf Coast and in the Houston Ship Channel, which is very far removed from West Texas. This is not about data centers. It's not about renewables. It is about our planning process systematically under-planning for industrial growth for more than 10 years. We are in a catch-up phase because of extreme restrictions that were put on forecasting of industrial growth. The utilities have been permitted to use econometric forecasts and other tools to project future residential and commercial growth, but that has been extremely restricted for large customers, and as a result, transmission needs of the business community have been systematically not met for 10 years. It's not just the Permian, it's across the state. And that's why you'll hear experts over and over say, even without data centers, these projects are needed, and that's because we are trying to catch up for the backlog of transmission that's needed to serve the industrial growth along with the growth in other sectors, residential, subdivisions, commercial growth, grocery stores. The state's growing and we need all of that transmission. Mr. Taylor referenced this earlier, but one of the things that may not be obvious is once transmission lines are approved through the ERCOT planning process, all subsequent studies that ERCOT does to interconnect any load or any generation are premised on the prior approval of those projects. So if you were to backtrack on approved projects now, including the Permian projects, you would be looking at potentially having to redo hundreds of load studies, hundreds of generation interconnection studies. So it's not just a matter of, looking at 765 versus 345 kV alternatives. Once you change the topology in that manner, you have to go all the way back through the process for all of those applications, and it would be extremely disruptive. You all know how many times I've sat here and told you about how my clients do not want to give the utilities more money if they don't need it. And we certainly don't want to pay them to build infrastructure that's not needed. We've been agnostic on the voltage, on the engineering specifics of the plan, but where we have been consistent is that we desperately need additional infrastructure to support business growth. And like Mr. Staples mentioned, when 765 was first proposed, I think we were among the biggest skeptics of that technology. We were concerned about introducing it in a time when we desperately needed this transmission, and any controversy could potentially cause delay. But after doing extensive scrutiny, after asking the commission to have private meetings with the utilities to look through their procurement plans and make sure that they could meet the timelines and execute on these projects, we finally got comfortable with it. And now that that decision has been made, there would be extreme consequences to backtracking on that. Finally, I did want to mention, again, Mr. Staples said this as well, but we have consistently opposed transmission that is meant to alleviate renewable export constraints. That's not what this is. If it were, we would be opposing it. The truth of the matter is when you add new transmission elements, everybody gets to use them. Dispatchable generators get to use them, renewable generators get to use them, loads get to use them. So anytime you build new facilities, yes, there will be renewable electrons that flow across those facilities. But to be clear, these lines were studied and are premised exclusively on serving load and not data center load. It is traditional manufacturing growth. And so with that, I'd be happy to take any questions.
Thank you, Katie. Will McAdams.
Thank you, Mr. Chairman, members. Appreciate the opportunity to testify today. My name is Will McAdams, and I'm here representing McAdams Energy Group. This is a full-service consulting firm focused on regulatory engagement and technical support for loads, I'll say energy consumers, for better understanding of the panel and the audience, to essentially achieve grid service in a constrained environment. As you know, I do represent companies before the legislature and am a registered lobbyist because I like to be able to talk to you legally. I am not here representing their interests today. I'm here as a resource to describe what we are seeing in terms of our technical assessment of infrastructure needs to serve our clients. As background, I also served as a commissioner for the Public Utility Commission immediately following Winter Storm Uri. I worked with many of you to enact reforms to help put the pieces back together and stabilize the system following 2021. We have heard a great deal today from witnesses affected by the CCNs crossing West Texas about what need means and process. These complaints heard by the witnesses are absolutely valid. The process needs work. It needs refinement. It always has. It's never going to be perfect. You got to pick between neighbors, landowners. It was the worst job I had at the PUC was to judge these routes. But you need to know certain factors to balance whatever decision you decide to make, you and the Senate, going into the next legislative session, and whatever you want the PUC to do over the coming months. First, the Public Utility Regulatory Act, Section 38.005, says that the Commission shall implement service quality and reliability standards relating to the delivery of electricity to retail customers by electric utilities and transmission and distribution utilities. It further requires that each electric utility, transmission and distribution utility, electric co-op, municipally owned utility, and generation provider shall be obligated to comply with any operational criteria duly established by the independent organization as defined by Section 39151. Just so you know, that's ERCOT. Boil that down in a nutshell, the utilities have a vested interest in complying with ERCOT studies, models, and plans that ensure reliability across the system. The 2024 RTP, the regional planning group plans that we've discussed in front of this committee, are all predicated on ERCOT's analysis to ensure reliability moving forward in a very dynamic environment. I'm going to walk you through, I think a picture's worth 1,000 words, and so I've given you a couple of slides to kind of walk through. The first thing that the PUC has to determine is need. And that's what ERCOT has been attempting to establish for the last, frankly, 6 years. They've been doing incremental analysis on West Texas, but now they have a more comprehensive vision on how the needs of Texas need to be served in an environment where load is growing, and it's growing exponentially. And it's just not concentrated in the large load segment. And that's what you see in the picture before you. Texas has always been a story of growth, and our energy demand is no exception. In 2023, just as a landmark for you to look at, our system peaked at 85.5 gigawatts. But looking ahead, ERCOT forecasts that by 2031, demand from traditional industrial and organic growth alone will push our peak to around 121 gigawatts. That's a staggering 40% increase over 5 to 6 years. That includes an exceptional amount of what we call native load growth. This is regular people in Houston, San Antonio, Austin, and DFW. Their energy needs have been growing leaps and bounds just by virtue of society's needs for greater electrification. This has brought stress on the system, and this has resulted, as you'll see in the next slide, in congestion. And Representative Darby did a heck of a good job earlier describing what congestion means. Another way I think about congestion is basically your your artery system, your cardiovascular system. And since batch zero has been frozen, I feel like I'm about to have a heart attack every day. But that's what congestion is. You will start to see price increases and bottlenecks of energy along the transmission network when it's overtaxed, where there's not enough power flow to get power from A to B. You'll see that first show up in high prices on one side versus low prices on the other, where a surplus of energy exists versus scarcity on the other side of the bottleneck. We see that in a big way across ERCOT, and we've seen it on elevated levels since 2020. And you remember what happened in 2020? We were coming out of COVID lockdowns. Then we hit it big time after Winter Storm Uri. Load took off like a rocket. The PUC saw that. We tried to take action immediately. We even ordered $2 billion worth of transmission down to the Rio Grande Valley. You'll see that in the next slide, which was an attempt to try to stay ahead or catch back up to a dearth of transmission infrastructure that really hadn't been enhanced since 2014 and 2015. On the third slide, you'll see basically a sort of snapshot window of time between the top 10 generic transmission constraints between 2021 and 2023. The top 10, as you'll see, were more regionally dispersed across the state. There's two of note. One is a little green dot south of San Antonio, and the other one is what we call the Wharton County GTC, south of Houston. These things are big-time GTCs. The one south of San Antonio forced us into EEA2 in 2023. ERCOT had to take extraordinary measures just to prevent load shed. So it shows you how critical and destabilizing these bottlenecks can become over time. Now, if you fast forward to today, 2024 and 2025, you'll see the concentration, all the top 10 are in West Texas, just west of Midland. It started out near Pecos, and it's grown east toward Midland, toward the urban center of West Texas. This is a major problem, not just for oil and gas, but it's the people of West Texas now. The old GTCs didn't disappear because we still haven't enhanced our transmission network. That's still to come with the 765s and the need for backbone infrastructure. But they are just dwarfed by now the critical nature of the stability issues resulting out in West Texas and the concentration of oil and gas load along with everything else. So as you move forward, I think it's important to know ERCOT's load is growing fast. It's across industrial segments. This factor of data centers is a misnomer. It's a red herring. It is just the cherry on top of the stack of demand that we have been building over the last 5 years. And that demand includes everything from everyday citizens like you and me to water treatment facilities, hospitals, LNG export terminals, legacy industries, advanced manufacturing, all of which provides thousands of jobs. And right now, because of the uncertainty around 765, all of that could be paused. And this is a race. The entire batch zero schedule, the entire Permian plan as a first step toward backbone systems across the state was predicated on trying to stay on schedule so that you don't have a reliability event. Now we're racing against that. So as you consider whatever reforms you need to make, the important factor is the schedule and staying on time. And you as a legislature, you certainly have a hierarchy of needs that you will factor in as you make this decision, just as the PUC would. First, we have an obligation to reliably and affordably meet the energy needs of the people of the state of Texas, not businesses, your citizens and voters. Then you look to supporting the needs of businesses who employ those people, give them the opportunity for a better life. And finally, we should attempt to integrate these loads that offer an enormous opportunity to help provide tax base and rate base to pay for the infrastructure that benefits all of us. And that's what's before you today. Happy to answer any questions.
Thank you very much. Before we go to questions, the next public testimony panel will consist of David Stedman, Holly Bachholt, and Terry Phillips. All right, questions. Oh, Mr. Anchia.
Thank you, Mr. Chairman. You know, I've heard a lot of valid criticisms of 765s on a procedural basis. Okay, I'm open to changes there. But the one criticism that I think we really need to wrestle with is need. Mr. McAdams, you and I have not always agreed and have had some pretty vigorous debates here. I am persuaded by your chart here that shows 9 gigawatts of native load growth, pardon me. And if I'm going to say back to you what I think I heard, maybe with some additional context, Texas has grown by 2.5 million people since 2020. We're slated to grow substantially more by 2031. We're really proud of that. We're proud that people are leaving other states, other places, and coming here. But we haven't kept up with that growth. We also have a moral obligation and a legal obligation to not let people die because they don't have electricity. It's pretty fundamental. So when you put in your chart here that native load growth, what we really are talking about is mom, is grandmother, is brothers and sisters, children, your family, right? Our Texas family. And to me, that's pretty persuasive. I was also noticing in a quick search, notes that the American Society of Civil Engineers gave Texas's overall infrastructure a C grade, but separately, ERCOT received a D- grade for transmission planning.
Right.
Due to rising demand. D-. So when I hear some of the testimony of the people up here saying, hey, we're way behind, Katie, we're way behind, that too is impressive to me. And finally, when you say that traditional industrial growth, and again, we're now the 8th largest economy in the world, we're going to be leapfrogging other countries ahead of us in economic activity. We're proud of that. We always sort of pound our chests on that. Traditional industrial load growth is going to be is going to increase by 26 gigawatts by 2031. So that is separate and apart from data centers. Am I to understand that correctly?
Yes, sir.
And for people to understand what 9 gigawatts is of load growth, I tried to look at city comparables. Los Angeles, City of Los Angeles is 6.5 gigawatts.
That's right.
New York City is 10 gigawatts. So we're going to add native load growth equivalent almost to a New York City. And that's before we even get to data centers and before we even get to the existing transmission constraints that cost my constituents an extra $3 billion a year, our constituents an extra $3 billion a year. So the need case that some people have quarreled with, I do not quarrel with. That to me sounds pretty compelling. Process, I think we can have that discussion. The last thing I would note on this issue is that we are not going backwards in electrification. Processes that were industrial processes, whether it's the Port of Houston or DFW Airport that were not electrified, the oil patch, they're now electrified. They're using a lot more juice since COVID. And to me, there's a pretty significant need there. The question really is, and this is something I've wrestled with, is who bears the brunt of us being the 8th largest economy in the world? And the externalities associated with that. Who bears that? In the past, it's been my constituents. And you mentioned DFW Airport. You know, you can take Love Field there. You can take I-35. You talked about all those things. All those things completely ran over my constituents because they didn't have agency. Divided their neighborhoods, completely took their land without compensation. And that's been okay with this legislature. That's been okay, because when I have bills to deal with the 7 batch plants in Northwest Dallas, I can't even get a hearing here. So everybody's okay with that for the people I represent, for those people. And so we have to ask ourselves, hey, if we're so proud of all this economic activity, who bears the brunt of that? Who bears the brunt of that? Because Texas has been okay with letting my constituents bear the brunt of that for a long time. And I want people to answer that question.
If I could, sir, at the end of the day, Mr. Taylor threw back in our face
Will,
something
just identify yourself.
Oh, sorry, Will McAdams, McAdams Energy Group, what we identified at the commission, which at the end of the day, loads pay. Now, that's spread across all loads by different classes. And there's going to be new processes associated with the fairness aspect of that and the cost causation aspect of that, hopefully to reinforce that principle. But loads pay, and they'll either pay for infrastructure on a set basis, or they will pay for volatility and reliability, which will result in sky-high wholesale prices one minute because of this congestion, and they won't be able to hedge against it. And then the argument that, okay, so let's build the generation, and we do need to do that, but that map shows you, west of Midland, you can't deliver the power. There's too many bottlenecks. So you're going to have something out there to resolve that, to get the power flows from whatever the gas plants that Walt's crew is going to build to that oil field and the people of Pecos and Reeves County and everything else. There is an interdependency at work here. I've already used the Jenga analogy. Jaron copied me. I swear he ripped it off. But this is a cornerstone of a framework that is very tenuous. I mean, I was worried about this at the time when ERCOT sort of devised it. These 765s are the single point of failure if they delay. And I hope Chairman Gleason can give them a remedy to address these ills over the next months. But if they delay, if this stands past the session and y'all pass a law that reworks the entire process for the purposes of those Permian lines, just know that the first in-service date on the first 765, the earliest one, drill hole to longshore, is 2028, okay? We've done some analysis, and I don't know if ERCOT can back this up, but if that delays, it will affect 400 miles of 345 kV network that's supposed to connect into it. And so this entire spider web of grid starts getting delayed, and it will have to wait on the law to be passed, 6 months, on the commission to enact a rule, 6 months, for ERCOT to restudy all the loads and all the network as a part of an RPG, 6 months, year. And then the commission, the utilities will have to hold public hearings and do whatever you require of them to comply with the new law, 365 days. So you're looking at 3 years before we can begin to move forward. That's risky.
If I could add on, I think maybe what you were asking is, I'm sorry, thank you. Katie Coleman for TAM and TCC. I think you're trying to highlight the impact of condemnation and infrastructure growth on real people and their homes, and that can't be diminished. It's something that the state has struggled with in various contexts for a long time. It is a symbiotic relationship. People are moving here to capture the economic prosperity of that growth. That's why we're seeing residential population growth. But there are consequences of that growth, and it includes the need for additional infrastructure. It is a tough set of issues. I will say that on these transmission lines in particular, and generally with transmission, it does often impact non-residential sectors. We have many clients with facilities who are affected by those lines. I think the difference is you don't hear from them because they're used to infrastructure, and typically they don't have an issue with it on their property. Sometimes they want it on their property. And so there are condemnation, proceedings that affect industrials. But I think it's not as personal, clearly, as the impact of a residential landowner.
And I was asking that question almost rhetorically. You don't have to answer it. I mean, the point I was trying to make is that, hey, are we all in this together? Are we not? Who is it? People only without agency that get to bear the brunt of activity, of industrial activity that makes the state great, or is it everybody?
Members, other questions of the panel? Mr. Darby.
Thank you. Well, by the way, I'd like to see that report on the letter grading on our transmission system, but I've been advocating, as Katie knows and Will knows certainly, for economic modeling that would have, in my opinion, forecasted and prevented this discussion we had today. If we'd been upgrading these facilities over the last 8 to 10 years, then we wouldn't be sitting here today talking about this. So, Todd, you mentioned in your presentation, did you say 8 gigawatts of demand,
6 gigawatts of
6
unconnected
gigawatts, okay,
demand
okay.
today.
Well, we all recognize what the oil and gas industry has done for this state. It's paid for our roads, it's paying for our schools, it's paying for local governments through local taxes, paying for government services, sales taxes. I think the figure, was it last year, wasn't it 27 billion? Did I get that right?
27 billion in state and local taxes and state
That's
royalties
right.
in just 1 year, 200 billion cumulatively since in about 10 years.
So those that would like to Chairman Anchia's point, divide us up. We're in this together. While these oil fields may be in far west Texas in the Delaware Basin, the Permian Basin, the impact of this industry on the state is profound and plays out every day in every one of our lives. And so, I mean, the products are delivered to the Gulf Coast for refinement, and then they're distributed throughout the world. So expand a little bit about the 6 gigawatts and what that does and what you need it to do to provide those services and resources to the state of Texas.
Thank you, Mr. Chairman. Todd Staples, Texoga. I think the consequences of not getting this right are catastrophic. And what I mean by that, in Winter Storm Uri, oil and gas operations in the field were not classified as critical infrastructure, and they lost their power.
They didn't register.
They were prohibited from register prior to this legislature identifying that and giving them that opportunity to do so.
I disagree with you.
Well, the good news is we're registered,
Now.
and and the need is even greater. We've got produced water's been mentioned in the earlier session significantly. You have produced water requires electrification in order to make that process even semi-feasible. And companies are investing heavily today with the expectation that you'll be able to electrify that and make that produced water available. You have compression. You've got processing of that product. All of that has to be done to move that product to all Texans to make it available to them. And that's what's at stake if we don't get this right. The cost of having temporary power is like 2.5 times to 3 times the cost of what it is. We're ready to pay our share. We're absolutely ready to do that, and it's more reliable because in Winter Storm Uri you couldn't get trucks on the road, and if you've got to go to all those generators, all those individual turbines, and just keep them going, it's going to work better for everyone, and it is disruptive, and it needs to be as transparent as possible, and we need to accommodate landowners at every phase. But it's catastrophic if we do not address this, not to mention the reliability problems that have already been identified about the regional rolling blackouts that are imminent, and that's already there. And we know these projects are not going to be built in time to solve all of that. And so that's a very real risk that impacts more than oil and gas. It impacts hospitals, it impacts schools, it impacts assisted living facilities. And so we need to get this done.
What does delaying till, in Will's testimony, 2028 for which node would be in place by then? What?
Yes, sir. It was the drill hole to Longshore segment of the line.
What impact does that have not being in place by 2028?
It just pushes projects back further. I mean, at a time when the world is needing energy security and looking to America to deliver, it just pushes projects back further. It takes capital that would have been deployed to building pipelines, building processing plants, and spending it on temporary power solutions that don't really work in the long run.
I'm aware that one of your members of your association has recently had to spend another $125 million to provide temporary power.
That's exactly right. It's an individual company, and so I won't name them, but they signed up for power. They're told they'd get the megawatts they needed. They only got half of what they needed. They keep getting delayed. They keep getting delayed. And rather than deploying that capital into production, they've had to use that, and just this week made that decision to spend that money on temporary power solutions rather than production and moving product.
Speak as a panel, anybody. We've talked about the size of these 765 facilities, the height, the width, the right-of-way. Talk about the efficiencies. I know from what I've read, there are certain efficiencies associated with these 765s about transporting electrons without loss. They're traveling great distances, but talk, if you can, illuminate the
Yeah, I know anecdotally. So we looked at this in the Senate Business and Commerce Committee back in 2018. And so given like 100 miles of transmission network, a 345 kV line will lose about 2% of its power along route. It just falls off because of the technology. It may be different than that. Oh, it's 3%. Well, that's higher. And so we tried to look at compensating people for line loss. And again, it was such a policy tangle to try to do it through a market mechanism, like making a generator whole or unwinding the postage stamp scheme of delivery charges. It just never addressed it. But 765 is much more efficient. It does not incur, by virtue of the voltage that it's running at and what it's pushing along the lines, that loss.
So there's no question from an engineering standpoint that I'm sorry, Katie Coleman, TAM, and TCC, there's no question that from an efficiency standpoint, if you know that the load is going to show up on either end of that line, that 765 is more efficient. It's fewer line losses. You know, it's like a highway, right? Like it's a lot more efficient. It can carry a lot more capacity. I think it's 4 times the capacity with less right-of-way. You see in the Permian plan that to replace the 3 765 kV lines, we would have needed 5 345 kV lines. So it is definitely a more efficient technology. I think one of the reasons that we have been reluctant to deploy it in ERCOT previously is that it's not incremental. You can't kind of cancel portions of a 765 kV facility as the facts on the ground change. And so it's been a bigger kind of upfront commitment, and you need to have more assurance that the load numbers that you're premising this build on are going to show up. And I think that's ultimately why the Permian plan ended up being a good way to deploy this, because we had such solid data about the growth that's going to occur in West Texas. It wasn't this data center stuff that we're trying to get our heads around right now. The numbers were real, and when you know that that's the case, it is a lot more efficient than the 345 kV if you're willing to forego that kind of incremental optionality.
Well, Powering Texans and TCPA, I'm in the business of generating power, not building the power lines. But I want to follow up with your earlier question to Todd, and when he was saying, they've got a lot of load that's ready to go and is having to use temporary power solutions, we want to sell them that power rather than them having to run diesel gensets and temporary power supply. But we need the load there, and it's done right. It's a virtuous circle. The lines will help ensure that we can get power to the load. The load will then encourage new dispatchable plants to be built. And the new large load customers, oil and gas and others, and Katie's and everybody, will be paying a larger share of the transmission costs overall, which can lead to more plants being built, lower prices, and a good circle for customers.
Thank you, Mr. Chairman.
Done. Anybody else? I've just got one before y'all take off, and Will, this is probably more for you, or maybe Katie, because we've talked about it too. Because we talked a lot about how critical West Texas is to our economy, and the plan was already there before we ever heard the word data center. But talking a little bit about the scarcity in places like Houston, and that this isn't just the West Texas oil field's going to be underpowered. I'd just like to hear a little bit about that.
I think we both tag team it. So going back to my time at the commission, Houston was always what I was worried about. That's where the people are. Very dense, very transmission constrained for the longest time. It took moving heaven and earth to get the Houston Import Project built down into Houston to deliver more power. I'd also point out in Houston, that's why that orange dot on the congestion map, that's the Wharton County GTC. It's a big bottleneck. It's a big disruptor. So instead of the north side of Houston, which is fed really by power generation and the Houston Import Project, the south is starved. And so that creates a reliability dynamic when you have disruptions in power lines, Hurricane Beryl. That causes a threat to that system. It causes it to be options to be reduced in order to get power in there. Another thing I'll say about Houston, Houston is a non-attainment area. Okay, you can only do so much about the federal government. There's only so many power plants that can be built inside of Houston. It is dense. So transmission is absolutely necessary to feed that population hub in the years to come, especially with that 9 gigawatts of load growth, which is people.
Yeah, I agree with what Will said. Katie Coleman again. And I'll just add that, Houston is a very significant industrial area. And what we've had to do over the years because of the issues that Will is raising with the inability to build significant new generation in the Houston region is we keep having to build additional 345 kV lines into Houston. It's sort of a poster child for where a 765 kV line would make a lot more sense. You're going to have to keep building transmission into that region. I think Mr. Rickerson said either today or at a prior hearing, there's only 5 gigawatts of remaining import capacity into Houston, so that is going to be a near-term problem. And something like a moratorium on 765, I think, would be a big setback in trying to address the continued need for transmission into that region.
So it's proximity-wise, and Chairman Anchia, you probably know this because you were looking stuff up. Using a data center, by the way. You said New York was 10 gigawatts?
10 to 12.
And how much is Houston just today?
It's 25% of the ERCOT load. So whatever your 91 is, it's stayed relatively constant with that. Yeah, so 20 gigawatts of that.
And they only have 5 additional as fast as they're growing.
Yeah, and now I hear, and y'all need to check this, but rumors about distribution level load growth 1 gigawatt a year for the next 5 years, that's a lot of distribution level load growth. That's not at the transmission level. That is homes and businesses.
Well, I think we're right, and that's why I brought it up and wanted you to talk about this, because the last conversation we had about it, that was your frustration that we're not talking about Meta not getting to compute data. We're talking about grandma not having electricity.
Well, yes, sir, and Will McAdams Energy Group. The point was, we are starting to see these clusters move toward the urban centers, like Midland out in West Texas, and then toward DFW. I-35 is the next big. You really need to get Woody Rickerson to tell you some horror stories sometimes, but it's areas that he worries about. And I-35 corridor, that's where the people are. Houston, getting enough power in there. And those are the concerns that ultimately have to be relieved because of different constraints to build generation or otherwise to get power moving around.
Thank you. Members, any other questions to this panel? I see none. Thanks, guys. Yeah. Yeah. All right. Let's see. David Stedman. Holly Buckholt, and Terry Phillips. The next panel will be Jan Rose, John Burrow, Eric Gulbranson. Are you? Are you Holly?
Yes.
Okay. The record shows you're Holly Buckholt. You're here on behalf of yourself, is that
That's
correct?
correct.
Please proceed.
Yes, sir. Good evening. I'm Holly Buckholt, a possible affected landowner in the Hill G. Blue Lacey proposed 765 route. I truly believe there needs to be an opportunity to assess viable alternatives such as expansion of localized, reliable power generation that could secure our grid without impacting thousands of Texan landowners and their property rights. Please pause and study this. There will be permanent generational damage that can't be undone. Unnecessary, irreversible property damage is unconscionable simply to accommodate data centers and other industries that may not materialize. Farming and ranching are hard enough without this added worrisome burden. The entire process feels rushed. I also have serious concerns regarding notification of nearby property owners who do not have standing but are greatly affected by these massive structures looming over their property. And how will property owners be notified if they are near existing 345 transmission lines running perpendicular to the proposed 765 transmission lines? I hope notification will be made prior to the final routes being chosen. Property owners deserve to be aware that these 765 lines will be spaced much closer together than 1,200 feet. Some landowners could be affected with 700-foot spacing instead of the 1,200-foot spacing to accommodate the sag to get past existing 345 lines. And add the possibility that these 765 lines crossing the 345s will likely be taller and could require a red light for air traffic. Again, I request that this entire process be re-looked at without putting a tremendous monetary and emotional burden on property owners. Thank you.
Thank you for your testimony. Members or questions to this witness? I see none. Thank you again. Terry Phillips? Are you Terry?
Yes.
The record shows you're Terry Phillips. You are here on behalf of Friends of the San Saba and yourself. Is that correct?
That is correct.
Please proceed.
Thank you. Chairman King and honorable members of the committee, thank you for allowing me to speak today. As already stated, my name is Terry Phillips. I'm a third-generation Texas landowner, and I'm also a Brady, Texas City Councilman and the Mayor Pro Tem at Brady. And I'm here to speak to you today about this proposed 765 kV transmission line and how it could seriously affect my family ranch as well as my community. One proposed route near Brady could interfere with the city's upcoming plans to lengthen our north-south runway, which would affect the flight path of arriving and departing flights. So that's a concern for the future. It's not a concern for the day. But today, I'm here to mainly speak to you about my little small 200-acre ranch that's on the pristine San Saba River, and it looks more like a state park than it does a ranch. But, and it's located in Mason County. To a giant utility company, 200 acres may look like a small dot on the map. But to me and my family, it represents years of work, a lot of memories, and the land that we hope to continue to pass on to our generations beyond me. I understand that Texas is growing and our electric grid must grow with it. I'm not opposed to progress, but progress should not place an unfair burden on Texas families and small landowners. A 765 kV transmission line is massive, and on a small ranch, there will be simply no way to get away from it. It will actually divide our property, it will bisect it, it will restrict the use of my ranch, it will affect its value and permanently change its character. Today, I am respectfully asking you to require every reasonable alternative to be considered, especially existing corridors, and to consider the impact on small landowners and communities, and not just simply the construction cost.
Thank you, Mr. Phillips. I have one question.
Well, I've got one more.
No, sir.
Am I out of
Your
time?
time's
Okay.
up, but I do have a question for you.
Okay, yes, sir.
it was brought up by Chairman Darby earlier about the landowners that have, what was the stat, like 66% aren't going to be affected by this, but think they could be, and they're spending money and time to fight this. How do you know, or is the process transparent enough for you to know, or at some point, that you're in the 66% or you're in the target zone?
Thank you for asking me that question. And the answer is yes, I'm certain of it, because the map, if you look at the M33 route, the route comes off of Charles, well, I'm sorry, I can't remember his name. He's my neighbor across the river. It comes off of him, it comes right over onto me, goes right over the top of my hunting cabin, within 500 feet of my house. Then it cuts diagonally and goes back to the east and cuts that part of my ranch in half, which happens to be where I raise all my bees, which are very important to the ecology of our state. And I'll have to either move them or I'll lose them if the EMFs affect them. So yes, I am aware it is going to affect me. I've seen it on the map, if that route is
Right.
approved.
But at some point, I guess it's just, that's part of the process question, right? Because if 66% of those that think they're going to get, are going to be in the route, are not in the route, at some point, we need to tell the 66%, hey, quit spending money, you're out of the target zone, and then try to work better with the ones that are in the route. So anyway, I
Chairman,
appreciate
from your mouth to God's ears on that.
Yeah.
Because I hope that I'm not in that 66% or the 44% that it does affect. But if you look at the map, so I have to hope for the best, but I also have to plan for the worst.
Right, and I think our purposes and what we're hearing up here is, we don't want you hoping for the best. We want you to know, one way or the other. And if you know, okay, I skated, I'm not in the map, well, you can quit spending money on you, and maybe you help your neighbors or whatever. But I think what I've heard today, that part of the process is categorically unfair. So anyway, thank you very much.
Thank you for the question.
Mr. Stedman, the record shows you're David Stedman. You represent the Laredo EDC, is that correct?
That's correct, sir.
Please proceed.
Thank you. Yeah, I'm David Stedman, President and CEO of the Laredo Economic Development Corporation. I'd like to begin, Mr. Chairman, to thank you and Representative Richard Raymond, our representative here, as well as the distinguished members of the committee for standing tall on this important topic and listening. But I'm also here to propose a new state highway, Texas 765, the Energy Superhighway. Just as our interstate highways connected manufacturers to markets and transformed the American economy, 765 kilovolt transmission can connect the industries that will drive the next generation of the economy. You see, data centers are just forcing us to confront a much larger reality. The economy of the future will run on electricity. Advanced manufacturing, robotics, aerospace, automotive, life sciences, AI, and the automated supply chain will all require enormous amounts of power, and increasingly, the industries of the future will locate where they can find it. That's why connecting Texas is critical to the future of the economy. Webb County sits on the edge of the Eagle Ford Shale, It's currently Texas' leading natural gas producing county. We can do more than consume electricity. We can export power back into the grid. And look where the power would be located. Laredo is once again the nation's #1 port by trade value because it sits at the center of the North American supply chain. Put abundant power near the center of the American supply chain, and we can diversify and grow the Texas economy and the center of the Western Hemisphere.
Thank you, Mr. Stedman.
And we can do it responsibly.
Mr. Stedman, thank you.
Governor Abbott has proven.
Thank you for your testimony.
All right.
Member, is there a question for Mr. Stedman?
Yes.
Mr. Raymond.
All right.
Yes, sir, Mr. Chairman, thank you. And thank you, David, for coming up and for everything you do. And
Highway 765. So there you go, Chairman. Highway 765.
Sounds like Mr. Stedman's for it. So
We're creative in Laredo, but I do appreciate him being here because, you know, thanks to the administration, the Trump administration, we've gotten our permits, actually all the bridges, not just Laredo, our international bridges to expand. In our case, we're going to double the 2 trade bridges, and it is expected that when that is completed in about 2.5 years, Laredo will be the 3rd busiest port in the world. And the only 2 that'll be ahead of us are in China, so we'll be the busiest port in the free world. And I think that's what he's talking about in terms of what's coming. And it's everywhere. It's not just Laredo, but for us, obviously,
Sure.
it's a big deal. Thank you.
Okay, thank you. Members, further questions of the panel? I don't see any. Thank y'all for being here. Chair calls Jan Rose, John Burrow, Eric Gulbranson. What time is it? 6? Yeah, we can do a third. We can still get to our last 2 minutes. While they're getting settled, the next panel is going to be Mia Surratt, Colin Gwynn, and Susan Burrow. Okay. Ms. Rose?
Thank you.
I show you as Jan Rose. You're here on behalf of yourself. Is that correct?
Yes, sir.
Please proceed.
Thank you. Chairman, thank you, and members of the committee. My name is Jan Rose. I'm a 6th-generation rancher in Texas. We own and operate a place that has been in our family for 140 years. It is our home. Our family has served Texas since the Texas Revolution to the present day. In fact, last week we said goodbye one more time to our son as he leaves for his 11th combat deployment. I too served during the global war on terrorism. We serve because we believe in this country, our way of life, and we serve for you. I request that this project be denied and our legislature relook at it at the next legislative session. And I had a whole bunch of notes here, but I've changed them because I want to answer some of the questions that I've heard today as I've sat here. I'd like to expand on 3 points. PURA 37.065 gives routing guidelines to the TSPs. On our route, Encore did not follow any property lines. 75 landowners, 40 miles. They used tax rolls and property parcels, not land boundaries. Mr. Gleason said he would instruct not to cross 100-year-old legacy ranches, for example. Mr. Taylor said he would move the property boundaries, I think he called them micro shifts, to my property boundaries. My neighbors to my right and left were not notified. So to move it to my property lines would make the line closer to their homes and property, and they would get no compensation. The second point, the talk about delays. Right now, my economic opportunities and planned improvements are delayed. Landowners have spent millions of dollars, and there is no recovery of that money, though many people are benefiting.
Thank you, Ms. Rose. Members, there are questions of the witness. Make valid points. That's what we've been hearing, and it's, you know, it hasn't fallen on deaf ears. Thank you for that. Mr. Burrow.
Thank you.
Record shows you're John Burrow. You're testifying on behalf of yourself. Is that correct?
Yes, sir.
Please
Thank
proceed.
you. Thank you. Chairman, members, my name is John Burrow. I'm a pro se intervener on Import Path 2. That's docket 59475. I'm one of the 1,400 Texas landowners on that docket that never received a public meeting before the transmission routes were drawn on my properties. That map I provided you tells the whole story. These aren't straight lines. The purple routes represent the original routes. About 2,800 landowners received notice of the June 25 public meetings. They had 10 months to ask questions, hire experts, and begin defending their property rights before the application was filed. The yellow routes tell a different story. Those are the after the public meetings ended, Encore and LCA added 400 miles of new routes affecting the 1,400 landowners, which I'm one of them. Those are families that were never invited to a public meeting. They received their first notice only after the application was filed and had roughly 3 weeks to intervene and defend their families, their homes, and their livelihoods. I have some simple questions. Why did one group of Texans deserve 10 months to prepare while another group received only 3 weeks? What makes the property rights of one set of landowners more valued than the property rights of another set of landowners? The answer is nothing. Every Texas landowner deserves the same opportunity to be heard before the government authorizes eminent domain. This just isn't about transmission lines. It's about equal treatment under the law, due process, and whether government will protect every Texan as strongly as it protects billion-dollar utility companies. Every landowner deserves the same notice, the same opportunity to participate, and the same chance to defend their property before routes are selected, not after the decisions have already been made. So thank you. Remember the Alamo. God bless Texas, and God bless Tanya Tucker.
Amen. Mr. Burrow, one question.
Yes, sir.
For clarification, because you brought it up in your testimony. Did somebody actually tell you they are imposing eminent domain on you?
Not yet.
Not yet, but I realize it's a thing and it could happen and all that, but up to today, nobody has come and threatened you with eminent domain?
No, sir, not yet, because a route hasn't been finally selected.
I just want to make sure we had clarification on that. We don't need help on the rumor mill. So I just want to make sure we're abundantly clear that hadn't happened yet.
That's correct.
Is there any opportunity for me to say one thing?
No, sir, not until you're called. It's rules.
Okay, my name's Kevin Kennedy.
Well, I hadn't called you.
I know, I'm just saying, I wanted you to know my name in case you'd like to call me, because I'd like the opportunity to comment on this exact matter.
Well, sir, we can't have discussion out of order. Mr. Burrow, thank you. Members, there are other questions, Mr. Burrow? I see none. Eric Goldbranson, is that right?
Yes,
The
sir.
record shows you're Eric Goldbranson. You're testifying on behalf of yourself. Is that correct?
That's correct,
Please
sir.
proceed.
Thank you. Thank you, Chairman King and Committee. My name is Eric Goldbranson. In 2013, I closed my family's 84-year-old business in Los Angeles so that our family could live in the greatest state on earth, Texas. We were steadily losing our freedoms in the once golden state, and the American dream was slipping away. We moved to Bell County, where I bought a house that my wife hadn't seen. I made 10 trips and spent 40 days behind the wheel of my Ford truck, moving us from Los Angeles to Florence. My wife was pregnant with our second daughter, so she flew out to meet me and fell in love with our new home. Our new church and the beautiful people of Texas welcomed us. 7 years later, we were able to buy a larger piece of land 2 miles down the road. We now had 4 children, and together we spent 6 years working the land, stretching fencing, and building a barn and shop house. Last April, we were blindsided when we received our Encore packet in the mail. The notice came 9 months after Encore held their public meeting. We were also one of those 1,400. There were no available utility attorneys. The ones we spoke to had already been hired by other links or the applicants themselves. We were thrown into a marathon where others had started running almost a year before us. We quickly had to learn what we could about the project, how to navigate the interchange, file to intervene and file a testimony and attend hearings, all while trying to homeschool our children and keep our business going. Our forever home was in their crosshairs. It is included in 92 of the 122 potential routes, and it is also their best meets route. These massive lines will be 300 feet from our home and children. We built with our hands. The applicants and the doctors that they pay say that the EMF from these lines are safe for our children, but there are no long-term U.S. studies. Our children would become the study. In the last 4 months, we have spent 7 long days in Austin, and today will be our 8th. We have lost hundreds of hours with our children, and it has cost our family thousands of dollars that we don't have. Our Texas dream hangs in the balance, and the future of our family's ranch lies in the hands of the PUC. This statewide project should not be decided in a mere 180 days with no oversight from our representatives. Thank you, and God bless Texas.
Thank you, Mr. Branson. Members, questions of this witness? I see none. Thank you, panel. Appreciate you being here. Chair calls Mia Surratt, Colin Gwynn, Susan Burrow. Will. Drew.
Ms. Surratt?
Yep, that's me.
We'll begin with you.
Okay, perfect. Hello, committee. My name is Mia Surratt. I'm a homeschool mom from Burnett County and founder of Hill Country Land and Legacy Alliance. This is 500 pages of paper. In Bell County East to Big Hill, the application was filed March 26. The application package and supporting direct testimony totaled approximately 3,443 pages, which is almost 7 of these. Landowners had 32 days to intervene, and then their testimony was due May 13th. In those 7 weeks, assuming they got their notification immediately, they had to learn an unfamiliar legal process, understand a technically complex application, investigate impacts of their property, conduct their due diligence, and prepare testimony. Then came May 13th. I personally identified 714 testimony filings totaling 21,329 pages, including exhibits. That is more than 42 of these, and cross-rebuttal was due 9 days later. I'm not suggesting every landowner needed to read every word, but to determine what affected their case, they had to find the relevant evidence within more than 21,000 pages, while also following RFIs, motions, objections, orders, and other filings. SOAH required every party to monitor the interchange, review filings, and respond when necessary. But these aren't full-time litigants. They're farmers, ranchers, parents, retirees, and small business owners. This is not a realistic opportunity to defend your property. I'm providing you the testimony filing list via email, the case timeline, and my written recommendations. I'm not asking you to guarantee landowners the outcome that they want. I'm asking you to give them a genuine opportunity to influence the outcome and not forget the Texans already required to navigate it under the system you're now examining. Because a right that can not be realistically exercised is a right that has been diminished.
Ms. Surratt, thank you so much for your testimony. Ms. Burrow?
Chairman King and the committee, thank you for having me and allowing me to speak. My name is Susan Burrow. I'm a Texas landowner from Bell County. My husband and I are among the 1,400 families that did not have a chance to attend the public meeting. We were notified in April of this year, about the first week of April, and we didn't even know this project existed until April of this year. By then, the routes have already been chosen. We had only weeks to learn the legal process and try to intervene and try to defend our home. And this isn't the Texas that I know. And I believe it's about whether rural Texans still have a voice when government billion-dollar corporations are making decisions that affect our homes, our families, and our future. I think that's being heard across Texas more and more because landowners are joining together to protect their private property rights. Our family has lived on our property for 40 years. My husband and I bought 40 years ago, scrimped and saved. We plan to pass it on to our children and grandchildren, and these routes will forever change that land that we worked so hard to get and then protect. I respectfully ask that you recommend that these 765 kV lines, the applications be paused until the 90th Texas Legislature meets in January, and give our elected representatives the opportunity to fix the process and strengthen our property rights and make sure that decisions are made for Texans and not just for the large corporations. Thank you, and
God bless Texas.
Yeah, thank you for your testimony. Mr. Young?
I'm Cullen Gwynn from Erath County, Texas is my home. I lease or own property in about 8 different counties in central, west, south Texas. I ranch and I also have a oil and gas service company. So I get around to see a lot of different situations, from solar panels to wind turbines to production, gas being flared, such things that I'm not sure that everyone's aware of. And that goes to the power source that we've been speaking of, and why we have to bring nuclear power from Glen Rose, Texas to the Permian Basin. Doesn't equate. But nonetheless, I want to reference a few things. I want to make sure that everybody remember to respect your taxpayers who allows us to be here today, and consider your own family and the future of your family while we're going through this. There was a conversation earlier about were you threatened with eminent domain? Well, I know for a fact Encore sent me a landowner bill of rights, and I don't know how you would reference that, but that's a eminent domain's coming right behind that if you're not aware of that. So not much else to it. A little map that's worth about 3 cents, but a landowner bill of rights nonetheless. So. They also spoke about negotiation in the land acquisition stage, and talked about 95% where they made a deal on, and 5% they had to condemn. The 95%, the majority of those people, when that takes place, they have no choice. They can't afford to fight it, so they take what they can. That's how they act, like it's agreeable on these 345s and that there's no opposition or very little. That's false. Anyway, I want you to just keep in consideration that I know there's a lot of people here today, and but there would be a lot more if it wasn't on a Wednesday where these people were working. It's kind of hard for us to make all this come together. The powers in the fossil fuels, we're flaring it daily. I want everybody to understand the damage of a power line of that size, even a 2-phase power line. There's a lot of cathodic protection needed. There's a lot of damage there. Nonetheless, thank you for your time.
Thank you for your testimony. Members, any questions for this panel, these witnesses? Chairman Guerin? Yep. Okay, thank you all for being here today. We'll move on to the next panel. Chair calls Mr. John Pitts, Carr Ingram, Jim Scott, Graham Bacon. Thank you all for being here today. Before you begin, please state your name and who you represent for the record. Mr. Pitts, we'll start with you.
Thank you, Mr. Chairman and members. My name is John Pitts, and I'm here on behalf of the Texas Energy Buyers Alliance, known as TEBA. TEBA is mostly made up of very large employers that are based in Texas or have significant operations in Texas, which buy power directly from generators. Our member companies come from manufacturing, oil and gas, large big box retail, and yes, technology hyperscalers. And they came together a few years ago under the TEBA name to work together to ensure that Texas continues to have a reliable, affordable grid, which is what attracted them to our state. This committee, the legislature, and the governor have taken significant strides over the past several years to maintain that reliability and affordability, and our members are grateful. As you look at the challenges that continue to arise in this growing dynamic state, we respectfully request that you continue to prioritize both reliability and affordability. I don't want to repeat all of that was said in the panel with the other large employers, Texoga, TAM, and TCC. We share a lot of members with them. So I'm just going to focus on a few specific points. ERCOT's backbone transmission plan is critical for reliability, both in the Permian and across the state. We understand, and has been stated, that without it, the pockets of the state could see power outages in the coming years. And as has been noted, this could be a statewide issue, not just a Permian issue in the coming years. We believe that the decision by the regulators and transmission companies to choose 765 kV as the voltage for the backbone is the correct decision for affordability. We conducted a study last year comparing 345 to 765, and 765 outperformed 345 on both reliability and cost savings. In particular, 765 delivers up to 5 times greater benefits per dollar invested which benefits every ratepayer and helps reduce both energy costs and congestion in critical parts of the state, more than 345 would. Further, as also stated earlier, ERCOT would need up to 4 times as many 345 kV lines to ensure that reliability, which would take up significantly more land. All that being said, we understand that other smaller lines are still needed in the future. TIBA was very supportive of Chairman Darby's proposal last session, which passed the House, to give ERCOT some direction on using longer time horizons when planning all transmission. Current planning discounts 3 years of benefits into 1 year, which significantly undervalues the benefits of these long-term lines, and also misses the opportunity to proactively address the growing congestion and demand we see in the system right now. That congestion costs, as has been stated, consumers around $3 billion a year. 765 can alleviate some of that cost, and long-term planning, when done to optimize consumer cost savings, referred to as economic planning, as the chairman said earlier, can reduce this even more. Also, Chairman Anchia and others have proposed the use of alternative transmission technologies and grid-enhancing technologies that would create more capacity in existing lines, lessening the need to build new lines. TIBA is currently working with ERCOT to host a broader discussion around these technologies later this fall. Pivoting from transmission planning to transmission costs, our members are concerned about how all of the new transmission Texas needs for our growth will be paid for, in particular the growth driven by these new large loads. In other states, we have seen tension on cost allocation between many of our members play out in public. So in Texas, we have worked internally to develop a plan to ensure those new large loads, including many of our members, cover the costs of the transmission growth that they need, holding other commercial transmission costs flat and actually reducing transmission costs for residential consumers. In addition to the 12CP proposal that was discussed earlier, which will definitely help, we have proposed a minimum transmission charge, or MTC, that would require those new large loads to pay a set fee for a certain period of time to accomplish this. It would explicitly reduce costs for residential consumers. It is also important to note that because the transmission system has fixed costs that we all pay for, adding more new loads will actually bring down costs for everyone. We look forward to working with the PUC and Legislature in the coming months to fully develop and implement an appropriate cost allocation methodology. In closing, TIBA is seeking consistent policies that allow our members to continue to invest in Texas and employ Texans. We appreciate all the work the PUC and ERCOT are doing right now to address these issues, and we thank you for all your hard work over the past few years and in the months to come. I'm happy to answer any questions.
Thank you, Mr. Pitts. We'll move on to Mr. Ingham.
Ingham?
Yes.
Yeah.
Good afternoon, Mr. Chairman, members of the committee. My name is Carr Ingham. I'm a petroleum economist, and I have the privilege of serving as the president of the Texas Alliance of Energy Producers. The Alliance is a statewide upstream sector, which is exploration, production, oil and gas trade association representing operators and producers, drilling companies, and service companies. While we have the privilege of representing some of the state's biggest, most well-known, very active oil and gas producers, we also have a long history and reputation and legacy of serving and advocating for our state's smaller private independent oil and gas companies in both Austin and in Washington, D.C. for that matter. The contributions of the oil and gas industry in Texas to the economy, as Chairman Darby pointed out, are magnificent, generally well-known, bordering on legendary in terms of jobs, in terms of state GDP, in terms of taxes paid to the state. These are not actually the true measure of the economic value of what we do in Texas. That is measured by and comes from the long-term, the establishment of a long-term, affordable, abundant, reliable supply of energy for literally decades to come, a feat which most thought was not possible as recently as even 20 years ago or so. It's over the last 15 years or so, even though the Permian has long been the most significant producing region in the country, that it has become the shining star of U.S. domestic energy production. In 2011, there's about 1 million barrels a day of crude oil coming out of the Permian. As we sit here today, that number is 6.8 million barrels a day, and this is Texas and New Mexico. That's stunning and staggering. Natural gas production, even more staggering. The Permian was producing about 1.5 trillion cubic feet in 2011. That number will be well over 10 trillion cubic feet in 2026.
There are constraints to this production, however. When we were considering this issue in 2022 and 2023, in anticipation of the 2023 legislative session was House Bill 5066 was passed, I was looking around the country and around the world about where demanded production growth was going to come from. This was a time coming out of COVID, and this was the year in which Russia invaded the Ukraine and prices were higher. At that time, there was production in other states and other basins around the U.S. was lower than it had been even since 2015 and going into COVID in 2020. Most nations around the world were not growing production, so the only possibility for production growth to meet this demand that was implied by much higher prices in 2022 was in the Permian Basin of Texas and in Lee and Eddy counties in New Mexico. That phenomenon has not changed as we sit here today. And the story's a little bit different. This year it's the war in Iran, and it'll be something in the future. The world is crying out, and frankly, the U.S. is crying out for as much crude oil and natural gas as we can bring to the marketplace. And where's this going to come from? Looking around the producing states and basins in the U.S., not Oklahoma, not North Dakota, not the Bakken, not Louisiana. Utah's holding its own, but they don't bring very much to the marketplace. So this is the Permian Basin of Texas and New Mexico. We need to bring additional production to the market as rapidly as possible and as much as we can bring. What are the constraints to this? Well, I can think of three that are major. There's probably more than that, but significant just off the top of my head. One is this issue alone and directly. Sufficient electric power, electricity to power the drilling and production operations in the Permian Basin. That's number one. That's a real issue, and our members are suffering from it. And we know this, so you know this, the legislature knows this. House Bill 5066 is a testament to that. Significant large constraint number two, produced water. This is an ongoing, potentially crippling issue if we don't manage to get on top of that, and will indeed serve as a constraint to continued production growth if we don't manage to solve this problem. And the mechanisms by which this problem gets solved, other than injection and disposal back into the ground, are treating and producing that water to a standard where something can be done with it other than injecting it. That's extremely power intensive. That problem doesn't get solved without electricity provision growth within the Permian Basin. And the third is the staggering associated gas issue. As I think most of you know, of all the gas that comes out of the ground in the Permian Basin tries to make its way to market, 60 to 65% of that is kind of unwanted. It's associated with crude oil production, and there's been no place to put that gas. So we're growing pipeline capacity finally, thank goodness. But that gas goes nowhere absent the ability to process that gas within the region in gas processing plants. And I'll leave that to my friend to my right here, and he can talk about that. But from an upstream aspect, the midstream consequences of not generating or providing additional electric power just for gas processing in the Permian to deal with associated gas is going to be a constraint to production growth in the future. In fact, it is right now. These three things are causing our companies and our member companies to ratchet down their production rather than raise it at a time when the market and the U.S. and the world are crying out for additional production. I'll say one other word about smaller oil and gas operators in the Permian. We are all well aware of the fantastic large companies that are doing great big things in the Permian. They're big companies drilling big wells. There are hundreds and hundreds of smaller independent private oil and gas operators in the Permian whose names most people don't know and have never heard. As is always the case with negative economic impacts to the oil and gas industry, the smaller companies are always hit disproportionately. Rising electric costs are no different than this, and they are rising, by the way. Economics 101 suggests that when you have scarce supply in a time of demand that is much higher than that and rising, prices go up. Larger companies suffer the negative impacts of that. again, to a disproportionate degree relative to the larger guys. And when you have companies jockeying for resources that are in short supply, it's often, and most often, the smaller guys that get elbowed out because they lack sufficient market power to access the electricity, to access the processing, to access the pipelines to move that gas out of the region. So we spend an inordinate amount of time when it comes to state policy and when it comes to federal policy looking out for smaller, private, independent oil and gas operators. We don't want them to fall off the radar. We're certainly not going to lose sight of them, but they have a tough enough go as it is with industry economics and consolidation and everything else. And I'd like to not see other solvable issues drive their economics downward and jeopardize their, frankly, even their status as a going concern. Even if you don't lose companies, you're going to lose production if this problem doesn't get solved, and we already are. I appreciate your time today. I appreciate the challenge before you, and I'm grateful for the opportunity to come before you today.
Likewise.
Chairman King, members of the committee, thank you for the opportunity to speak today. My name is Graham Bacon. I'm with Enterprise Products Partners, where I serve as the company's Chief Operating Officer. Enterprise is a midstream energy company with significant operations throughout Texas and the Permian, as well as the nation at large. I want to offer you the perspective of a company that relies on critical infrastructure, the electrical transmission infrastructure we've been discussing today. Three key items that you should know. One, our electricity is vital in processing and moving energy in the form of oil and gas, and thus the production of energy. Two, power from the electrical grid needed for this to drive this critical infrastructure is not available in the Permian today. Three, the alternative means that you hear discussed often for generating power, we've heard today about temporary power and other sources of power, are costly, inefficient, and increasingly more difficult to obtain. So when we talk about growing electrical demand in the Permian, it's important to understand that this electricity is essential to oil and gas production. For Enterprise and other midstream operators,
Mr. Bacon, I'm sorry to interrupt. Would you pull that microphone closer? I think the audio's having a hard time picking you up.
Okay, is that better?
That's much better.
I'll try to speak up as well. Yeah. And so the facilities that are necessary to keep the oil and natural gas moving out of the basin and into the broader Texas energy system. If this oil and gas doesn't move, it doesn't get produced, as my cohort on the left had just previously indicated. The other thing you should know is our natural gas processing plants are considered critical infrastructure by the state. These facilities process the natural gas produced alongside the oil in the Permian and condition it so that it's marketable and can move through the pipeline transmission system where it fuels generation and the heating for our homes. There's an important connection here. The electric grid needs natural gas to be reliable, and the natural gas infrastructure that supplies that fuel for electric production needs a reliable electric grid. That interdependency is why adequate transmission capacity in the Permian is more about than accommodating load growth. It's about ensuring the reliability of critical infrastructure that Texas and the nation depend on every day. Today, adequate service in the Permian is not available. When we request it, we're told that it could be 5 to 8 years. We've got a project that we started in 2023 that we're still told we won't have power available until 2031. This is not in a remote area. It's an area just outside of Midland. We have many other projects that we're working on executing where power just won't be available until 2031. And so when it's not available, we have to find other ways, such as building on-site temporary generation to keep these critical facilities operating and meet the needs of our customers. However, that temporary on-site generation is not a good long-term substitute for reliable electric transmission grid. Use of the on-site generation results in a significant increase in our capital and operating cost. it's, you know, when we talk about the scale of the processing facilities aren't large-scale manufacturing facilities. They're typically facilities that are in the order of 10 to 30 megawatts. And when you try to build power on that at that scale, it's just not cost effective. When we look at our overall cost for operating a small-scale electric generation like that, it's probably 3 to 5 times the cost of power that we would get off the grid. And I think that's, you know, that's a significant burden that gets passed on to, really gets passed on to consumers. And due to the demand that we're seeing because of the lack of power available to go out and procure that short-term generation, that's becoming even harder and harder to obtain. Once we could obtain, we could go out and buy a gas-powered generator or a diesel generator, you could get it relatively quickly. Now you're looking at even 3 years for that type of generation. All of that will slow down the development and the production of oil and gas in the Permian Basin, which the nation relies on. The Permian Basin Reliability Plan gives our industry the ability to plan for the long term. We make infrastructure investments that are expected to operate for decades. When and where we decide to make those investment decisions, we need the confidence that the electric infrastructure is going to be available to support them. Again, the Permian's not simply another area of load growth. It's the most important oil-producing region in the country and home to the critical infrastructure that supports Texas' reliable electric reliability, economy, and energy security. Transmission infrastructure.
Mr. Bacon, can I get you to wrap it up? We've
Yeah,
been going a while.
Yeah, I'll just tell you at this point, thank you.
You bet. All right. Mr. Scott, please introduce yourself, tell us who you're with, and if you have an opening statement.
Mr. Chairman, thank you. Members, my name is Jim Scott. I'm a landscape architect and environmental planner. The agenda for today asks to review the regulatory and planning processes regarding the proposed 765 kilovolt transmission lines. I'm here to leave you with one understanding, that there is in fact no planning process for transmission lines in the state of Texas. It's a painful misconception. On July 29th, a TSP attorney testifying before the Senate on this same topic said, and I quote, "The process that exists in the state of Texas is probably the most robust routing process that exists," unquote. Sure, Texas has a application approval process, but a routing process? That would need to trace or bear some semblance of 55 years of professional planning practice and applied to transmission lines. It would reflect published national standards and use textbook environmental planning methodologies. It would align well with the spirit and letter of our statute, which does a great job of telling us what it wants us to achieve. It just never gave us the roadmap or the recipe on how to get there. Let me illustrate the present reality that we are accepting in place of a real routing methodology. Number one, there's nothing in statute or the administrative code that defines, articulates, or describes anything resembling a routing process. It's obvious when the project is announced, a map is presented with hundreds of route segments drawn on featureless maps, a stark menu of choices. To me, this is anti-planning. It's more like shock and awe. There's no facilitated planning sessions to capture what landowners care about. Comment cards, maybe some follow-up, nothing structured, nothing disciplined, no models to receive the voice of the people. This is not participation, this is superficial engagement. There's no baseline data available for months. Nothing is shared. There's no environmental data catalog, no analysis, just parcels and your potential fate. I asked the LCRA in January to get their route segments. They said, no, sorry, you're going to have to wait until we file the CCN. Well, fortunately, I know how to scrape web services, and I was able to get the data anyway. As an expert witness in one of the 765 cases, I benchmarked a nationally recognized planning process against the current administrative one. Two challenges have surfaced to address my work. The PUC staff reply brief argued my methodology is not called for in statute. The LCRA cross-examined me, only posing 3 questions to establish that no changes to the statute had occurred since 2006. I consider that an endorsement. The sheer number of interveners forced the ALJs to allocate just 3 minutes for cross and 13 minutes for the panel. The public is just starved of any access to the process. The picture is clear. TSPs control the information, they manage the clock, they avoid reducing the scope, and in a final brief, they can declare all their routes are acceptable. That's not a help for a decision maker. They've controlled the agenda for 50 years since the passage of the statute, and landowners are left to navigate cryptic legal procedures and unfair constraints. You can fix this. The standards, the practices, the commitment to engagement, they've existed elsewhere for many decades, and technology has already revolutionized them. Imagine how we might restore landowner rights and voice with a real planning process. A project is announced, a study area is presented. There's no routes. There's nothing on the map. It's just it's a compilation of a potential area where a route might go. Everyone gets notice in that area. All environmental data is made public, accessible to everyone. Everyone has all the same facts, all the same maps. Then there's real work sessions, facilitated design sessions where landowners put what they care about on the map. The family cemetery, the spring, the water well, the view from the porch. Those things become data with weights. I found it interesting, whenever we're talking about ERCOTs and their work, people are very comfortable talking about methodologies and weights and those kinds of capabilities. But when it comes to planning, none of that comes into the discussion. When I brought that into the hearing on the merits, there was some reticence to even think that there would be a model to help make these decisions. It was pretty interesting. Next, corridors would be modeled before any route segments. The analysis narrows the land in play. Fewer families touched. The intervener pool shrinks significantly. Then, inside the corridors, engineers do their technical work. They site towers, work with the parcels, parallel roads, avoid habitat, align with compatible land use. Every trade-off is measured, weighed, and presented in the open, and judgment is participatory, on the table where everyone can see it. The ALJs and PUC choose among a set of defensible, reasoned alternatives. This process works. I've lived this. I helped shape it. I routed scores of major pipelines around the world this way, with the proven technology that I developed, that the electric industry's own research arm published in 2006. Today, technical mapping and analysis is amazingly fast. When CenterPoint recently announced their new 765 project, I analyzed each of their route segments, collected all the data, probably, I think, more data than they have in their possession at this time, all the environmental infrastructure data, parcel data, everything. I downloaded it and processed it and did analysis in 2.5 hours, less than half of this day. I recommend that you direct the PUC to hit the brakes. Deny all these applications. They all share the same non-planning process. Give yourselves one session to envision a law that works for the public interest and all the landowners. Members, the critical need and the path to our future is working with Texas landowners. What is the risk of not doing that?
Yep.
And if I could, I'd like to make a couple of extra points that were brought up during some of the testimony today. There was this idea that the...
Mr. Scott.
Yes, sir.
Could you make them quickly? We need to get
I
to
will.
questions.
I will. Number one, the gentleman from Encore said that they had to cross the San Saba River. They did not. I ran my methodology. It went north of the San Saba River. My client, it still ran 9 miles along his property. You'll hear from him in a minute. Number two, there were discussions about 22 aerial data. Every day, 9 satellites pass over this building collecting aerial imagery less than a foot in resolution. So the idea that there's stale data that we're using today to make these decisions is not appropriate.
Thank you. Thank you very much. Members, question, Mr. Metcalf.
Thank you, Mr. Chairman. Mr. Graham, my question is for you. What's at risk and what happens if we do not get power where we need it to be in the near future?
I think this is Graham Bacon. If you don't, what's at risk is the ability for producers to keep producing oil and gas. I think at this point, the the industry has been able to keep up with temporary power solutions. Those are becoming more and more difficult each and every day. And I think if that continues to develop, it's going to be harder to generate the projects that support the oil and gas infrastructure development in the state.
Thank you very much. Thank you, Mr. Chairman.
Members, other questions? Mr. Darby?
Going to echo Will's question. What we've seen from testimony from Mr. Brown and Carr is that you'll simply cut back production, and ultimately consumers who buy those products are going to have to pay for those additional costs of substitute generation. Is that a fair summarization?
I think when you look, any time that you look at the cost of producing any type of good or service, you're going to have to, those costs typically get passed on. And as we continue to have to spend more and more to produce our own power, just due to the economics and the shortfall of generation equipment, that's going to get more and more expensive to produce and move the oil and gas.
The unique thing about, I'm sorry, Carr Ingham, Texas Alliance of Energy Producers. The unique thing about crude oil and natural gas pricing is that oil and gas operators, even the largest oil and gas operators, have no opportunity to pass the cost of higher costs along to consumers and to purchasers of crude oil. That price is just set, and you just take it. So you don't get to pass that along. So what do? Well, you have to respond to constraints to higher costs or lower prices really by doing one thing, and that's lowering production. That's it. It's a constraint to production, and the only way to make the economics work is not to charge more for your product, because you can't get that on a daily basis. All you can do is respond by lowering production in response to those cost increases, things that you're unable to do because you can't get the power and because you can't get the gas processed, and all of these things that we've talked about today.
Thank you, Mr. Chairman.
Could I actually quickly jump in on this?
One question about that. It's similar to the cow business then. So in the years where you can make a bunch of money, you better hang on to it, because when it's not so good, you're going to lose some. It's no different than the cow business, is it?
That's a fact. If you go to economics school, they tell you about all these market models. Agriculture and oil and gas commodities, that's how it goes. And I grew up on a farm and ranch in the northern panhandle, and we kind of went broke because of that very thing right there. So we get it.
And this is John Pitts, TIBA. Just to echo some of that, but also to emphasize something else that I think the PUC and ERCOT have said is, if we see energy scarcity in any part of the state, it hits these big businesses, but it also hits small businesses, and ultimately residential consumers will see energy scarcity and their lights will go out.
Yes, absolutely. Members, other questions at this time? Okay. Well, last comment, certainly, Carr, I agree with everything y'all are saying, but, I'm in the oil and gas service business, and it's up and down, and feast or famine, and higher input cost, will reduce production, which is ultimately going to raise prices. So, it's how it works. But actually, Mr. Scott, I actually found your testimony kind of fascinating. When I buy real estate now, Google Earth kind of shows me where I can go, where I can't, where the boundaries are, and it does seem like our process is a little arcane, if that's a good word. But I appreciate you being here. Thank y'all. Yes. Good. I think we should do that. All right. Thank y'all. Thank you. Gosh, I forgot to make the announcement. Is that Beryl? Beryl? Damon Beryl? Beryl? Beryl, I think. Tyan Clements, Debbie Nobles. The next panel will be Gerald Nobles, Carolyn Quillen, Louise Leverett. Damon.
Excuse me. Yes, ma'am.
Tyan. We have, okay. Damon, is it Beerle?
Byerly.
Byerly. It's, okay. I'm sorry about that.
That's all right.
Damon Byerly, we show you as, here as a commissioner for Burnett County. Is that correct?
Yes, sir.
Please proceed.
Thank you for taking the time. Chairman and members of the committee, my name is Damon Byerly, Burnett County Commissioner for Precinct 2. The process to advance these 765 transmission lines has not been fair to Texas. That's very clear after today's hearing. ERCOT and the PUC decided that 765 lines were the solution before affected landowners knew their property was in the path. Encore then presented routes and not a genuine opportunity to debate whether this project was necessary, whether 765 was appropriate, or whether less damaging alternatives were available. Encore denied our request to host an open house in Burnett County, even though every possible route was routed through Burnett County. By the time landowners received notice, the most important decisions had already been made. Their only choice was to fight over whose ranch, home, or family legacy was going to be sacrificed. Some had less than 30 days to respond. Over 1,100 Texans signed up to intervene on our route alone, and about 800 of those were denied because the process was designed for them to be shut down on a technicality before the hearing even began, and this is not meaningful public participation. PURE requires the PUC to evaluate more than the utility's preferred route. It requires consideration of community values, historical and aesthetic values, environmental integrity, and the use of compatible rights-of-way. Those protections are not suggestions, yet ERCOT, the PUC, and Encore have treated them like boxes to check just on the project. Landowners have been denied a fair comparison of alternatives. Meanwhile, they face eminent domain, reduced property values, environmental damage, and permanent scars across land that their families have protected for generations. I oppose the process, and I ask the legislature to require real transparency and landowner participation, before, but not after these decisions are made. And I do appreciate your service to Texas.
Thank you. Appreciate your service as well. Questions of this witness? Turn that off. Yes, I need somebody who knows how to work this. I got left alone. So, all right, is it, Tyann, okay.
Yes.
Tyann Clements, here representing yourself, is that correct?
Yes, sir.
Please proceed.
Good evening. My name is Tyann Clements, and I'm a student at Whitehorse Christian Academy in Stephenville, Texas. I am asking you to reject Route C3 of the proposed Dinosaur Longshore 765 kV transmission line. On a map, C3 may just look like another line, but underneath that line is my school, my family's ranch, and my entire childhood. Whitehorse Christian Academy is where children and young adults, as in myself, learn, grow in faith, and prepare for their future. Our ranch is where my family works, raises livestock, and has built a life. This is not vacant land. It is a school, a working ranch, and a very important part of our Erath County community. I understand that Texas needs reliable electricity, and I'm not against reliable power. I'm against choosing a route that sacrifices children's educations, their future, agriculture, livestock, the animals to that livelihood, and a family property when other routes can be considered. This line would require 200 foot of right-of-way and enormous steel towers. It would divide pastures, interfere with livestock and ranch operations, limit the future use of our land, and threaten my school's ability to grow. Construction may eventually end, but the towers and restrictions would remain for generations. Adults often say that decisions made today should protect the future. I am one of the young people who have to live with this decision. The students at Whitehorse deserve a peaceful place to learn and room for their school to grow. Ranch families deserve the opportunity to keep working on the land that they have cared for generations without it being permanently divided and destroyed. Please do not treat our school and ranch as acceptable damage. Look beyond a line on the map and see students, teachers, families, livestock, and livelihoods beneath it. My name is Tyann Clements, and I respectfully ask you to reject Route C3 and select a route that avoids Whitehorse Christian Academy and my family ranch. Thank you.
Thank you for that testimony. Members, are questions of this witness? Tyann, I've got one.
Yes, sir.
How old are you?
I'm 15.
You did great.
Thank you.
There's a lot of people that do this professionally that don't understand time limits, and they're not that clear and concise.
Yes, sir.
So I just want to say I appreciate you, and we'll take
Yes,
it
sir.
under advisement for sure.
Thank you. I appreciate it.
Ms. Nobles, we show you Debbie Nobles. You're here on behalf of yourself. Is that correct?
That's correct.
Please proceed.
My name is Debbie Nobles. My husband and I live on the San Saba River. We manage native and exotic wildlife. We raise red Angus Wagyu cross cattle and quarter horses. We've devoted the last 14 months of our lives protecting the most valuable asset we own, the ranch that we worked many years to acquire and have managed well. We've worked on this project every day and night during the past 14 months to keep the 765 kV lines from being built on or near or crossing the San Saba River corridor. We traveled many miles to meet with legislators. We met with Speaker Burrows in Lubbock, Representative Guerin. We met you in Fort Worth at Cattle Raisers with Jim Scott. We met with Darby's staff in Austin. We're grateful for those meetings. The person I would most like to meet is Governor Abbott. After being in the trenches waging war against the 765 kV lines since June 2025, I have finally realized that the governor is our adversary. He will benefit mightily by the building of these gigantic transmission lines. Of course, he's not the only one. According to American Stewards of Liberty, Oncor will profit $1 billion annually when the lines are operational. My husband and I and our fellow landowners have done so much and worked so hard, but we can't match that. We don't have a staff of lawyers. We don't have an unlimited budget. We don't stand to make unbelievable amounts of money when the gigantic transmission lines are built. What we could have happen to us is that we lose the most valuable asset we own to the illegal taking of our ranch by the state. We would be giving up everything forever. This process is like the events in Tiananmen Square that we saw on TV so many years ago. My husband and I and all the people here today are like the tiny Chinese people in Tiananmen Square who were run over by government tanks. The most disturbing part is that some of our Texas legislators are driving those tanks. I respectfully ask you to demand a pause on this project and a denial of the CCNs. Thank you so much.
Thank you. Members, are there questions of this panel? I see none. Thank you, panel. Ma'am, did you register?
You called my name.
When? It must have been on the next, well, for the next panel. What is your name?
Carolyn Quillen.
Yeah, you're on the next one. I haven't called you up yet.
Okay.
But you guys are done. Thank you. You stay right there.
Okay.
I'm about to recognize you.
Okay.
Okay. So we still need Gerald Nobles and Louise Leverett. Thank you. All right. Is it Quillen?
Quillen.
Quillen? Okay. We're just going to start with you because you've been there the longest.
Okay.
The record shows you're Caroline Quillen, or Carolyn, is it Carolyn Quillen, and you're here on behalf of yourself. Is that correct?
Yes.
Please proceed.
That is right. I'm Carolyn Quillen. I live on a ranch southeast of San Angelo that my family has had since the 1870s. It is grievous what is happening to our beautiful, bountiful land. Who would ever have thought that the powers that be in our state would have so little respect for the treasure that God bestowed upon us? It is most frustrating to have spent money to defend our properties and only recently to have our governor call for guidelines and guardrails on transmission line expansion. It behooved him to have done this so many months ago, but it wasn't quite close enough to election time. To add insult to injury, Mr. Gleason, chairman of the PUC, admitted in an interview with that lawmakers never explicitly approved the controversial 765 transmission lines. Did the PUC, ERCOT, and Oncor transform a regional directive from HB 5066 into a de facto statewide 765 plan with no authority? Governor Abbott should immediately call for this project to be stomped out. The current plan is to extend transmission service where existing or projected electrical loads are underserved, remote, have limited distribution levels, or can't be connected timelessly. Valid issues, egregious rollout. In a recent interview with Texas Scorecard, Representative Brad Buckley discussed a myriad of problems associated with transmission lines. He suggested that the electricity market needed reforming. Perhaps this year's legislative session will address this issue. He explained that the current market favors renewables that are not always there for us. There is fear that if the 765 lines are built, they will just put more renewables online, exacerbating the existing problem. We request legislation that will protect our lives and our property. Many thanks to you brave legislators and landowners who have stepped up to fight for all the landowners in Texas. Best wishes for an upcoming session. Respectfully submitted, Carolyn Quillen.
Thank you, ma'am. Questions? Ms. Quillen? Seeing none, but I appreciate you being here. Gerald Nobles. Record shows you're Gerald Nobles. You're here on behalf of Friends of the San Saba and yourself. Is that correct?
That is correct.
Please proceed.
Okay. My name is Gerald Nobles Jr. I'm representing our family ranch and 3 generations of family ranching out of 7. Yes, this process is a manipulated mess. For example, with no applicant follow-ups to city or county governments seeking inputs for specific local concerns, it's now a mastered exercise to showcase a needed event to deliver a predetermined outcome. For instance, myself and 3 friends traveled to Denver. None of us have ever been there. I asked my 3 friends, each with a 2022 map of Denver, to give me a route to the other side of the city. I get 3 different routes. Now, do I arbitrarily choose one of the routes, or do I use maps or Google Waze on my computer screen in my car? That's where we are today. At the PUC hearing, the PUC engineer stated that he came up with 1 route. The applicant's engineer came up with a 2nd route, and was probable a 3rd engineer would select a 3rd route. That's a good way to lose 50% of your productivity and 50% of your real estate value of your ranch. The author of Bill 5066 has stated publicly that ERCOT and PUC took his bill beyond intentions. All we've witnessed in this whole process is a cold, fast, hurry-up process. Utilities were given a gift of perpetual new massive income. They have 20 lobbyists to our 1. They have business partners to join them in advertising the need for transmission lines, ignoring updates and regional energy methods. And we read articles about how they're making donations to our Texas lawmakers. And here recently we found out, we now know why Texas Parks and Wildlife withdrew their intervention in this case. They received a call from the governor.
Thank you, Mr. Nobles. Members, there are questions, Mr. Nobles? Thank you very much for that. Louise Leverett?
Yes, that's
If
me.
we show you as Louise Leverett, you're here on behalf of yourself. Is that all correct?
Myself and my husband, Bobby Leverett.
Well, you only are registered as self. Is
That's
that
fine.
okay?
Yes.
I'll change
He
it.
lets me talk.
Okay, well, then we're going to keep you as self with your permission, and go ahead, proceed.
Okay. My name is Louise Leverett, graduate of Texas A&M, small business owner, real estate agent, and proud ranch owner. Sometimes in life, in business, and in politics, there's something out there that only deserves one answer, a hard no. If the PUC was told tomorrow to find another way that did not involve giant 760 power lines crossing the entire state, they would do it. This build-out would be laughable if it were not about to happen. This represents yesterday's technology and outdated answers fueled by the greed of Oncor. There are many ways to generate power locally in the Permian Basin. The testimony we just heard from Jaron Taylor, legal rep for Oncor, shouldn't be given very much credibility. Oncor's gigantic profits depend on building transmission lines, so of course that's his only option. We, the voters of Texas, have trusted you all with the power to make the decisions for us, not the PUC, not Oncor. We just heard that ERCOT scored a D-. Maybe they need some new leadership, which circles back to the PUC. With that House Bill 5066, your intentions were good, but Encore and the PUC have not been respectful partners. We, the voters and landowners, are asking you to take back your power and put Texans and Texas lands first. Any proposal that is so destructive to the lands of Texas and to the lives of so many Texans should meet with an immediate and final answer of no. Please don't be the politicians that let this happen on your watch. Making the grid stronger and ruining the lands of Texas is still a losing proposition for Texas. Please make these power lines one of the things in life that deserve a hard no. You don't have to know how to provide better power, and neither do we. The PUC will quickly find a way to generate and transmit power locally if they are told no. Please be the ones to help say no.
Thank you.
This is Texas. Anything is possible.
Appreciate that testimony. Members, are questions, Ms. Lever? Or into the panel? I see none. Thank you for being here.
Thank you.
All right, chair calls Nancy White. I'm gonna screw this up, I know, but it's, I'm gonna say Media Nazarenas. Anywhere close to that? And James Gregory Torres. We have James Torres? He is coming? Okay, then we'll go ahead and get started with Ms. White. I showed Nancy White here testifying on behalf of self. Is that correct?
Yes, sir.
Please proceed.
Thank you, Chairman King and present committee members, all four of you. I just want to start off, first off, giving credit where credit is due. The way you ran this committee today is phenomenal. I really appreciate how you're alternating, so thank you. I really wish Mr. Anchia was here right now because I would like to echo his frustration earlier today. You know, when it comes to constituents, as you know, the state is ran by the people. We elect our governance. And right now, the only people who seem to really be in favor of this transmission lines are those that are going to be benefiting financially. I do find it very interesting that, you know, the gentleman from Encore said that generation is not relevant to transmission, and yet Mr. Gleason acknowledged that it is. I also find it interesting that the gentleman from the Oil and Gas Association in the hearing in the BNC on July 29th acknowledged that the reason that we need the 765 is because of the overgrowth of solar and wind that is currently in the Permian Basin. I'm very fascinated to find out how me in East Texas and Canton, little bitty Canton that's known for our hay and farm, is going to provide energy to the most energy-rich location in our state and potentially our country. What transmission line is going to be sending, what power are we sending through those transmission lines there? That doesn't make sense. I have the ability to work with some amazing people, and I'm going to send it to you later. Mike Swearingen is a world-renowned expert for the grid, and he is doing a 5-part series right now that's available on YouTube that breaks down the transmission line information. But the bottom line is the people that you serve in Texas clearly have a problem. There's an issue happening here. And industry is a big drive behind that. And the people don't care about money. We care about the quiet. We want to be left alone. We want our stars, and we want our silence. There's no dollar sign that's depreciated that can fix that or off in some ether somewhere. Because whenever your dollar goes away in 5, 10, 15, 100 years, my land is over 100-year generational. And there is no dollar sign that can value that. So I urge you and request that you listen to the people, you pause this, because our land will still have value when that dollar no longer does. And I appreciate your time.
Thank you, Ms. White. Appreciate that testimony. And listen, I hear what everybody has said so far, and it seems like the resounding cohesiveness is obviously routes and where they're going, but the transparency of the process.
Correct. And I'm not even in a line. I'm actually in Canton, so it's heading that way to East Texas. I'm not directly impacted by this. But I understand grid operation, and this is not functional to the actual issue. It's just a Band-Aid, another one. We don't need more Band-Aids.
Understood. Thank you for that testimony. Members, are there questions? Seeing none, we're going to move on. And ma'am, I'm going to mess this up. Is it media?
It's media.
Media. Okay, I didn't know if it'd be media. Is it Nazarenas?
Nazarenas.
Okay. Well, I graduated from a Nazarene school, so I knew that part of it.
That's my married name.
Okay, media Nazarenas.
Well, good afternoon, and thank you, Chairman King,
you're
and
here,
your committee.
One second. you're here as self, correct?
Yes.
Okay, now proceed.
Good afternoon, and thank you, Chairman King and your committee for allowing me to speak to you today. My name is Media Burns Nazarenas, and I'm a fourth-generation rancher from McCullough County. My ranch has been in our family for over 100 years and has received the Family Land Heritage designation from the Texas Department of Agriculture. It's located along the San Saba River and is potentially impacted by the proposed Bell County Big Hill line. In June 2025, I received notification of a proposed route that crossed my property. Upon review of this information and conversations with the powers that be, I learned that there was no plan for remediation of the land for proper grazing. Ongoing maintenance was simply a flyover every 5 years or so to see if there were any repairs needed. And additionally, there was no specific plan regarding existing county and private roads and the wear and tear that they would endure as a result of this construction. Let me tell you, our county road cannot handle such wear and tear as we're still awaiting repair and rebuilding as a result of last year's catastrophic July 4th flooding. March 30th, 2026, I received a package dated and postmarked March 27th, 2026, the same day that Encore and LCRA filed a preferred route application with the PUC. This second notification detailed a previously undisclosed alternative route that has an enormous footprint on our property and would be devastating to our ranching operation as it basically bisects my ranch and appears to be no more than 400 yards from my home. I submitted a protest online, but the lack of timely notice prevented me from a thorough review or for seeking further advice from legal counsel. The agricultural community is vital to the local, state, and national economy, and the impact that these lines would have on agricultural production is not positive. The impact is detrimental to all of our natural resources, habitats, wildlife, the river. And finally, land valuations would suffer significantly, and there's a negative cycle that would result because of that.
Thank you for your testimony. I have one question.
Yes.
I think I heard you say that, who's the power company that was or is it
It's
Encore?
Encore LCRA.
Okay, and did you just testify that they offered no remediation to the land? Like, you know, if they come in and put the power poles in and they make a big mess while they're doing it, they've not offered to plant your grass back, to do anything?
Correct. I specifically asked about that because they said, oh yeah, your cattle are welcome to graze under the lines. And I was like, well, what are they gonna graze?
Right, you gotta replant the grass.
Exactly.
Just like pipelines do it all the time. I had a big transmission line come through my ranch, and that power company, it wasn't even a question. They just came out and planted grass and stuff. So I find that disheartening that if you're gonna get stuck with the line, the grass that is left, they wouldn't put it back. That doesn't make any sense to me at all. I would not be happy about that one either.
I was not. And again, that was a specific question, and
Wow.
I can give you more detail on that later,
Well,
but
I appreciate your testimony. You're out of time. Is there another question that needs to be handled? That's just bad PR. I mean, if you're gonna run around and give yourself a black eye, great, but maybe not give yourself two. It just seems weird. Mr. Torres, we have James Gregory Torres.
Yes, sir.
And you are here on behalf of McCullough County Commissioners Court, is that right?
Yes, sir. McCullough County Commissioners Court.
Please proceed.
Thank you, Mr. Chairman. Good evening to the rest of the committee. Joining me today is the entire Commissioner Court. I serve as county attorney, but the entire Commissioner Court is right behind me, our county judge and 4 precinct commissioners. And we were here 21 days ago testifying in front of the different Senate committee. And when we did that, we testified, of course, in opposition for various reasons, being our road conditions and the negative impact it would have economically, and not just that, aesthetically, on our culture, our heritage, and our industries, agriculture and hunting. But while I've got the time this evening, we want to touch on another critical aspect, and that aspect is the cooperation, or should I say lack of cooperation, between local rural governments and the entities involved in this. As elected officials and as lawmakers, we're taught to listen to our constituents, follow the law, and be proactive. We objectively did all of those things, and yet when we seeked communication and cooperation from these entities, we received a lot of blame shifting between the organizations, deflection, outright refusal to come to public meetings like commissioners' courts, and we didn't receive much at all, but I guess we did receive a standard form letter, canned response from the Encore attorney, Mr. Jaron Taylor. That's what we received. I think, I don't want to cast blame, but I think if the plan was to vote for a law and then shift the consequences and aftermath on rural local governments, I think that's unfair. And the good news is it's not too late. Y'all's own colleagues have come out and stated through various comments and statements that this bill that was voted on, HB 5066, is not what was intended to be voted on. In addition, the Senate committee 3 weeks ago came out a day after the hearings and signed a letter pending telling the PUC, deny the applications. One cautionary tale, because I've heard this a lot, is I think reading between the lines with these organizations and entities, I think they're trying to hedge and try to get the win for the landowners, and I put that in air quotes. The win is going to be next session changing the process. Let me be clear. That will not be satisfactory to rural areas, to local governments, and to the landowners. We want it changed this time around, not in the future. Thank you.
Members, are questions, Mr. Torres? Seeing none. Thank you all for being here. Okay. Chair calls Luther King, Dan Gaddis, Stephen Bauer, and Trillian. There we go. I was getting there.
You did great. I'm last. No, you come over right there. Oh, you're awesome.
Dan, I'm going to start with you.
You want to start with me?
We'll start with you. Have Dan Gaddis, you're here representing the Texas South and Southwestern Cattle Raisers Association. Is that correct?
Yes, Mr. Chairman.
If you got an opening statement, fire it off.
All right. Chairman King and members of the committee, thank you for the opportunity to testify today regarding the impacts of proposed 7065 kV transmission lines on Texas landowners and producers. My name is Dan Gaddis. I am a recovering politician, a lawyer that represents landowners in condemnation cases. I'm a sixth-generation Texas cattle producer and a landowner, and I also serve as Vice President of Texas Southwest Cattle Raisers Association, or TSCRA as it's called. TSCRA is a 149-year-old trade order association and the state's oldest and largest livestock association, and we represent approximately 28,000 individuals and businesses as members of that contribute to the production and beef and stewardship of natural resources in Texas and Southwest. Private property rights are not simply one issue among many for our members. It is the foundation upon which agriculture, conservation, and rural communities are built. The ability to own, use, improve, and pass land on to the next generation is not only one of the defining principles of Texas, but is a fundamental principle of freedom our country was actually built on. At the outset, I want one thing to be very clear. Our members certainly understand Texas is growing. We recognize that reliable electric infrastructure is essential to maintaining our economy, supporting new development, and ensuring grid reliability. We are not here today to oppose transmission infrastructure when needed or if necessary for the public good. Texas landowners have long been considered necessary partners in building roads, pipelines, electric transmission, power generation, and other infrastructure that have made the state an economic leader. What we are asking is that landowners be actually treated as partners in that process, not as an inconvenient nuisance or as an afterthought once decisions have already been made. The greatest frustration is not necessarily that a transmission line may cross a property, rather it is that the current process often leaves landowners feeling uninformed, rushed, and without a meaningful opportunity to participate before major decisions have already been made. If any testimony today should have been listened to, Jim Scott should have been listened to by this panel and probably should be replayed for everyone. We actually had Jim at our convention this past year to speak to our members. The land itself is just as essential and often more so to these projects as the steel, the wire, and electricity they ultimately carry. For many families, the first notice of a project comes after months and often years of planning by the utility. Landowners are often expected in a matter of weeks or less to review hundreds of pages or technical documents, evaluate route alternatives, attend Public Utility Commission proceedings, coordinate with neighbors, understand complex legal issues, and make decisions that could affect their property and ultimately its value for generations, all while continuing to operate their ranch. For cattle producers, that often means stepping away from livestock and other daily responsibilities to navigate a regulatory process that few people, even in this body, fully understand. That's not a partnership. In fact, hell, that's not even neighborly. So how do we get to a better process? We support restoring the one-year timeline for CCN proceedings. The current 180-day process is simply too compressed for projects of this magnitude for sure. But extending the timeline alone will not solve every problem. We also need to ensure the process provides meaningful landowner engagement and producers better routing and siting decisions. Meaningful engagement should begin well before an application is filed. The public at large, but certainly the impacted landowners, should have access to all potential route segments, detailed mapping, and knowledgeable project representatives who can actually answer questions while routing alternatives are still under consideration. Early engagement allows landowners, local officials, and communities to identify conditions that may not be apparent from a map or a desktop analysis, such as existing homes, working cattle facilities, water infrastructure, wildlife habitat, conservation easements, future operational needs, and other local considerations. Those conversations can make the project better, and routing deserves particular attention. We encourage planners to look beyond simply selecting the shortest route or relying on the average construction cost per transmission structure. Routing decisions should consider the natural topography of the land, the actual cost of construction, access to major highways and existing utility easements, and opportunities to minimize impacts to the land, agricultural operations, and our rural communities. Where feasible, planners should prioritize existing utility corridors and access to major highways rather than relying on our local public roads simply because they appear on a map. Many rural county roads are already in a state of disrepair, as you've already heard. Many rural county are adding major infrastructure project and a significant construction traffic to those roads can create additional burdens for rural communities, our counties, and those local taxpayers for sure. The best route on paper is not always the best route on the ground. Although today's discussions center on the 765 kilovolt transmission lines, Texas landowners have navigated many of these same challenges for decades through pipelines, highways, and other infrastructure requiring the exercise of eminent domain. We have seen what happens when infrastructure is needed, but the process does not adequately account for the people who actually live and work on the land. TSCRA has long called for the requirement of meaningful public meetings to be had on all infrastructure projects which intend to utilize the state's eminent domain power to take land from private landowners. Such meetings should be had, as well as public disclosure of the products, the potential routing decisions, and information on the actual need for such project well before the process of actual route selection or eminent domain starts. These recommendations are not intended to delay the infrastructure Texas needs. They are intended to improve it. The oil and gas industry, year after year, session after session, will always tell you the sky is falling and an emergency is now, and today is dire. I will tell you, the decisions that have been made over Texas landowners on their land, those decisions cannot be undone once they are done. We have the ability to change that process. We support the request the legislature pause the current proceedings long enough for this legislature to evaluate the process. We can build the infrastructure necessary to power the state of Texas and the country without disrespecting the constitutional rights of Texans whose land makes that infrastructure possible. Thank you very much for the opportunity to speak today.
Thank you, Dan. All right, we're going to go through the panel. Next we'll go to Ann. Would you just state your name so I don't butcher it again and tell us who you're with and proceed.
Thank you, Chairman and members of the committee. My name is Ann Terrillion. I'm a retired business analyst and a pro se landowner representing the 21 family Medina County Pearson community interveners on the Howard Solstice line. We're a small, dense 20 to 400 acre landowners that can't afford high-priced or high-powered attorneys. We're not here to argue the case. Instead, we share our procedural case study highlighting our experience with systemic regulatory, statutory, and data integrity flaws within the 765 kilovolt transmission framework. CPS built 256 links and 77 route options. We saw these initial routing maps lacked due diligence. This gap forces unrepresented landowners to perform engineering, cross-referencing, and safety verification as testimony, evidence, and courtroom arguments. We lived Ben Barkley's PUC testimony for 180 days timeline, surviving every gateway. The regulatory system relies on landowner attrition, counting on families getting overwhelmed by the legal process and dropping out. There's more about intervener tradition on page 2 of your packet. When landowners drop out, critical errors go unchecked. Specifically, the applicant completely omitted an active 12-inch high-pressure natural gas pipeline crossing 6 of our properties. The utility failed to cross-reference the Texas Railroad Commission public map. But I found that pipeline on the public map in August 2025, far ahead of the application. To us, this illustrates the applicant failed to perform basic infrastructure cross-referencing. By omitting this infrastructure, they proposed the route, placing the 765 kilovolt line directly and paralleling on top of the gas line for over a mile. This alternating current interference accelerates cathodic corrosion on buried steel pipelines, presenting a long-term risk of catastrophic rupture. If they had cross-referenced the Railroad Commission maps, the route likely would have taken another path. The Railroad Commission tracks over 470,000 miles of pipeline in Texas. Power lines and gas lines are mathematically bound to intersect. This omitted pipeline demonstrates that the application's initial routing analysis was incomplete, forcing the state to evaluate infrastructure options based on flawed data. Furthermore, the utility used appraisal district records to mail official notices but ignored the corresponding physical land maps. They assumed property lines on paper were fence lines. They assumed, missing the fact that the route physically bisects contiguous parcels owned by the same family for almost all of our 21 interveners. Slicing through the family parcels divides cohesive blocks of land, disrupts agriculture and ranching operations. The irony of the West Texas gas pipeline is that the exact pipeline that the applicant missed terminates at 2 Medina County data centers fueling their generators. Industry has already proven it can move fuel safely to where power is consumed, yet current rules under the PURA Chapter 39 framework incentivizes long-distance wire over local generation. I am pro-progress, but the bigger question is why are we running power lines from South Texas to Permian Basin? Why not build those power plants where the gas and oil is and where the gas and oil industry needs it in the Permian Basin? If the data centers can do it in my backyard, why can't the rest of the world? The PUC answers to you, the legislature. We ask the committee to influence the laws and the commission through 3 reforms. First, require applicants to verify pipeline records and field conditions before filing, ensuring the correct landowner records and prohibiting over-encumbrance. Second, require an independent analysis comparing the proposed transmission expansion against local generation alternatives, mandating a written reviewable findings. Third, address the timing. The state is auditing data center projects, forming the basis for our need findings. It makes 0 sense to approve lines and condemn land based on load numbers the state is rechecking. The commission's final decision for Howard Solstice is due at the end of August. Use your influence to urge the commission to formally abate these dockets while the state finishes rechecking its data center loads figures. Do not let the state agencies condemn private property based on unverified projections and unverified route data. Protect Texas landowners and protect the Pearson community.
Thank you very much. Luther King. Show Luther King, Friends of San Saba, and self. Is that all correct?
I'm representing myself. and I am a member of the Friends of San Saba.
But in
I'm
this,
a
in this.
member of the Texas.
At this moment, are you testifying on behalf of Friends of San
No,
Saba or
no,
just
on me-
yourself?
behalf of me.
Huh? Well,
Behalf
just on
of
behalf
me.
of you.
But
Do
I
I
wanna-
have your permission to change that in the record?
Well, it should be changed, yes.
1 second. He's only representing himself. Yeah, you were actually invited testimony as Friends of San Saba, but we've had several
Okay.
testifies. But
Well-
how would you like it to be in the record?
I'll testify on behalf of myself.
Okay.
And the 4K Land and Cattle Company. And let me say that most everything that I would have said and will say has already been said and said much better than I can say it. So my thanks to Jim Scott, to the individuals to my left. But I do want to say a few things that I think have not been said or maybe elaborate on. I am a member of the Friends of San Saba. I'm a longstanding member of the Texas Southwest Cattle Raisers. I spent 2 terms on the Nature Conservancy Board. We've had 3 conservation awards for our ranch. It's a long, long list. I was fortunate enough to inherit 1/3 interest in 400 acres in North Mason County. I've been fortunate enough to, over the last 55 years, over 50 transactions, accumulate over 100,000 acres in McCullough County, San Saba County, and Mason County. Now, much of this has already been said, but you raised a question, Chairman King, that I like your name, by the way, that I'd like to elaborate on. You know, I did call a lawyer about eminent domain. He did not call me, and I got his name. I didn't know him, from 3 different people that said he was an expert in the field. Now, there's no plans to use that, but he said something that was interesting, and it's interesting because of the conversations we've had about the number of landowners impacted by these potential transmission lines. He said that there is an issue on line of sight, and that it's not only the landowner whose the line goes across, but who might else be impacted by that land. Now, I'm not a lawyer, fortunately, but I just pass that out because that's been mentioned here today. So it may be broader than just the landowner. Now, it is broader than the landowner because in the communities that we're talking about here, how many, 15, 16, I don't know how many counties, most of them have county seats, most of them have newspapers. You know, on our ranch, we'll have over 300 deer hunters. You know, they'll all be impacted by the transmission lines. Now, the transmission lines will hit us. You know, one will go 10.5 miles, one will go 11 miles. One will hit a space in Mason County called Spy Rock, which is 180-foot granite, ought to be a state park. That's all crazy. And so my involvement here really is when I saw what how the lines had been drawn, I'd have probably, I was busy doing something else. But there's a much better way to do it. The drainage is such, you can't even ride a horse across part of it. It was poorly done. Just absolutely not done well. The other thing that is of interest, well, there's several interests. Of course, the company that owns 80% of Encore is a publicly held company. It's a California utility company. I'm in the position or profession of analyzing companies, looking at their reports, reading what's, Claude, the internet say. A big part of their potential growth in earnings is transmission lines, and specifically Texas. So there's interests here that go beyond us needing electricity in West Texas. which I get when we all are for. It's how do we go about it? There's people who have a potential conflict that really should be thinking about their fiduciary responsibility now. That's enough said about that, but it's, it should be known that, that company, Encore, is 80% owned by a publicly held company who's talking about their earnings growth based on transmission lines. Now, I have taken the time to go to data centers, watching them be built. It's a feed trough. They're also happy, the people working on the amount of equipment, what their next project's gonna be, and that's wonderful because we need those projects. But we need to be careful about how we're going about this. So it's already been mentioned that I think governance and policy procedures could probably be improved. And, that's been said before, Gleason said, there's been a number of people that have said that. Scott said it. I've heard Scott speak. He's actually, probably shouldn't say that, but he's on a retainer. Not because of my ranching operations. It's my gift to the state of Texas. We need to do better at the things we're doing. And I feel for our leadership, you and others who are probably being talked to by lobbyists and different people would have different interests. But, there's just a better way to do it than we've been doing it. And I would replay what Jim has had to say.
Thank you, Mr.
There's other things that ought to be said. And, here's all my notes. I've trashed them because it's already been said.
Sure.
And there's no need to rehash it.
Well, I appreciate that, and you recognizing that if it's already been said, let's let somebody else say it. There's still some that we're going to try to get to tonight, but I appreciate that testimony. And we've got one more to read in. Stephen Bauer.
Yes, sir.
You're here on behalf of Farm Bureau, is that correct?
Yes, sir.
You got an opening statement? Go
Yes,
for
sir,
it.
I do. Thank you. Chairman King, members of the committee, thank you for the opportunity to testify today and for calling this hearing to examine the impacts of the proposed 765 kilowatt transmission projects. My name is Stephen Bauer, Texas Farm Bureau State Director, District 10, a rancher from Kerr County. I'm here to testify on behalf of the Texas Farm Bureau. Texas Farm Bureau understands the importance of a reliable electric grid. Our members depend upon that electricity every day, and we recognize that Texas will need infrastructure investments to support the continued growth. However, projects of this size can have permanent impacts on our private property rights, agricultural operations, and rural communities. Because of those impacts, we believe there must be a rigorous demonstration of need and stronger protections for affected landowners before these projects are approved. Landowners across Texas continue to express the concerns that these projects are being advanced based on long-term forecasts and planning assumptions rather than demonstrated immediate needs. While planning studies play an important role, they should not replace the Public Utility Commission's responsibility to independently determine whether a project is reasonable and necessary. We also believe all reasonable alternatives should be thoroughly evaluated before approving these projects. Existing infrastructure upgrades, advanced technologies, generating energy closer to where it is needed, and other alternatives deserve meaningful consideration before permanently affecting Texas farms, ranches, and rural communities. For producers, these impacts are significant. A 765 kV transmission line requires substantial right-of-way that can affect irrigation systems, aerial applications, pasture management, future improvements, and overall productivity of the agricultural land. Landowners are also concerned about the loss of productive acreage, fragmentation of farms and ranches, and restrictions on future land use. We appreciate the growing recognition from state leaders that these concerns deserve additional attention. We are encouraged members of the legislature are calling for the Public Utility Commission to deny the pending applications until many of these issues can be addressed. As the legislature considers potential reforms, we believe it is important to remember that it's not the first time landowners have expressed concerns about the construction of transmission lines. Beginning in 2017, we spent 6 years fighting for eminent domain reforms along with our colleagues at the Texas and Southwest Cattle Raisers and the Texas Wildlife Association. During that effort, we advocated for advance notice for landowners, meaningful public meetings all along the proposed route, and adequate time for landowners and adjacent landowners to participate in the process. Unfortunately, these provisions are not in the legislation passed in 2021. It seems, based on the current situation, that those concerns remain just as relevant today. And given the size of these structures and the width of the right-of-way, it also calls into question how the court will determine damages to the remaining property in an eminent domain procedure. This is an important issue for landowners. This type of project also calls into question something long discussed among our members as regards to the transmission lines. Whether or not there should be some mechanism that allows the landowner to receive ongoing payments to share in the economic value created by the transmission line. Our members believe this is justified to compensate them for the long-term inconvenience created by the transmission line. This concept of adequate and fair compensation seems to be particularly appropriate considering the enormity of these transmission lines. The current process simply does not match the size and the complexity of these massive transmission projects. When routes can cross multiple counties and affect thousands of acres, landowners need more than a notice in the mail. They need early notice, meaningful opportunities to engage, access to information, and sufficient time to understand how a project may affect their property, their operation, and their future. Ultimately, Texas can meet its reliability needs while respecting private property rights. Texas Farm Bureau encourages the legislature to strengthen the requirements for demonstrating need, ensure meaningful evaluation of alternatives, improve notice and public participation throughout transmission planning and siting process, and consider whether these projects merit another look at the eminent domain process for these types of projects. Thank you for your time and consideration. I'll be happy to answer any questions.
Thank you, Mr. Bauer. Mr. Guerin?
Thank you, Mr. Chairman. Mr. King, Luther, on your ranch in those 3 counties, there are some really unique rock structures similar to the Enchanted Rock. Is that correct?
That's correct.
Does anyone talk to you about, because these lines are going to affect?
No one has talked to me about anything. You know, it's a real mystery. You know, you'd think that it's a pretty long stretch that somebody would have said something rather than me just reading about it in the paper. And, you know, the number of articles written now are tremendous, even in the Wall Street Journal. Even, you know, there's articles about what's going on. This is, to me, is you know, you mentioned earlier what we tried to do before. There's some resistance to improving the system. You know, we can speculate where that is.
And I really appreciate you taking time out of your day to be here, because I know a lot of your clients, and I am one, and we appreciate what you do for us at home.
I've been fortunate. You know, my position here is for the landowners. You know, I love Texas. I had one of my ancestors was Sam Houston. That's how long we've been here. So it's an emotional thing. That's why there's a better place to put the lines. You know, and we can argue about the lines. Hell, there's going to be an I-14 going across north of 190. I mean, you know, what are we thinking about? It's just very, very shallow. And, you know, I appreciate you asking me. You know, the eminent domain thing was a very interesting conversation. I'm not interested in that, but there's a lot of issues here that they don't want to go there because this is something they could lose. And you lose that, then you lose something that really is important. But this is something that they could lose because there's other alternatives. There's a policy issue. There's a lot of things that haven't been done, and it almost has the feeling of a bully effect and a kind of an arrogancy that's associated with it. Now I say that, you know, as I mentioned before, I've served on 5 New York Stock Exchange boards. 3 of them are energy. You know, chairman of TCU, vice chairman of UTEMCO, chairman of the investment committee of the Employees of Retirement of Texas, have a whole list of analysts, and have the luxury of having people that can do a lot of deep research. You know, in polite company like this, I really won't say what I really think about the policy. I mean,
again, thank you for being here.
What are we thinking about? What are we thinking about?
Mr. Bauer?
Yes, sir.
My question, really, you or Dan, you know, being with associations that are known for supporting landowner rights, you know, I've got all kinds of questions, you know, about eminent domain. I've always pushed that landowners, particularly ones that don't have royalties, ought to have the right to renegotiate an easement. When land's changed, when the company's changed hands 10 times and you're stuck with an easement that you had nothing to do with. But I digress. That's another fight. What I want to know is, have you had your state convention?
Not yet. We'll
Not
have
yet.
our state convention in December.
Okay, but before session, when you get all your priorities that are in the Farm Bureau Bible that
Yes, sir.
you guys are going to stick to, and there's no negotiation.
No,
You
sir.
know, once y'all come to session, and you tell your lobbyists this is the company line, that's what you stick to, correct?
Yes, sir. That is correct.
Is this and reform going to be a priority for Farm Bureau at convention and going into session?
I will tell you it's definitely going to be considered, and I think it will probably make the priority list. Yes, sir. I think it will be there, and we are in the process right now in our county levels with policy development. They're bringing that forward. As it progresses along, we feel there may be some changes to that and possibly, yes, be on our priority list to bring to y'all.
Dan, would you like to address that?
Chairman King, as you well know, we've talked on many times, and you've championed in many of the causes that we've had. TSCRA will be here back in the legislature again, asking for reforms that we've asked for years and years, many of which, it's not an I told you so type of scenario, but it is somewhat, many of which would have helped to address the hue and cry that has gone out across this state over this project. What you are hearing from landowners is what we've heard from landowners for decades about the need for change. You know, maybe it's fortunate in one way that the number of people have been impacted by this project, because I think it's woken up some people to know that the process is not working for the, quote, partners that own the land in this process. And it has to work for them too.
Well, I would just encourage the landowners in here and the ones watching that maybe are maybe not part of one of your organizations, and not that there's not other good private property rights organizations and these individual groups that have come together, but Farm Bureau and Texas Southwest Cattle Raisers have been around so long, and that's what you do, is advocate private property rights, and it makes it much easier if there is a clear, unified message, you know, instead of 10. And so I would just encourage your membership to, you know, to get involved, and when you come, have some clear direction of, because I've heard a lot of different ideas that people want, and I'm not certain. I am a landowner, and I'm not. What scares me the most about any of this is inadvertently eroding private property rights.
Well, Chairman King, I will tell you this, you know, the Texas Farm Bureau and Texas Southwest Cattle Raisers have been at the joined at the hip for this for a long time, and we will continue to be great partners. But I will, you know, Representative Chia, I mean, what I want to point out is this is not just the rural people, okay? This is not an issue for just the rural people and the ranchers and the farmers across this state. Representative Chia earlier today made a great point. It's all the people that own land that really, that are taken advantage of by these projects of when they, well, we just got to get it done. We just got to get it done, and we get run over in the process. That should not happen. There should be good processes in place, and for those that are going to be impacted, good compensation for them to truly value what they've lost and what's been taken from them.
I think the part of it that I was getting at that bothers me the most is when I hear ideas from landowners about what their neighbor can do with their land. But if that neighbor decided, well, you run black cows and I like red ones, so we're going to let everybody vote and make you run red cows. I mean, we're still a private property right state. And if somebody wants to make a deal with the utility and get compensated, I don't want to go down the road where somebody tells somebody else what they can do with their land. We do need to be good stewards. It needs to be a good process. And I'm just encouraging Farm Bureau and cattle raisers, whatever ideas you come up with, that's my number one concern. I'm up for changing the process. I'm certainly up for protecting the landowner, but not at the expense of giving up private property rights.
Exactly. Representative King, I think you feel confident that we will be coming to you with some suggested changes.
Perfect. Mr. Darby.
Dan, it's always good to see you. When I first came to the legislature, you were a mentor for me, and I'm always grateful for that.
Based upon your votes, I don't want to necessarily tell everybody that sometimes, Drew, because we don't always agree now, but I appreciate that very much.
Well, we don't always agree on everything, but we agree on a lot. We do agree on this process being broken. We do agree that eminent domain should be on the legislative agenda in the next session. I've been a part of this, and several members of this committee have been, to know that we went through a very painful process, and there was a highly negotiated agreement, and there was an agreement to wait 10 years before we tackle this again. And so I think it's time. It's time we do it, and I would appreciate if both your organizations would make it a priority, make your issues known, and the solutions you suggest. Dan, take a look at I mean, you are an eminent domain lawyer, and take a look at the process, how we can improve that. Take a look at certainly the PUC process. Clearly, time of notice is going to be on the table. A lot of other issues. So,
Chairman Darby, you made a comment earlier in this day that I think you recognized the unevenness of the process in some respects, and the fact that the taking entity always has their attorney's fees paid, and yet the landowner is never made whole.
Yeah.
Even when they win at court,
yeah,
they're never made whole because of the expense and the time and the effort that they have to go through this. And so I think there's some things that we can potentially talk about and do, and I appreciate that. I really do appreciate that comment earlier today, because it's a true recognition of the uneven playing field that we have.
well, and landowners pay for it twice.
Correct.
In the
Correct.
electricity rates. So
Correct.
Anyway, thank you again thanks to the panel. Really appreciate your insight. Mr. King,
I'm glad to be here.
thanks for your insight and your contributions to Texas. They're invaluable. Thank you.
Drew, it's good to hear you talk about property rights. I want you to have that same understanding about the urban people with data centers.
Members, any other questions for this panel? Seeing none, thank you all for being here this evening.
Thank you.
Appreciate you. This time, the chair calls up Roycilla Lancaster, Carla Willis, Eddie Houghton.
Thank you, Mr. King. I've introduced myself before. I'm store boss. Yeah. Can you get in?
Good evening. Thank you all for being here today. We will start with Roycilla Lancaster. Is that correct?
Yes, sir.
Wonderful. Thank you so much. Have you testifying as self, rancher neutral. You may proceed.
Thank you. Thank you for having us today. We appreciate your attention to our questions and our concerns. I personally am a sixth-generation Texan and landowner. I have grandchildren, so now I have eighth-generation children that will own my land someday, I hope. There's a very small percentage of people that have the opportunity and the privilege to stand on a piece of land and look in every direction and see nothing but nature. These lines are going to forever alter our landscape and take that peace of mind away. I've changed my notes 100 times today because so many people have already spoken and said so many other things that I wanted to say and have said them quite eloquently. I wanted to say, though, I was very well represented in my county. I am a McCullough County person. My county judge was here. My county attorney is here. My commissioners were here. And my ranch neighbors were here. I want to just try to summarize some of the highlights of what others have testified to. I want to say we do understand the need for our grid, for everything to be solid, and the need for electricity transmission. However, the application process heavily favors the utility applicants, and it is a detriment to the landowners. The routes were added. That question has come up a few times today. There were routes added. I was one of the people who was not within the 500 feet, was not within the notice process, who received a notice in April of this year and had the 21 days or whatever to try to become an intervener, to try to find representation, et cetera, et cetera.
Ms. Lancaster, thank you for your testimony. We do need to move on. Mr. Eddie Houghton?
Yes, sir.
Yes, thank you for being here.
Chairman and committee members, my name is Eddie Houghton. I'm a retired landowner in Salado, Bell County. The proposed 765 kV transmission line will run 142 feet from my home on link F20. My question is simple. Is the Public Utility Commission poised to make the correct decision or simply a fast one in 180 days? During my career at Fort Hood, I was responsible for all the law enforcement, the fire protection, the physical security, and access control of Fort Hood. When the 4th Infantry Division prepared to deploy in support of Operation Iraqi Freedom in 2003 after 9/11, we dealt with an enormous amount of information, intelligence, and competing analysis. One principle was critical to our success. You do not act on information simply because it's available. You must verify it before you commit. That is what I believe is missing here. House Bill 5066 established a direction for Texas energy needs. It did not mandate a particular 765 kV corridor across private property, farms, and generational property. When the entities help design the routes, justify the project, also stand to build, own, operate, and earn the return from it, Texans deserve independent verification. Before the decisions become permanent, I ask for an independent engineering and routing review from someone with no financial stake in the outcome, answering just two questions. First, is a 765 kV truly the most efficient solution for supplying the permanent basin? Second, have less invasive alternatives to taking private land been fully and independently evaluated? Transmission lines do not produce electricity, they only move it. West Texas has abundant natural gas and can provide dispatchable generation closer to where the power is needed.
Thank you for your testimony this evening and appreciate your service to our country. Miss Carla Willis.
Hello, I'm Carla Wills. Good evening to all of you. Carla Wills, Burnett County, Burnett, Texas. How in the world did we get here? House Bill 5066 passed with a House vote of 139-3 and a Senate vote of 31-0. Every state lawmaker I have knowledge of has given the same responses. This isn't what we wanted, and the ERCOT and PUCT have gone too far. I totally agree with you. And those responses may all be true. You know, maybe you just didn't consider the negative impact it would have on the landowners. Doesn't matter. The fact remains that you, the elected representatives, are responsible for the situation that the people of Texas have been thrust into. We cast our votes for you, believing you would responsibly represent us. You may think this statement doesn't apply to you because your district doesn't currently have a planned 765 line. Think again. If this plan proceeds, 765 lines will dominate the state. Even if your district avoids a 765 line, your constituents will be burdened with paying for construction, maintenance, and guaranteed annual profits for the applicants. When they call you in a panic because they can't pay their bill, what do you say? It's your responsibility to correct this problem, and it'll take more than a firmly worded statement. Please take quick action and put unrelenting pressure on the governor to immediately call for a special session to correct the actions, restore our faith in state government. May God save Texas.
Thank you for your testimony. Members, any questions for this panel? Thank you all for being here this evening. Chair calls up Gary Oldham, Margaret Pemberton, Shelley McAfee. Good evening. Chair called up Gary Oldham, Margaret Pemberton, and Shelley McAfee. We'll begin with Margaret Pemberton.
Good evening,
Please
Chairman
proceed.
and
Thank you.
members. My name is Margaret Pemberton. I'm not going to repeat everything that people have been saying all along, but I will say that in 2009, I started working at the Public Utility Commission as in the legal department. And I handled many of the CREZ cases, including the largest ones. Those cases were still not as big as these. We could actually settle cases with 70 people in them. The largest one I had was 1,100 people. We had it at the convention center in Austin. And we had spent, the case actually lasted for 2 weeks. So typically what happened on the 180-day deadline is half of it would be given up front, up to the hearing. Then we'd have the hearing, and that'd usually be a week, but in a case that size, it would be 2 weeks, and we had several of those. And then the rest of the time would be the ALJs, the SOAH, writing the proposal for decision, with leaving a month for the commissioners to be able to have 2 open meetings to consider it. And that's that process was hard, even with fewer people, but we made it work because the staff was very involved in the cases. We worked tirelessly talking to the landowners and also doing discovery. They had 30 days to file their testimony after they intervened, not the 2.5 weeks that they're getting in the 765s. They were able to hire attorneys because they had that extra time to get their heads around it, and they also could call the staff and get help. And we, like I said, once the commission actually started giving us decisions, and this is important because they started providing precedent to us by using more expensive routes to satisfy landowners. Actually using monopoles, which cannot be used here, to try to lessen the burden on the property. And they also allowed deviations that weren't minor to satisfy landowners. And with that information from the commission, staff was able to actually settle even more cases. Now, the 1,100-person case could not be settled by any means.
Thank you for your testimony. Ms. Shelley McAfee?
Do I just grab one?
Yes,
Sure.
please.
Oh, well, I don't want to be in stereo. Okay, don't
Thank you
start
for
yet.
being here.
Okay. Okay, I think I'm ready. My name is Shelley McAfee, board member for 501c3 named Edwards Plateau Alliance. For 4 years, our mission has been to engage in education regarding preservation and conservation of natural resources, wildlife, habitat, ranching heritage, and rural community within the geographic area known as the Edwards Trinity Aquifer. We are in agreement with the testimonies of Senator Sparks and Representatives Buckley and Slauson, who appeared before the PUC on August 14th. In summary, we seek denial of the CCN applications currently pending due to many reasons, including overreach of a regional plan into a statewide plan without legislative authority, a failed process of due notice to landowners, lack of due diligence by TSPs, lack of addressing alternatives before massive confiscation of private land, lack of addressing the need for baseload energy generation and resulting necessary market adjustments, since the unreliability in our grid is largely attributed to intermittent, toxic, destructive, and federally subsidized renewable energy. Now I diverge from my previously prepared comments. I'm glad I wrote a talk down on paper, because after sitting here since 7:30 a.m., I would otherwise be speechless at how the people who profit 9.5% on $33 billion, have six-figure salaries, and make billions of dollars on heavy industry get unlimited talk time, but the experienced people who are sacrificing everything to bring factual information and perspectives to you, including that young lady who's sandwiched between ammonia plants and you cut off, they get 2 minutes. We don't need God to bless Texas. We need God to save Texas. This is happening on your watch. Thank you, Mrs. Thompson, for your comments. I'm finished.
Thank you for your testimony. Mr. Gary Oldham?
Thank you. Gary Oldham from Round Rock. Along with the many, many other things that have been said here today, while Texans and our natural resources are being involuntarily forced to subsidize the immense profits of Encore and data centers, this 765 kV power line presents an immediate threat to Texas and Texans. The Texas Wildfire Mitigation Project analysis that was done found that power lines in Texas caused more than 4,000 wildfires in 3.5 years. I've responded to hundreds, maybe thousands of wildfires in my career, often as an incident commander. Electricity infrastructure is all too often the cause of wildfires. The largest wildfire in Texas history, the Smokehouse Fire in 2024, burned 1 million acres and was caused by a power line failure. The Windy Deuce Fire in 2024, 144,000 acres, caused by sparks and molten metal from a power pole. The Bastrop Complex in 2011 destroyed 1,673 homes, killed 2 people. That was caused by sparks from a power line. The Steiner Ranch Fire here in Austin in 2011 destroyed 23 homes from arcing power lines. The Eastland Complex and the aptly named Power Line Fire in 2022 burned more than 54,000 acres and killed 1 person from lines arcing in the wind. The Perrytown and Power Line Fire in 2017 Power line and transformer failures burned 318,000 acres, caused one fatality. I could go on for hours with other examples of the risks that above-ground power lines cause, but it exacerbates our wildfire problem in Texas and presents yet another threat, and it's supporting the threat of data centers as well. Sure, there's other demands on the grids, but let's face it, data centers are really accelerating this requirement. And speaking of data centers and Chairman's desire to reduce misinformation, heard many kind of snide side comments about, oh, you looked that up on your phone, you used a data center, or keyboard warriors. Those types of lookups have been done for decades with legacy-type data centers. That's not what's driving the growth in
Thank you for your
Texas. It's
testimony
AI
this evening.
Data centers.
Members,
only.
any questions for this panel? Ms. Thompson.
What are driving them?
I'm sorry,
What are
ma'am?
driving the data centers then?
The greed in that speculative industry that's going to have a bubble that bursts soon. The national security red herring is a ludicrous excuse. It is greed, corporate greed.
You mentioned in your testimony about these wildfires being, many of them have been caused by sparks from the wire, electrical wiring.
Yes, ma'am.
Doing your course of research in this area, did you come across any kind of materials, suggested materials, that may have mitigated those kind of problems that they could have used instead of the wiring that they're using now?
The biggest mitigation fact with power distribution is doing underground wiring instead of above ground. There's obviously tree trimming and keeping those trees and branches away from power lines, but even when there are no trees around, lines can bounce together and arc in the wind. We have strong winds in the plains here, and those lines, if they're too close together, will spark and arc if they're improperly maintained. There's a lot of maintenance required on an ongoing basis in power distribution to minimize the wildfire risk.
Well, you know, the chairman of the committee had a problem last year because of wiring, and he lost a lot of cattle, had a lot of fires. And I know he can testify to probably some of the unsafe conditions of it. It just seems like to me that one of the things that we ought to be trying to find out is better methods and techniques that we can utilize in being able to provide electricity to people and without the hazardous condition that they may create.
I would absolutely agree with that, Representative. There are things that can be done, they cost money, and often utilities are unwilling to spend that money, would rather gamble and hope a fire isn't started.
Well, the offset would be the safety of the people. In the long run, it would be a savings, I think.
I would agree.
Okay, thank you so much.
Thank you.
Members, any other questions for this panel? Thank you all for being here today.
We have chair calls Marilee Keller, Paul Grimming, Elizabeth Kuntz. And as, just a reminder, as per the posting, this will be our last panel of the night. We have a hard stop at 8, so.
What do we do with our materials? Do we hand them to the clerk?
Yes. And this is it.
Chairman King, members of, oh,
1 second. Are you Shelley McAfee? Did you change that? That's not right.
no, she
that's-
already
hang
spoke.
on 1
I'm
second.
Marilee Keller.
Hang 1 second. We haven't got it updated yet. All right. Marilee Keller, we show you are representing the Devil's River Association and self. Is that correct?
That is correct.
Please proceed.
Chairman King, members of the committee, I'm Marilee Hodge Keller. My husband and I own the Hodge Keller Juneau Ranch, 21,000 acres in northern Val Verde County. Our family has ranched that county for more than 100 years. We are interveners in the Howard Solstice case. The Best Meats Routes is on our ranch. I'm not here to re-argue our route. I'm here because of what our record showed about the process itself. The routing criteria leave out things that make our land worthwhile: the water, the karst, the conservation easement, the view. And the demand these lines were built on was never verified before the applications were filed. This is not a complaint about an outcome. It is a defect, and only this legislature can fix it. You need to start with authority. Members who sat on this committee in 2023 have said plainly that 765 lines were never discussed when you passed the Permian Basin Reliability Directive. A regional reliability study has become a statewide extra high voltage grid plan. At the August 14th open meeting, the chairman of the commission acknowledged it was pursued without an explicit vote of this legislature. Then look at the process itself. You've heard a lot about this process. I affirm it all. I especially agree with the statements made by TSCRA. When one landowner says the process has failed them, that's a complaint. When 200 say it in the same terms on every one of these lines, that's a finding. And you're not only hearing it from landowners across the Permian Basin docket. State officials have filed more than 30 letters asking the commission to slow down, re-examine, defer, or deny from September 2024 through this month. In your own name, Mr. Chairman, on a letter last November asking for a more deliberate, transparent, and locally informed process.
Thank you for your testimony. I appreciate it. Members, there are questions of this witness? I see none. Ms. Thompson.
Will this line be going through your middle of your property or something?
One of the proposed lines goes through the middle. The Best Meats line goes closer to the boundary. But it is on a conservation easement, and they ignored the conservation easement.
Is that the agricultural conservation easement?
I'm sorry, ma'am?
Is that the agricultural conservation easement?
No, it's a perpetual conservation easement that protects the ecological aspects of the land forever. So it's to the benefit of Texas and Texans, and they are infringing on this.
Thank you.
Ms. Thompson, it basically means that land can never be developed. It'll always be ranch land.
Okay. Is that it? No question? Okay. We'll move to Paul, how do you say your last name?
Grimmy, sir.
Grimmy.
Yes, sir.
I was guessing that. Okay, we have Paul Grimmy, registered to testify on behalf of yourself. Is that correct?
That's right.
Please proceed.
Yes, sir. Thank you. So my name is Paul Grimmy. My wife and I have a cattle ranch in San Saba County, and we're affected by one of the proposed 765 kV lines. I'm going to skip most of what I wrote and really just try to cover the 3 points I think you should hear. The first is, I don't think we should give up on this question of need. I think if you look at the PBRP, which kicked this whole thing off at the beginning, there are enough changes in terms of gas generation to offset what the need is there, and I think those numbers need to be revisited. For example, there were 22 gigawatts of gas generation when the PBRP was committed. There's over 70 now, and in West Texas, it went from 4 to 20. That's versus 15 gigawatts for all these 765 kV lines right now that everybody's so upset about. I don't know that we're fixing the right problem in the right way. The second is that this 180-day CCN process was just too quick. I went to my mailbox and learned that I had 3 proposed lines on my property, and I had 26 days to do something about it, and this was 9 months after the public hearings. I don't think that in Texas we should be doing things this way. Last, because this thing was so rushed, where the transmission lines are routed makes a big difference, obviously. Mine goes right through the center of my ranch, right over top of an irrigation system, and I virtually had no time to try to do that. And by the way, good luck finding an attorney after all that isn't conflicted because they're representing everybody else already. This is not a fair process. So really there are 3 things. With those questions about need, about the 180-day time, about the routing requirements or routing issues that were, I don't think we're in a position to be commissioning these things. Don't put this on the backs of Texas landowners, because everybody is telling you it has to be done now. It's rushed. The whole world will fall apart if we don't do this. Take the time and do it right. Rushing a bad decision is not a way to do it. Thank you.
Thank you. I appreciate that testimony. And, you kind of reiterated the theme of the day.
Yes,
Those
sir.
3 points is what we've heard all day long on both charges. So I appreciate that.
Yes, sir.
Elizabeth Coons?
Yes.
Is that right? You're registered on behalf of yourself, is that correct?
Yes, sir.
Please proceed.
I guess I'm one of the lucky ones. I've been dealing with this for 14 months. I've spent our group $90,000 in legal fees working through this process. And while we're not currently on the 2 preferred routes, don't let Encore say they didn't suggest a route. They were the first one to hit the ground with a route that's going to pass 2 miles north of me. Well, PUC came back with their preferred route. That's going to pass 1.5 miles north of me. And then going through the statistics and compiling the testimony and using AI, the 3rd route, after all the testimony was compiled, will come through the front of my ranch. It doesn't split my ranch. My ranch is very small, but it's very dear to me. Raised in Houston. And I look at you, Ms. Thompson. My first career before I became a financial planner who specialized in working with families with kids with special needs, I was a school teacher at Nimitz High School. And I know that's in your district. Mr. Metcalf, I have 2 sons that are both veterans. They live in your district, one in Willis and one in Montgomery. I had something for Anna. My 3rd son is a firefighter in Galena Park. So our family is about service. It's about community. It's about the people of Texas. I have earned a new nickname. Everybody calls me Alamo, because at the Senate hearing, I invoked, "Remember the Alamo." And it brings the teacher out in me that if you know your Texas history, one of the founding reasons for Texas independence was personal property rights and autonomy. And we've lost those personal property rights in this process. My ancestor, Sarah Dotson, she designed and flew the first flag over Washington on the Brazos. And my husband's direct ancestor fought in the Battle of Gonzales. So we have a lot of Texas history. We have a lot of passion. We are Texans. We fight. And every landowner involved in these cases will fight to their last breath.
Thank you.
All right. Well, thank you very much for your testimonies. It's much appreciated. There's no bill before this committee. This is not the last discussion. This will carry on, and you have been heard. If you did not testify, please remember the public portal comment is open till 5 p.m. tomorrow. Friday, I'm sorry, 5 p.m. on Friday.
We can't hear.
Oh,
Yeah.
so is it not working? Okay, so the public comment portal is open till 5 p.m. on Friday. Public comments will be in the record. They'll be part of the report. And once again, this is not the last conversation. There's no bill before this committee. So that concludes our time for the charge on 765 lines. Members, that concludes today's agenda. If there's further business for the committee to discuss, if not, the chair moves to adjourn. As there objection, hearing none, the committee stands adjourned. Subject called the chair.